I have kept this table in front of you so that we can easily understand what needs to be covered and what not. We're essentially going to be looking at the following criteria. What is the contextual inspiration historically for these? What is the primary purpose that they serve? Is there one quotation or an anecdote that can be associated to these? What is their primary obligation as far as the government is concerned? What is their legal status? And if you have to make amendments, how do you make amendments to these? First things first, when we look at the preamble is originally inspired from the Objectives Resolution which Jawaharlal Nehru had made at the very beginning of the sessions of the Constituent Assembly. However, despite the fact that the Objectives Resolution was moved right at the very beginning of the sessions of the Constituent Assembly, the preamble was the last addition to the draft of the Constitution before it was put up to vote. So, therefore, the significance is it is the Objectives Resolution which was moved by Nehru. Now, we have taken inspiration from the Objectives Resolution, but we haven't cut, copy, pasted the entire Objectives Resolution. If you compare it to fundamental rights, the idea of having heightened rights, which are exclusively mentioned in a dedicated part of the Constitution, is an idea that we've taken from the United States. However, specific fundamental rights, specific ideas of a specific nature could have been taken from different parts of the world. For example, when we look at the term procedure established by law, we've discussed this term in an earlier lecture. That has been taken by the Japanese from the Japanese Constitution. But the larger idea has been taken from the US Constitution. When we look at directive principles, there are actually two sources. One is an international source and one is sort of a local source. The international source has been the Irish Constitution. Now, it has been the Irish Constitution for a very specific reason, because Ireland got its constitution in 1946. It is eerily close to when we were also drafting our constitution. So the Irish constitution becomes, undoubtedly it's a Catholic constitution, it becomes the most recent international constitution in the world that you could take inspiration from. So therefore, the Irish constitution is where we have taken the idea of directive principles. No doubt the directive principles that we've taken from the Irish constitution, the Irish have copied it from the Spanish, but we have taken it from Ireland. So our point of reference has to be the Irish constitution. Now, internally, one of the most significant British laws that were passed during colonial rule was the Government of India Act of 1935, which we've discussed in legal history. Now, the Government of India Act of 1935 contained a set of sections, a set of provisions, which was called Instruments of Instruction. Now, they were similar in nature to directive principles. So there is a point of reference again there. The fundamental duties, as you would recall very well, were added to the 42nd Constitutional Amendment 1976 to the Constitution of India. The preamble, rights and directive principles have been original parts of the Constitution, but Part 4A, as we know it to be, did not exist at the commencement of the Constitution, which is 26 January 1950. And the inspiration of this, of course, comes from the Soviet Union, because at that time, the country of Russia did not exist. It's only after the disintegration of the Soviet Union in the 90s that the country of Russia as Russia was born. Prior to that, you had what was called the Soviet Union or USSR. Now, that is more than enough for historical context. At least in the last 10 years, I can confidently recall there has not been a prelims question on this, because it is too basic and it is beyond the dignity of the UPSC to ask you such a basic question. However, when it comes to the purpose, I believe it is important. The fundamental purpose that the preamble serves is that it is an interpretation tool. Now, what does it help you interpret? It helps you interpret provisions in the Constitution. It helps you interpret other laws. It also helps you interpret international documents that India has ratified and are now being applicable to India through national law or any other means. Now, when the preamble is to be used for interpretation, and we will understand this with legal status, it cannot be the sole use, or it cannot be solely on the basis of the preamble. If you're interpreting anything in the Constitution, or you're interpreting anything in any other law, or you're interpreting any international document, it is not done solely on the basis of the preamble. The preamble is always playing a supportive role, and that is something that one must remember. In addition to that, the preamble also gives you the date of adoption, the date of enactment of the Constitution. It lays down the objectives of the state, it lays down the aspirations to the people. All of those are fairly obvious from the text of the preamble, undoubtedly. But what is its primary purpose? Its primary purpose is that it has been evolved to effectively be an interpretation tool. As I said before, it gives you a certain date, which is, of course, the 26th November as the date of the adoption or the enactment of the Constitution. It also gives you the aspirations of the state, and also the aspirations that the state would have for the people of India. It also fundamentally tells you that we are the ultimate sovereign. I will do this in detail in the next few minutes. But the primary purpose is that it is an interpretation tool. Now, the primary purpose of fundamental rights is to provide civil and political democracy. It effectively enables the state to create an environment to make the lives of the people better. Fundamental rights are not active tools of welfare, they're enabling tools of welfare. For instance, because you have the freedom to work, under Article 19(1)(g), you have the freedom of profession, occupation, trade, and business that allows you to undertake a profession or an occupation of your choice, which allows you to be a productive member of society. And unless for reasonable restrictions, the state can't prevent you from choosing a profession of your choice. So that is an enabling right. The state cannot treat you in a manner which is not equal. So therefore, when everybody has been treated equally, there is a substantive notion of equality of opportunity. And therefore, when everybody has been given that opportunity to be treated equally, how you utilize that opportunity to make your life better is essentially the purpose of fundamental rights, which is why it is said fundamental rights are tools of political or civil democracy. Directive principles, on the other hand, are tools of social, or you could say economic democracy. Now, why would we say this? We would say that directive principles are tools of social or economic democracy for a simple reason. And that reason is, it is actively pushing the states, it's not compelling the states in any manner. It is pushing the states to undertake certain policy measures. It could be through legislation, it could be through executive action, it could be through any means, to ensure that certain basic policy ideas see the light of day. So when the government promotes cottage industries, people are able to set up cottage industries, to work in cottage industries, and therefore cottage industries get the necessary government push to become active contributors of society and economy at large. This is one of the ways to understand how directive principles are effectively tools of what are called socio-economic democratic values. So that's the larger purpose that they serve. Fundamental duties, on the other hand, serve a purpose of harmony. If you are calling upon the citizens of your country to act in a certain manner, to have a value system of a certain order, to have a moral compass of a certain nature, it is effectively leading to a system of harmony, and that harmony that serves in preserving the integrity of the country, the sovereignty of the country, peace and companionship amongst society. Now, I understand that these are utopian ideas in the sense that these sound very extrapolatory in nature, but that's largely the purpose. So, the purpose of doing this is, if you get a question like this in the prelims exam, you have to look at the closest words in the options to the four words that I have given you, and whichever is the closest word is perhaps the right answer. Now, anecdote. Anecdote are popular quotes that are generally said about these. Now, the fact that the preamble, as you already know, has a very, very limited legal status. It in fact has no independent legal status of its own, as you will understand in some time. So the preamble itself becomes a poetic, and it becomes an inspirational, and it becomes a hearty start to the Constitution. So a key way to understand the preamble is, if the preamble is outlining the objectives for the state, it is also outlining the aspirations for the citizens, then it is reflecting what the original intent of the mind of the makers was, or the fact that the preamble takes its inspiration from the objectives resolution, which was one of the first things that the Constituent Assembly accepted. That means it reflected the mind of the makers right from the beginning of the sessions of the Constituent Assembly. So therefore, in the Berubari Union case, a case which had severely diminished the status of the preamble and therefore was eventually overruled in Keswananda Bharti. It was actually in the Berubari Union case of 1960, which was a presidential reference. The Supreme Court had said that the preamble reflects the mind of the makers of the Constitution. In addition to this, if you want to just play ball, if there is anything which cannot be legally defined, for example, anything which is futuristic in nature or transient in nature, in the sense that the vision or the identity card or a peek into the Constitution, you would therefore be talking about the preamble in its very right. So therefore what eventually happens is you're referring to any of these open-ended terms. So therefore the mind of the makers is a general reference to the preamble, and in case they ask you associated terms, you would have an adequate answer to those. Now, as such, there is no quote that refers to fundamental rights as a whole. Now, that's largely because fundamental rights, by the nature of them, are so diverse. You cannot have a single quote defining the larger idea of fundamental rights. So what effectively happens is the Supreme Court has very specifically spoken about Article 32, which essentially gives you the fundamental rights pertaining to writs. So the Supreme Court calls Article 32, and so does Dr. Ambedkar, and both of them have sort of, the Supreme Court has given a reference there that writs are nothing but the soul of the Constitution. Now take a minute and indulge in the sense that a soul reflects the primary essence of a being. Without a soul, a human being is not a human being. So without fundamental rights, without Article 32, fundamental rights are devoid of their meaning, because the reason they are fundamental, and one of the reasons that they are fundamental, is because you have a direct access to the Supreme Court in case your fundamental right is violated. That is one way of saying as to why fundamental rights are fundamental. So to that extent, Article 32 reflects the enforceability of rights, without which a right has no meaning. And a right without such enforceability effectively correlates to predominance of legal justice, which is, or predominance of legal spirit, which is one of the three arms to the rule of law that we've discussed in our earlier lectures. So therefore, Article 32, which is often referenced as the soul of the Constitution, is something that we are fairly aware of. Now, directive principles of state government are essentially actionable points. They are policy ideas, which is why there could be a confusion, and there is a previous year question based on this also. It is in fact categorically and textually written in directive principles that they could be fundamental to governance. This is explicitly mentioned within directive principles. So directive principles are fundamental to governance is written in directive principles. So even if there is an iota of doubt that it could be argued otherwise, that should effectively be removed, because there's one thing that we know. If the question is according to the Constitution, that means it has to be explicitly mentioned in the Constitution. And if something is explicitly mentioned in the Constitution, that is the closest right answer that there can be. In fact, this is a very common tactic that I'm observing in the prelims questions, that these seemingly vague questions that the UPSC asks. For example, last year there was a question that a writ of mandamus cannot be issued against a government owned company. Now, in reality, of course, it can. But if you read Article 12, it simply mentions certain open phrases. It does not mention government company at all. And therefore, a government company is not state by the constitutional definition of state. It could be state by subsequent Supreme Court interpretations of it. So the UPSC has been very categorical in identifying whether you've read the text of the Constitution or not. So therefore, by that analogy and logic, one can very safely say that directive principles are in fact fundamental to governance. The logical answer to this is, if directive principles are action points, they're effectively instructing the government that if you can, when you can, and whether you can, if you could implement a bunch of these things, the country would definitely become a better one to live in. That effectively is governance, and governance in its simplest form is actions of the government. So therefore, yes, fundamental to governance sounds like a fair idea. However, there is no remarkable court as such as far as fundamental duties are concerned. So one can move forward. Now let's look at the obligations. See, the Constitution is a document which effectively regulates the government. So the obligations that we have to be concerned about are obligations on the state. Now, because the preamble has no independent legal status, and we are just going to come to that point, it will have no obligation whatsoever. There is no reason or compulsion. For example, even if you want to seek interpretation of a term, you are not forced to look at the preamble. If you want to look at the preamble, fair and good, most happy to do so. But even if you don't, there's absolutely nothing wrong with it, and nobody's going to stop you, and nobody's going to question you as to why haven't you looked at the preamble. So that's that. Now, fundamental rights are effectively built in such a way that they prevent the state from doing things. So they're negative obligations on the state. Now hear me out, because some of you would have this in your minds, that there are some positive fundamental rights. So first things first, there is no such thing called a positive or a negative fundamental right. These are oversimplifications done in common textbooks that we read. However, for example, even if you are, let's say, talking about reservation, if you have closely read Article 15.5 or 15.6 or 15.4 or even 16.4, 4A, 4B, 16.6, you'd understand rather carefully, very, very simply, that the wordings of the article is nothing shall prevent the state from doing this. So the wording itself tells you that there is a negative obligation, which means we are not going to stop the state if the state wants to do this. But what is it that you're actively doing? You're not stopping the state. So there is still a negative obligation. Apart from the various obvious negative obligations, like, for example, the state cannot deny you equality before law or equal protection of law. The state cannot take your life or personal liberty away except if there is a procedure established by law. So these are obviously negatively set up terms. For example, even if you look at the latter fundamental rights, say 30 or something like that, you'll see that it largely says the state will not discriminate while granting funds to a minority institution on the basis of the fact that they're a minority institution. So the structure of fundamental rights is largely negative. Even if through being negative, you're wanting the government to do something positive, but you're effectively you're stopping the state from doing anything wrong. And that's largely the purpose of fundamental rights. So always remember this. While it is negative, it is essentially to uphold the positive notions of an individual's liberty. And that's been a previous year question, so you could bear that in mind. Now, the obligations that fundamental rights have on this, the obligations that directive principles have on the people, on the government, is a positive one. Even if the directive principle is asking the state to stop something, it is asking the state to actively do something to stop something. See, the obvious ones are promotion of cottage industry, promotion of panchayati raj, having a better standard of life, promotion for development of child opportunities, uh, ensuring participation of workers in management. These are positive things. But even if directive principles are telling you that, you've got to stop liquor or you've got to stop cow slaughter, what you're effectively doing is you're telling the state to make a law or make a policy or make an executive decision that makes these things to happen. So therefore what ends up happening is what you're effectively looking at is a simple way of trying to tell the state that this is what you can do. So even when, for example, in a directive principle which says you have to ban cow slaughter, the state has to make an affirmative law or an additional law trying to ban cow slaughter. That's also the case with prohibition on liquor. So directive principles are essentially what are called positive obligations on the state, and that is something that we have to always categorically bear in mind. Now, as far as fundamental duties are concerned, as far as fundamental duties have to be understood, there is absolutely no such obligation on the state whatsoever, because fundamental duties are largely centered on the people. Fundamental duties are largely centered on what we as citizens can do. Can the state make a law based on a fundamental duty? Yes. Does the state have to make a law? No. Are we even pushing the state to make a law to implement a fundamental duty? We are absolutely not. So that is something that we've got to keep in mind. That is why there are no obligations whatsoever as far as fundamental duties are concerned. Now, moving on to legal status. We've been hovering around this for quite some time, but generally the legal status with the preamble is the fact that there is absolutely no legal status whatsoever. Now, what does this mean? As per Keswananda Bharati's case, the preamble is a part of the constitution. Now, what does this mean? It means if you're a part of the constitution, it means that you could be amended in the constitution. So being a part of the constitution will have a reference to whether the preamble is basic structure or not. And I'm going to have that discussion in just a few minutes. But when we talk about the legal status, it means, can I use the preamble effectively as a tool for something else? Now, independently, the preamble does not have any ability to give power or any ability to stop anyone from doing something. So, for example, the preamble plus fundamental rights has legal value. The preamble plus directive principles could have some legal value, but the preamble itself has no legal value, and it has no independent status, or it has no legal status independent of any other part of the constitution. This has also been a PYQ, so we've got to remember this as well as we can. Now comes the fun part, which is fundamental rights. Now, when you look at fundamental rights, one has a very basic question to answer. That basic question is, what is the enforceability status? And you have to be very careful with this. Can the government make a law on the basis of fundamental rights? Yes. For example, there are some fundamental rights that in fact are calling upon the government to make a law without a time period, of course, but they are saying that you've got to make a law, you don't have a choice. For example, abolition of untouchability is such a right. Article 23 is such a right, that you've got to make a law stopping untouchability or stopping human trafficking or stopping forced labor. So yes, you can make laws on the basis of the preamble. Now, can you also make on the basis of the fundamental rights? Can you also make a scheme on the basis of fundamental rights? Of course, you can make schemes on the basis of fundamental rights. The best example that I can give you is of Article 21A. Now, 21A also calls for a law to be made, and under Article 21A, we've also made the Sarva Shiksha Abhiyan, which is now subsumed under the Samagra Shiksha Abhiyan. So can a scheme be made? Can an executive order be made? Of course, all of those things can be made, because whether it is a law or is it an executive order, it will still come under the larger notion of state under Article 12, and none of these can violate a fundamental right as per Article 13 Clause 2. So can the legislature or the executive make implementations of further implementations of fundamental rights? Absolutely. Do they necessarily have to, unless called for it? No. But can they? Of course, yes. Now, that means our fundamental rights, and this is the important part, are fundamental rights a source of power? The answer is yes. Fundamental rights are indeed a source of power. If fundamental rights were not a source of power, then neither the judiciary nor the legislature would have made interpretations of those and made laws on the basis of their interpretations of those. So, yes, they are a source of power. As far as the judiciary is concerned, the answer is fairly simple. Can they be enforceable in a court of law? Absolutely. Can the court give a judgment on the basis of a fundamental right? Absolutely. That's the very nature of it, which is also why you have Article 12, Article 13.2, you have Article 32 read with Article 226. It talks about enforceability in a court of law, which is enforceability by the judiciary. Now, moving on to directive principles of state policy. Now, again, the primary question that we're answering is, are directive principles a source of power? The answer is yes, they are also a source of power. In fact, they are a very, very obvious source of power. They have been written and structured in such a way that you have been called upon to make these actions, to implement these ideas. So, yes, you are effectively what is called a source of power, and rightfully so, you should be. So, can the legislature make a law on it? Yes. In fact, we made constitutional amendments on the basis of directive principles, which is the 73rd and the 74th Amendment. Additionally, we made several laws on the basis of directive principles, whether it is about labor codes, whether it is about certain welfare nationalization laws. We've made several nationalization laws to implement the larger objectives of directive principles. Have we made executive decisions? Yes, we have. MG Narega has a source of reference or a point of reference to directive principles, as a matter of fact. So yes, are they a source of power? They are absolutely a source of power. Now the question is, are they a compulsory implementation tool? The answer is no. And the reason as to why they are not is simply because of rule number 1, democratic mandate. You cannot force a government, no matter what the case might be, to compulsorily, under all circumstances, implement a directive principle, because then you're violating the electoral mandate. When you have won the largest election on the face of this planet and you are now the government, you have the right to take certain key policy decisions. And because you have the right to take these key policy decisions, this also means that you should have the independence to take those decisions. And nobody should take away that independence of yours, even if it is the constitution. So even if part 4 tells you, all right, you won the election, you're in power, you've got to make laws on these. There could be several logistical constraints. There could be several financial constraints. There could be constraints on political will. There could be constraints on the fact that maybe the nation does not need one of the things which is mentioned in part 4, which is why there is no compulsion. But are they a source of power? Yes. Can they give a certain leeway that you can make a law on something? Yes. But are they a source of power? Yes. Are they any source of compulsion? The answer is an absolute no. Now, which is exactly what applies to enforceability. So because they are not, because of democratic mandate, because of the fact that you cannot force them to do so, you cannot take a government to court simply because, you know what, you've not implemented a directive principle. If you've implemented the directive principle through a law, and that law is violating a fundamental right, be my guest, take them to court. But my idea is, if the government has not implemented a directive principle, you cannot take them to court. Neither can the court give a direction to the government and say that you've got to implement this directive principle. You've got no choice. This is for two reasons. One, democratic mandate, and rule number 3, separation of powers. Now, fundamental duties. Fairly similar to directive principles, are fundamental duties a source of power? Yes. Can you make a law legalizing a duty? Yes, you can. In fact, the very first odd fundamental duty is that you've got to respect the national anthem, so on and so forth. And we've made a law that says prevention of insults to the National Honours Act of 1971, if I remember the year correctly. But my point is, you can make a law and take an inspiration again from fundamental duties. Are they a source of power? Yes. Are they compulsorily to be implemented? No. Which means if the government is not making a law on a fundamental duty, you can't take the government to court. If the citizen is not implementing a fundamental duty, you cannot take the citizen to court. But if you've made a law, for example, you've made a law called the Prevention of Insults to National Honours Act, and somebody is violating this law, can you take them to court? Yes. Can you challenge the constitutionality of this law if there is enough reason to? Absolutely yes. But can you take the government to court for not implementing a fundamental duty? Can you take a citizen to court for not implementing a fundamental duty? The answer, of course, is no. Now, as far as amendments are concerned, all of these three are not explicitly mentioned under Article 368. And under none of the articles which are contained across these four is it written that they are an exception to Article 368. So therefore, by a default, you can amend them through constitutional amendments which are under 368 but do not require what are called state ratifications. So this is to be done by what is called special majority 2, and special majority 2 requires the Lok Sabha and the Rajya Sabha to vote. They can never vote together. There are no joint sittings permitted in constitutional amendments. The president necessarily has to give an assent to a constitutional amendment. The procedure is fairly simple. In the first round of voting, you ask for an all-encompassing vote, which is more than 50% of the total strength. And thereafter, you ask for more than 2/3 of the people who are present and voting. As I've discussed earlier, this special majority 2 actually requires 2 rounds of voting. It's the same person will vote twice in special majority 2. Anyway, so the idea is a very simple one. This is how these 4 parts, which are correlated to each other, are effectively run in the context of the country. Now that we've understood comparisons, let's quickly look at our classifications. See, our story in classifications effectively begins on a certain criteria. Now we figured out that we have to first look at classifications of rights. Now, there are 3 kinds of rights. Part 3, fundamental rights. Anything in the constitution but outside part 3, constitutional rights. And any right in any other law which is not the constitution is a statutory right or a legal right. Now, as per UPSC language, a statutory right and a legal right are effectively the same thing. Now, why is this important? Because there is no dedicated enforcement procedure, which is why you've kept them the same. In UPSC's terminology, a statutory right and a legal right effectively means the same thing. Now let's understand the process as well as we can. So a fundamental right can be amended through special majority 2. A constitutional right can also be amended through a special majority 2, which means in terms of amendments, a fundamental right and a constitutional right are effectively the same. Now, why is this the case? This is the case because they are effectively serving the purpose of constitutionalism, which is restricting the powers of the state. Any higher amendment would be an amendment which would require special majority 3. And this has to be explicitly mentioned under 368. And as we recall correctly, each of these will have a federal component, as the case might be. Now, fundamental rights don't have a federal component. They are not changing the powers of the center or the states in any manner. In fact, they are aloof from the division of powers, because those division of powers are an outcome of what is called ordinary legislative powers, which is why we use special majority 2 and not special majority 3. Now, if these rights are violated, what is it that happens? If your fundamental right is violated, you could directly go to the Supreme Court or the High Court. If your constitutional right is violated, it is not specifically mentioned anywhere as to what will you do. Now, the example of a constitutional right is the right to vote, and this is also cross-referenced to a PYQ. So your right to vote is a constitutional right. Your right to citizenship is a constitutional right. We've discussed this before. Your right to property is also a constitutional right. Now, here's the fun part. Even for a legal right or a statutory right, you can directly go to the High Court, which means in terms of enforcement procedure, constitutional rights and legal rights are effectively the same. Now, what is the outcome of this and why is this important? The outcome of this and why is this important is the answer. The answer is as follows. A right is as good as it can be enforced. So therefore, when we are saying that a legal right is a legal right violation could directly allow you to go to the High Court, and we are silent on what can happen to a constitutional right, we are saying a constitutional right is the same thing as a legal right, because generally a legal right is a right granted through any law, and the Constitution also happens to be a law. So this is why if you say the right to property is a constitutional right, it is correct. If you say the right to property is a legal right, it is also correct. If you say the right to citizenship is a legal right, that is also correct. But when you say the right to vote is a legal right, it becomes incorrect, because the Constitution specifically mentions for this, and the Supreme Court has been very categorical about it, that the right to vote is a constitutional right. So how do you determine what is a constitutional right and what is a legal right? For example, what happens here is, when we say right to property, you can call it a constitutional right and you can call it a legal right, because you have the Constitution and a law both referencing to a property right. Transfer of property right, you would have the land resettlement law, you will have property rights under several personal laws. These are legal rights. But when we talk about the right to vote, we said that the right to vote is only a constitutional right, it is not a legal right. Because the right to vote is categorically mentioned under Article 326 of the Constitution, which therefore means there is no other law. The Representation of People's Act nowhere speaks about whether you have the right to vote or not. It speaks to you about the restrictions that you could have as a voter. But the right to vote is granted to you by the Constitution. In the same way, the right to contest elections and be elected, the Constitution simply gives you an eligibility criteria. So it's not a constitutional right. But your right to contest an election is largely given in a law called the Representation of People's Act. So the right to contest elections becomes a legal right. So this is actually the understanding. So therefore what happens is, when you're looking at the different kind of rights, if the UPSC throws a question at you, is the right to citizenship, what kind of a right is it? We have constitutional provisions on citizenship. We also have Citizenship Act of 1955. So it is a dual right. But when we say the right to vote, there is no law that specifically gives you the right to vote. The Constitution is the only law that gives you a right to vote, also by beating around the bush and coming to Article 326 and referring to a concept called universal adult franchise. And that's the larger concept that we're trying to play with. Now, why is this important? It's important because when you look at it from a violation point of view, when you look at it from a comparison point of view, there's absolutely no difference in getting a constitutional right or a legal right enforced, because they're effectively doing the same job. You have given a special status to fundamental rights because they're fundamental to the basic being of a person, and they have been specially protected under Part 3, which is why they've all been written in Part 3. And that is also why you will notice even Article 32, it's effectively talking about jurisdiction of the Supreme Court. But it is written in Part 3 Because if the jurisdiction is about fundamental rights, it should have the same force, effect, and nature of a fundamental right, which is why 32 is in part 3 and not alongside 131 and 136 and 143 and so on and so forth, as far as the Supreme Court is concerned. So, equivalence of enforcement procedure, and the simple idea is unless there is an alternate judicial remedy. For example, your consumer right is a legal right, but your Consumer Rights Act or your Protection of Consumer Rights Act very categorically allows you to approach a consumer forum. So you cannot directly show up to the High Court saying, "Hey, my consumer right is violated," when there is an alternate legal remedy available. So that is the key point. You can ask, you can come to the High Court directly if there is no alternate legal remedy available. Now, these are the classifications as far as rights are concerned. Now, rights are something that are deeper in nature. There are, of course, larger discussions about what is the natural right, what is the human right, and so on and so forth. So, human right is a right that human beings should have. A natural right is a right that is so natural to existence, you don't even have to bother writing it down somewhere. But because we're in the business of law, a right is something that can be enforced. A right is something that can be guaranteed. So what generally happens is, and this is where there is a little bit of a correlation. The correlation is when our constitution was being framed from 1946 till about 1950, an international organization called the UN had just come into existence in 1945, and they were coming up with the Universal Declaration of Human Rights in, I think, 1948. So the timelines are carefully overlapping. So there is a lot of give and take between the Universal Declaration of Human Rights and our fundamental rights. There's a lot that we've taken from them, and there is a lot that we've given them. And that's something that we have to always be mindful of. Now, which is why, though UDHR says Universal Declaration of Human Rights, the key word is human rights. This means things that a human being should have. It may not be something that you can guarantee a human being. So a human being should have a good standard of living, which is something in our directive principles. A human being should have what is called liberty of thought. It may not necessarily be in our fundamental rights, it is in our preamble. A human being should respect fellow human beings. It does not have to be a right, it is in our duties. So, which is why it's also a previous PYQ. Universal Declaration of Human Rights correlate to all four things: the preamble, the rights, directive principles, and fundamental duties. Now, if this becomes an international human rights document start to begin with, what generally happens here as an outcome is that you would have several human rights instruments that have been evolved in the world. Now, what are these human rights instruments that we are referring to? For example, you'll have something called the Convention on Racial Discrimination. Now, this is something that India has ratified, and in fact, our fundamental rights very categorically prohibit discrimination on race. We have the International Covenant on Civil and Political Rights. We have ratified the parent document. We have not ratified the optional protocol, which calls for the world to abolish death penalty, but the parent document we have obviously ratified. There's also something called the International Covenant on Economic, Social, and Cultural Rights. That's also a document that we have ratified. Apart from this, the Convention for Elimination of All Forms of Discrimination Against Women, that is also something that we've ratified. We are interestingly just a signatory to the Convention Against Torture. We've ratified the Convention on Rights of Child. We've ratified the Convention on Disabilities. Now, what does this mean? And as I'm sure you know already, if you've ratified an international document, that you have voluntarily taken the obligation to implement that international document. You could implement it by making a law, you could implement it by setting up a court, a tribunal, and a scheme, whatever it takes. In fact, in our legislative relations, if the parliament has to make a law to give effect to an international document that the country has ratified, then you can bypass your union list, state list, concurrent list divisions, which effectively means that, for example, we have, let's say tomorrow, if we ratify the Convention Against Torture, it could largely be consumed under law and order. Law and order is in the state list. If the parliament has to make a national law preventing torture, it could do so, even if it is in the state list. You don't even need permission from the Rajya Sabha, because you're ratified and you are implementing an international treaty. This is because the union has the powers to undertake foreign policy decisions, and that's also an application of rule number 2, which is center stronger than the states. We've done several measures because we've ratified several international documents. For instance, you would have often heard of the Disabilities Act. That's because we've ratified the Disabilities Convention. You would have heard of the Right to Education Act, the National Commission for Protection of Child Rights. That's because we've ratified what is called the Convention on Child Rights. So there have been several reasons whatsoever in the ways and means that we've implemented. The National Commission of Women is because we've ratified CEDAW largely. So this is the idea, and this is largely how your rights work. Now, which brings me to the last part of classifications, which is directive principles. Now, there are two things. One, a very favorite question of the UPSC is identify which is a directive principle and which is a fundamental duty. Now, the basic way to do this is you don't have to memorize it. You have to ask yourself a basic question. The question that you have to ask yourself is, when you're trying to look at identification, if the government is implementing something, then it is generally a directive principle. If you as the citizen are supposed to implement something, then it is a fundamental duty. This becomes test 1. For example, promotion of international peace and security. You and I, as much as we would want to, can't solve the Afghan crisis. It's the government who can support to do so. So promotion of international peace and security becomes a directive principle. For example, separation of the executive from the judiciary. You and I can't do this. The government will have to make laws for doing these. So it becomes what is called a directive principle. But if I say, for example, to respect the national flag. Now, to respect the national flag is something which is very individualistic. So it becomes a fundamental duty. For example, to cherish the ideals of the freedom struggle. If you have to cherish something, it's a very individualistic thing. So it's generally going to be a fundamental duty. That's test number 1. Test number 2 is look at the kind of language that is used. The kind of language that is used for directive principles is very, very formal. It is effectively what is called inanimate. The kind of language that you would use for directive principles is inanimate. Now, when I say it is inanimate, what does this mean? It means it is intangible in nature. It's not human in nature. So to promote international peace and security, to ensure participation of workers in management, to promote cottage industries, to support local self-government, or more effectively and more accurately, directive principles in the constitution refer to something called Panchayati Raj. They don't talk about urban municipalities. They mention the word Panchayati Raj very interestingly. So that becomes directive principles. But if the language is a little informal, it's a little more personal. For example, have compassion for living creatures. Now, human beings are enabled and have the powers to have compassion. So it becomes what is called a fundamental duty. So this becomes your second test, and you will generally not go wrong with this. Now, so therefore, this is largely what we have to do as far as our DPSP FD questions are concerned. Now, another favorite of the UPSC is to generally ask you questions on what kind of a directive principle is it. Again, you don't have to necessarily memorize it. There are essentially 3 kinds. You're either Gandhian, socialist, or a liberal or intellectual. Generally, Gandhian DPSPs will speak about things which are grassroots in nature, will speak about things which are conventional in nature. They will not generally speak of things otherwise. So, for example, promotion of cottage industries, Panchayati Raj, prohibition on liquor, ban on cow slaughter. These are largely very Gandhian ideas because they're either grassroots or they're conventional in nature. Socialist is always about an equitable distribution or equal distribution of resources or you could say the intervention of the state, anything which is welfareist by state intervention. That's generally what is socialist. So anything which has the word equal distribution of resources will generally be what is called a socialist idea. Now, what does this mean? So, for example, equal pay for equal work, or prevention of income inequalities, or prevention of concentration of wealth, or equal distribution of resources, they all become what are called socialist directive principles. Then you also have something called liberal or intellectual directive principles. Now, what does this mean? Anything which is not Gandhian or socialist is liberal. For example, uniform civil code, it doesn't fit into the state equally distributing something. It does not mean something which is a grassroots or a conventional idea. So it becomes a liberal or an intellectual principle. So that's how you can easily bifurcate directive principles. Another way to classify directive principles are that either some of them are goals, some of them are policies, some of them are non-justiciable rights, because as we know, directive principles are non-justiciable, they're not enforceable in a court. So for instance, when we say equal pay for equal work, that's a non-justiciable right as it's mentioned in directive principles. If we say that you should have prevention of concentration of wealth, it becomes a larger policy. If we say goal, we say that there should be universal, there should be abolition of liquor, or you say that, for example, there could be, in a manner of speaking, let's say there could be a good standard of life or a good level of nutrition. That could effectively be a goal. But this is a very, very academic distinction. It's not a very constitutionally determined distinction. So this is not generally asked. What is asked is identify if you're a Gandhian, socialist, liberal, or intellectual in that sense of the word. Now that we've understood, let's straight dive in and let's look at what is called the preamble. If there are few things that you've got to know about the preamble, this is what it is, and we'll quickly run through it. This is nothing too complicated. The preamble effectively tells you the following things. One, that we the people are the ultimate source of authority. It, as I mentioned before, tells you objectives for the state and aspirations for the people. That's the primary purpose of what is called the preamble. Now, apart from this, the preamble also gives you a date of adoption and an enactment to the constitution, which is the 26th of November 1949. You would remember, and if legal history serves you right, this is when the Constituent Assembly had passed the constitution. But to symbolically celebrate 26th January 1930 as the date where Poon Swaraj was publicly declared as our national agenda. It was passed in a 1929 December resolution of the Congress at Lahore, but it was on 26 January 1930 that we had publicly declared it. So therefore, we decided to commence the constitution from 26 January 1950, and legal history is something where I have explained to you. It's on 26 January 1950 that we now become a sovereign republic from what was called an independent dominion. Now, some technical questions that you will not get answers to generally. Can the preamble be amended? Yes, of course, the preamble can be amended. It has been amended before through the 42nd Amendment. It is a constitutional amendment under Article 368 without state ratification, because it is not explicitly mentioned under Article 368. It also reinforces Keswananda Bharati's judgment, which categorically says that the preamble is an integral part of the constitution, so therefore has the dignity to be what is called justified through a constitutional amendment. And through the 42nd Amendment, three words were added: socialist, secular, and unity and integrity. Now, what these words mean, I'll just cover in the next page. And then comes the larger question: is the preamble basic structure? As a whole, the preamble is not. That means you can change the preamble. The objectives, the phrases that are mentioned in the preamble are, which means, for instance, socialism is, as mentioned in the preamble, basic structure. So can I change socialism? Yes, in a way that the larger meaning of socialism does not change. So preamble as a whole is not basic structure, but the phrases mentioned in the preamble could be construed as basic structure. And as I've discussed before, since the preamble is not an independent source of authority, it is therefore neither a source of power nor a source of limitation whatsoever. Now, let's quickly look at the key ingredients as far as the preamble is concerned. Now, as far as the preamble is concerned, you've got two sets of ingredients. One are objectives of the state, and one is aspirations for the people. Now, what I've effectively done is, if at all there is going to be a question in this form, what we've got to know is the one line meaning that comes closest to this. There is no point having a deep academic discussion on it. The quickest and the most efficient way to do this is, what does your class 11th NCRT or your 12th NCRT identify as meanings to this? So what is it that we're referring to? For example, you've got the first word sovereign. Any option in the prelims exam which comes closest to the word non-interference. It could be non-interference externally, it could be non-interference internally. Sovereign effectively means independence of decision making. So any option that comes closest to non-intervention or independence of decision making is the correct answer. Socialist. Now, of course, there could be an hour and a half and maybe or even a 10-hour long lecture on socialism. But when we're writing an answer, when we're choosing an answer in the prelims exam, socialism effectively means intervention of the state for welfare. So anything that comes closest to state intervention for welfare is the correct answer. Now, interestingly, we've not had prelims questions from here, but we've had prelims questions from here, which means there could be a chance that they could suddenly turn tables. Now, secularism. With secularism, you need to understand there are essentially three things that we've got to know. One, everybody has freedom of religion. Two, the state is separated from religion. This means that there is no official religion of the state. This means there is no favorite religion of the state. It also means that the state can intervene on religion and the law can override religion as and when needed, which is why in the mains and in foundation courses, when I generally teach secularism, I cover essential religious practices as the center point of it. Because if you understand essential religious practices, you understand practically everything. Whether it's uniform civil code, power to excommunicate, manage religious affairs, right to propagate, ownership and management of religious institutions, and so on and so forth. There is deep state intervention. State separation does not mean that there cannot be state intervention. We have what is called state intervention. And finally, in the words of the great H.M. Sirvai, India is not an irreligious state. We are secular, but we are definitely not irreligious, which is why you will see a great intervention of state in religion. Now, as far as democratic, the word democratic is concerned, an easy way to remember this is S cube dr, similar to special drawing rights, a term that you would often use in economics. So democratic means two things: one, reflection of public will, and two, very, very importantly, the Council of Ministers are collectively responsible to the lower house. Now, this has been a PYQ. It has been a PYQ linking democracy to parliamentary democracy. Any option which has either of the two or closest to either of the two, or if these are two, you will choose this over this. Always remember this. And finally, of course, republicanism means that you have an elected head of state. The chances of this being asked are next to zero. Now we come to the words that are actually on this side, the words which are aspirations for citizens. Now, justice. There are two things you've got to know. One, the literal explicit words that are mentioned, and this is a common mistake that people do. There are previous year questions. For example, the question will say, economic justice is referred to. The answer is the preamble. Even if directive principles are trying to do economic justice, and I appreciate them for doing so, but the word economic justice explicitly written in the constitution, please remember the prelims tactics video that I had given you in the very first lecture. It has to be explicitly written in black or white. So therefore, Justice in the preamble has three forms: social justice, economic justice, and political justice. And justice has three approaches. It has to be non discriminatory, you have proportionate justice, and you have distributive justice. So, justice is essentially to undo a wrong. So, if people have been discriminated, then a wrong has been done to them. Everybody comes from different positions and places in life, so accordingly you should have different outcomes to them. It could work both positively and negatively, which is why the judiciary gets to decide the quantum of punishment. What generally happens is that your criminal laws tell you this is the maximum punishment that you can give. It is the judge that decides how much is the right punishment. A similar application of this could also be affirmative action. And speaking of affirmative action, you would have distributive justice. If people have been societally disadvantaged, if people have been civilizationally disadvantaged, then the government, of course, has the right to take the necessary actions needed to effectively make things right. So each of these, for example, social justice will have a non-discrimination angle, a proportionate angle, and a distributive angle. Economic justice would also have the three. Political justice would also have the three. This is how we generally write answers in the mains, but of course, in the prelims, this is more than enough. Now, as far as liberty is concerned, you're looking at liberty of thought, expression, faith, belief, and worship. Now, you've got to remember these, and liberty means two things. One, maximum development of oneself and no external restraints or interference. Liberty is nothing but personal sovereignty. That's exactly what liberty means. Of course, you have to play the devil's advocate when you solve questions. These have been asked in previous years, in the last 10 years. In fact, 3-4 years, this has been consistently asked year after year in different forms. For example, they'll ask you, if there is liberty, there is less laws. That's not necessarily true, because less laws could lead to more chaos. And why are you assuming that laws are necessarily anti-liberty? So you have to play the devil's advocate. Then you've got the words equality. Now, what happens with equality is that, of course, the preamble mentions equality of status and equality of opportunity. However, more importantly, the notions of equality, equal protection of law, and equality before law are categorically mentioned under Article 14, which I think we should do in a lot more detail. But what you should know is equality of status and equality of opportunity. As far as fraternity is concerned, fraternity means ensuring dignity. That's the key word that you're looking at, because in the preamble it mentions ensuring dignity, and the closest word to fraternity is brotherhood or commonality. And as far as unity and integrity is concerned, the closest meaning of this is national interest. If you know this much, you should be able to answer any question that the exam throws at you as far as the preamble is concerned. Now, once we've understood this, we now move to the next part, which is fundamental rights directly. Right? So let's start in a minute. When we begin fundamental rights, we start with the first two articles, which is Article 12 and Article 13. Now, Article 12 and Article 13 are of special significance because without them, there is not adequate context to fundamental rights. So let's start with Article 12. The UPSC has been a little shady with Article 12 when it has applied Article 12 to a mandamus under 32 and asked a fairly questionable question. But nonetheless, let's begin. Article 12 gives you the meaning of the word state. The first thing that we've got to know is state for part 3 and part 4 is the same thing as state under Article 12. So Article 12 not only defines state for part 3, which is fundamental rights, it is also defining state for part 4, which is directive principles of state policy. That is something we've got to be adequately very, very careful about. Now, very clearly, Article 12 talks about 4 things. It says the state includes the parliament and the union executive, the state legislatures and the state executive, all local and other authorities within the territory of India, all local and other authorities under the control of the executive union. And as you can adequately see, there are two basic problems. First, what is meant by local? What is meant by authorities, and what is meant by the control of the union. So, as a result of this, there is a series of Supreme Court judgments leading up to R.D. Shetty, leading up to Ajay Hasya, and so on and so forth, where the Supreme Court has given derivations on all of this. In fact, the Supreme Court has also derived a test on to identify what is an instrumentality of the state. There is a correlated doctrine also called the doctrine of state action, which we have in a limited manner imported from the US. But I'm going to make myself very, very clear. It is to be decided by the Supreme Court on a case by case basis. Even if they have to apply the test of instrumentality or the conditions laid by the Supreme Court in several Supreme Court cases, it is still decided on a case by case basis as to a specific entity being a state or not, whether it is, and we've seen previous Supreme Court cases on ONGC, on LIC, and so on and so forth. What we are particularly concerned about, as far as the prelims exam is concerned, is what is in the Constitution. These are the four elements which are in the Constitution, and we must keep that in mind. Now, a very important derivation is that the judicial function of the higher judiciary is not state. Now, why is it not state? And what does this mean? It means if you've gone to the High Court, the High Court has given an order and that order is against you. Now, can you go on appeal to the Supreme Court challenging the High Court order? Yes. But can you challenge the High Court order on the ground that the order itself is violating a right and therefore you've gone to the court under 32? No. You can go to the higher court under appellate jurisdiction, challenging the order of a lower court, but not on the case of using a writ. Now, why is this the case? It's the case because if the higher judiciary were state, that means they would become under the instrumentality of Article 12. That means no law can violate fundamental rights, and fundamental rights are available against the state, which means if higher judiciary and the judicial function of the higher judiciary was state, then the state would be compelled to give a pro-fundamental rights order, and that would effectively violate independence of judiciary and judicial review, both of which are basic structures. So understand this even more simply. If the judgments of the Supreme Court and the High Court were state, then those judgments would necessarily have to be pro part 3, because fundamental rights are available against the state and no law can violate a fundamental right. So therefore, if what you are doing is not state, then fundamental rights are not applicable to you. This is why the judicial functions of higher judiciary are not state. Again, this is a judicial interpretation, not a constitutional interpretation. The chances of this being asked in the prelims is extremely low. So, the non-judicial functions of the higher judiciary, are they state? Yes. Everything about lower judiciary is state? Yes. Which means a district court and below is state, whether it's a judicial function or a non-judicial function. But for higher judiciary, only the non-judicial functions are state. This is also why writs cannot be issued against higher courts, but writs can be issued against lower courts. In fact, we've got two writs, prohibition and certiorari, which can only and only be issued to lower courts. This is the larger example of it, the correlation of it. Now, this is what we know about Article 12. Article 13. Article 13 clearly says no law can violate Part 3. Now, the meaning of the word law would require some constitutional explanation. Now, Article 13 has embedded in itself the doctrine of eclipse that we've already discussed. So, 13.1 says pre-constitutional laws cannot be invalidated, their effect cannot be invalidated from the time that they were in effect, which is pre-constitution, which is pre-1950. However, post-constitutional laws can be invalid from the very start. So, Article 13 Clause 2 becomes the more contemporarily relevant article. And Article 13 itself, under 13.4, very categorically says constitutional amendments are not law, or constitutional amendments under 368 are not law. The reason why constitutional amendments under 368 are not law, and the reason why higher judicial functions of the higher judiciary is not state are effectively the same. Because if constitutional amendments under 368 are law, and no law can violate a fundamental right, so constitutional amendment cannot change a fundamental right. What if you want to evolve a fundamental right? It would effectively make the constitution an obsolete, fossilized sort of a frozen document. And that is something that we are not principally okay with. That is not something that was the vision of the makers of the constitution. You would always want the constitution to be a forever evolving document, to always change with changing times. In the same way, you cannot have the judiciary, higher judicial function, not state, because the intersection is very clear. When we talk about fundamental rights, we say they're available against the state, and no law can violate a fundamental right. So, if the judgments of the higher judiciary are state, if the judgments of the judiciary, or the judicial functions of the higher judiciary is state, that means fundamental rights are applicable on the judicial functions of the higher judiciary, which is the judgment, and you will never be able to give an independent opinion whether X is violating a fundamental right or not. In the same way, if constitutional amendments are law under Article 13.2, then you can never change the fundamental rights, and that would effectively stop the very evolution process, and it would undermine the powers of the parliament to amend the constitution under Article 368. Which then brings me to a very interesting question. Are Supreme Court or High Court judgments considered law for the purposes of 13 clause 2? By an expansion of interest in this, by an expansion of concept in this? No, they are not. Because if that was the case, then no Supreme Court, High Court judgment could ever give you an answer as to whether X is violating a fundamental right or not. Now, this is again a judicial or a legal derivation. It's not written in the Constitution anywhere. Up until this is where is clearly mentioned, but it is also derived constitutionally that, for example, there is an emergency proclamation, and under that emergency proclamation you are saying that a few of your fundamental rights are going to be restricted. So that emergency proclamation is effectively restricting your fundamental right. So is that allowed? Yes, that is by analogy of other constitutional provisions perfectly allowed, with no problem whatsoever. So therefore, this becomes our understanding on what is called state and supremacy. Now, moving from here, we move to our substantive fundamental rights. Equality. A large chunk of equality is something that we've covered in rule of law, because that's where the concept lies. Now, there are a few things you've got to know with equality. Number one, equality is available against the state as per Article 12. It's available for all citizens and foreigners. You do not need any additional law. It is self-executory by nature. And equality gives you two specific notions of equality: equality before law and equal protection of law. Equality before law simply means everybody, no matter who they are to be treated equally before the law. There is no special treatment whatsoever given to anybody, no matter who they are, what their status is, before the ordinary law of the land, before the courts of this country. And that's effectively what is meant by equality before law. Now, equality before law would therefore effectively be a UK concept, because you want everybody to be equal before the law, and before the law means any other law, and UK has had an unwritten constitution, so they've had an original understanding of that from there. But because no law is absolute, there will always be terms and conditions. So there are in fact several restrictions or several special cases to equality before law. For example, under Article 361, you have immunities given to the president and the governor. They have absolute immunities for actions in their official capacity, whether it is civil or criminal in nature. In their personal capacity, they cannot be charged with anything criminal till the time they hold office. In a civil capacity, in a personal civil capacity, they've got to be given a 2 months notice. So you're treating the president and the governor differently. In the same way, you would have diplomatic immunities, you would have special protections that are given to the armed forces, you would have 361A, where if you're true reporting what is called parliamentary proceedings, then you cannot be treated as everybody else who's doing a similar publication of proceedings job, because what you're doing, and even if whatever the content of the true parliamentary proceedings are, it could be objectionable, but the law cannot apply because you're simply the messenger and we don't shoot the messenger. So there are several such exemptions. What is equality before law doing? It is creating a special set of people who would be exempted from equality before law. Now, equal protection of law means everybody is not born the same, everybody doesn't come from the same advantages. It simply means that if it is a 100-meter race, a person who has had a disability and a person who's had great formal training and is wearing proper athletic shoes, they can't have the same start line, which is effectively what is called equal protection of law. So, equal protection of law is the birthplace of affirmative action, and one of the forms of affirmative action is reservation. So, it is effectively Article 14 that gives you the constitutional permission to reserve, and 15 and 16 effectively show you how that can be done. Now, therefore, equal protection of law largely deals with something called classification, but for a positive reason. Equality before law would be still allowing classification, but for a negative reason. So there is a positive and a negative connotation, and therefore it means treating like people alike. It does not mean that everybody who is different is similarly different. So you cannot treat people who are not like each other as the same group. So a physically disabled person cannot be treated in the same way as a person who has been socially disabled and therefore comes from a lower caste. So that's the larger understanding. But what is more important is whether it is equality before law or equal protection of law, it is allowing you to classify people. One is allowing you to classify negatively, the other is allowing you to classify positively. So the Supreme Court comes up with something called the Doctrine of Reasonable Classification, which means that it is perfectly all right to have groups of people serving a certain purpose. Makes absolute sense. But if you are going to classify, you should be able to answer two questions. First, the basis on the basis of which that you're classifying, that basis in itself is reasonable enough, and by classifying these people, the objective that you're trying to achieve first is a reasonable objective, and two, the objective is going to be achieved by classifying these people. As long as you can prove both of these things, the classification is valid. A simple example is you're classifying people on the basis of caste and therefore creating a scheduled caste community. By doing this, what are you trying to achieve? You want to give them a heightened opportunity so that everybody can equally compete. If that is the case, by giving them additional benefits, are you able to achieve better equality of opportunity and status? The answer is yes. So this classification is valid. So the technical term for your basis being reasonable is rational nexus, and the technical term for your objective being fair, justified and achievable is effectively called intelligible differentia. So to understand this carefully, intelligible differentia, I'm sorry, I've reversed it. Intelligible differentia is your basis is reasonable, and rational nexus is that your objective is fair, just and achievable. Now, this is the larger application of it. Again, is this in the Constitution? No. It has been judicially interpreted. So, the chances of this being asked in the prelims are extremely, extremely low. But what is actually happening? This is where you have to pay attention. Our journey started with rule of law. We understood rule of law had three branches: absence of arbitrariness, equality before law, and predominance of legal spirit. We understood that equality before law also means equal protection of law, which means you have now the ability to classify. If you have the ability to classify, which means you can treat people differently. Now, this means the classification has to be just, the classification has to be appropriate, and the classification has to be adequate. So, therefore, if the classification is not fair, just, or reasonable, it would effectively be arbitrary. And if it is arbitrary, you can question it in a court of law, therefore, predominance of legal spirit. So, what Article 14 really, really does is that it attacks arbitrariness at the core of it all. And this has been a previous year question. I've discussed this in the earlier lecture also. Arbitrariness is a violation of Article 14. It's something that we've already done. It's something that the exam has also asked you. They said that if there's an organization given with unwarranted powers to apply indiscriminately, what is it a violation of? It is a violation of Article 14. So this is Article 14, important for the prelims exam, as we should know. Now, apart from Article 14, we are now to Articles 15 and 16. Article 16 has been asked in 2023 already, so the priority becomes low. Let's quickly go through Articles 15 and 16. Article 15 clause 1 and 2 are largely referring to what are called non-discrimination articles. They're available against the state, they're available only and only for citizens, and they say that you cannot discriminate on the basis of caste, religion, race, sex, or place of birth. They use two very important terms: any or all of them, which means C plus R plus R plus S plus P or any combination of this is not okay, and just on the basis of this is not okay. But if there is something else which satisfies the doctrine of reasonable classification, which allows you to give a classification which is just, fair, and reasonable, yes, you can do that. The plus X principle is perfectly okay. What is not okay is anything which is C, R, R, S, and P. Do we understand this fairly and carefully? Yes, very, very simple in its essence. Now, once we figured this out, let's look at 15.3. 15.3 has been the original part of the Constitution. It allows for the state that nothing will stop the state. Again, a negative connotation, but asking the state to do something positively. It allows the state to make any provision. It could be a law, it could be an executive order, scheme, anything for women and children. And this is the starting point of identifying your first reasonable classification, which is women and children. Now, after the Supreme Court had effectively struck down a reservation policy of Tamil Nadu in the Champakam Dorai Rajan case. In response to that, we had what was called Article 15 Clause 4, which was added in the First Amendment itself. Now, 15.4 says, again, it's for the state, and you can make any provision for socially educationally backward classes, for scheduled castes, and for scheduled tribes. This is categorically mentioned under Article 15.4. It still does not talk about education. Your education policy for reservation is in 15.5 and 15.6. 15.5 was added through the 93rd Amendment 2005, and 15.6 was added through the 103rd Constitutional Amendment of 2019, which is the EWS Amendment. So what is basically our reservation policy? We have to just know our reservation policy for education in one line. It is obviously for the state. It's obviously only for citizens. If you're giving reservation in education for socially educationally backward classes, scheduled castes, and scheduled tribes, has to be by law. Today's socially educationally backward classes are called OBCs. That's the post-Mandal era. And if you're giving educational reservation for EWS, you can do it through any means, whether it's a law or an executive order, as categorically mentioned. Now, where in education can you give this kind of a policy? The idea is public education, private education, aided education, unaided education. The one place this reservation policy for education does not apply are religious and linguistic minority institutions under Article 30. Apart from this, it is clearly applicable no matter what, and it'll be applicable to all institutions. Public, private, aided, unaided, does not matter. The difference is, if it's an education policy giving educational reservation to scheduled castes, scheduled tribes, and OBCs, you require a law. If it's educational reservation for EWS, it can be a law, it can be an executive order. There's absolutely no problem whatsoever. So this is your education policy for reservation, which is a part of Article 15. So if you know carefully, Article 15 again has reflections of equality before law and equal protection of law. So 15(1) and 2 are reflections of equality before law, that will not discriminate against anyone in a public space and so on and so forth. But 15(3), 4, 5 and 6 are reflections of what is called equal protection of law. It's as simple as it is. Now, Article 16. Let's understand Article 16 as clearly as we can. Article 16 will also have similar reflections, which is equality before law and equal protection of law. Now let's understand this carefully and very, very clearly. See, Article 16(1) and Article 16(2) effectively are equality before law. Article 16(4) onwards is equal protection of law. That's the basic difference. Article 3 is also an enabling clause for equality before law. This has been asked in 2023, so therefore the relevance of it becomes even lesser. Article 16(1) says there should be equality of opportunity in matters of employment, obviously public employment, so against the state, and only for citizens, because why would you want to give foreigners equality in Indian government jobs? Now, Article 16(2) says, in addition to CRRSP, descent and residence. They've not used the word domicile, they've used the word descent. So descent and residence could also not be criterias of discrimination. So Article 62 says you cannot discriminate on the basis of descent, residence, caste, religion, race, sex or place of birth. Again, the same logic applies, any or all of them. And Article 16(3) is sort of an exception to 16(2) and says, oh, if you want to give a discrimination on residence, if you want to make residence a criteria, you can only be done by a law, and the only person who can do it is the parliament. The states cannot do it, a reflection of center stronger than the states. And if the states could be given the opportunity to give residence as a qualification, every state would say that you've got to be from our state to do this for us. Now, Article 16(4), because it's the original text of the Constitution, it mentions the word backward classes. So 16(4) says the state can make any provision. It could be a law, it could be a scheme, it could be anything for the upliftment, for the representation of backward classes who, in the opinion of the state, are underrepresented in the state. Now, the opinion of the state is obviously very, very subjective. Now, 16(4)(a) and 16(4)(b) have been in responses to Supreme Court judgments. 16(6) is the EWS setup. So whether it's Indira Sawhney or Jarnail Singh, you'll see some form of reflections on that count. So basically what you need to do is, 16(4)(a) was added by the 77th Amendment of 1995, 16(4)(b) was added by the 81st Amendment of 2000, and 16(6) was added by the 103rd Amendment of 2019. Now, what is it that they say? They say that the state can make any provision. Now, here, any provision is for everyone, which means even for SCs, STs, and let us say OBCs, you can make any provision through law or a scheme or an executive order, and even for EWS for employment based reservation. Here you had to make a law. Here for educational reservation for SC, ST, OBC, you've got to make a law. For employment reservation in SC, ST, OBC, you can make a law or you can give a direct order. And once you give reservation in employment, you are also legally allowed to give reservation not only at the recruitment stage but also at the promotion stage. You give reservation and somebody gets promoted because they are reserved, they become senior to the rest of the batch, they continue to retain their seniority, which is effectively what is mentioned as consequential seniority. But consequential seniority is effectively only and only for scheduled castes and scheduled tribes. It's not for OBCs, it's not for EWS. So consequential seniority would therefore only be granted to scheduled castes and scheduled tribes. Now, similarly, if there are any leftover seats from the previous recruitment year, and those seats could be added to the next year even if it breaches the 50% rule, which was the Indira Sawhney case. So that's another policy that has been integrated as a response to the Indira Sawhney judgment. So again, the carry forward rule will only be applicable to scheduled castes and scheduled tribes. Now, while you are giving reservation in employment, you are bound to consider Article 335, and this was in the prelims last year, that any reservation in employment should bear into mind that the reservation should not hamper the efficiency of administration in the country. As long as that is the case, there is absolutely no reason why you should not or why you cannot give any form of educational reservation. Article 16(5), by the nature of it, is not particularly relevant. It speaks that if there is a religious denomination and there is a head of that religious denomination, and there is a law that says that the head of the religious denomination should necessarily come from the same religion, then there's absolutely no problem. Effectively, you're giving a special condition on religion based reservation. So for example, Shwetambar Jains are a religious denomination. So the head of the Shwetambar Jain community is necessarily to be a Jain. If there is a law that provides for it, that law is perfectly valid, there's nothing wrong with it, and you are allowed to keep that law. That's effectively what is effectively meant by Article 16. So across reservation, what you also need to know is we have a horizontal and a vertical policy, which simply means that in the horizontal and vertical policy on reservation, for example, you have scheduled castes, scheduled tribe, OBCs, and EWS. Now, if there is another layer of reservation, let's say PWD, so it's PWD SC, PWD ST, PWD OBC, PWD EWS, and of course unreserved would also have PWD. So there are going to be two kinds of scheduled caste seats: scheduled caste non-PWD and scheduled caste PWD. That is more than enough as far as this exam is concerned. In the mains, we generally do a full timeline, but this much of context to reservation policy, to my mind, is more than enough for the prelims exam. One does not have to necessarily get into it. Now, from here we move to Articles 17 and 18, which have been asked in the exam in a certain manner. Now, Article 17 was asked from a very conceptual point of view. What was asked was, is untouchability an issue of equality or exploitation? And most people got confused and they thought it's exploitation. Untouchability is effectively treating a class of people as not even dignified to be in the caste system, which itself is a faulty idea, and therefore treating them as lesser beings. It does not necessarily mean exploiting them, which is why when you're treating a certain set of people as lesser people as everybody else, you're not necessarily exploiting them. It could be one of the things that you could do to them, but it's not necessarily a very natural outcome. When we're referring to Article 17, we are effectively referring to some basic provisions. First, Article 17 is non-self-executory in nature, which means you will require to make a law which allows you to effectively give effect to the fact that you are prohibiting untouchability. The Constitution prohibiting untouchability will not effectively make a lot of difference. The Constitution calls for the criminalization of untouchability by a law. Who can make that law? Can that law be made by the Parliament? Yes. Can the law be made by the states? Yes. Criminal law is in the concurrent list. What has happened in India is we have merged an earlier law into a current law called the Protection of Civil Rights Act. The Protection of Civil Rights Act 1955 very specifically is the law which criminalizes untouchability, and therefore it has two basic provisions. One, the burden of proof, which means innocent until proven guilty or guilty until proven innocent. In a special law like this, the burden of proof is on the accused. It is the accused who has to prove before the court that the accused is the one who has to prove that they have not committed the crime. The defense has to prove that they are innocent. The prosecution does not have to prove that, oh, the defense has done it. So that's one important point. Two, if you are convicted of untouchability under this act, then you're banned from contesting elections for 6 years from the date of your release. This is because often it is used as a political tool. In addition to this, you also have a law which is specifically for scheduled castes and scheduled tribes, the Protection Against Atrocities of Scheduled Castes, Scheduled Tribes Act, under which there is a specific section that if you are practicing untouchability specifically against scheduled castes, because scheduled castes are very closely often unfortunately merged with the concept of untouchability. If that is the case, then you have some special criminalizing provisions for it. That's all that you really need to know as far as Article 17 is concerned. Article 18, on the other hand, very clearly was also asked in the exam before. It was uniquely asked after the pandemic because several people had returned their their awards after the pandemic. Now, Article 18 refers to three basic things. Article 14 says, first, military and academic titles can be given by the state. So whether it is Field Marshal, Lieutenant Colonel, ranks, etc., academic titles such as a PhD can be given by the state. No other title of any nature can be given by the state. It also very clearly says, now this is not in the Constitution, this is through a Supreme Court judgment, that awards are not titles. This was also asked in the prelims exam, which is why I'm giving you Supreme Court judgments as and when necessary, which are necessary outcomes of it. Now, apart from this, the irrelevant part for the prelims exam, citizens can't accept foreign titles, obviously. Foreigners who are working for India cannot accept a foreign title without the consent of the President. This, of course, means the consent of the Council of Ministers, and no one working for India is able to accept or should be allowed to accept any present, any emolument, any gift from anything foreign without a presidential consent. So this is generally what is meant by abolition of titles. The chances of this being asked in 2023 are extremely low. It was a one-off question, and therefore the chances of it being asked this year in 2024 is even lower. Now, this is enough for as far as Article 14 to 18 is concerned. Now we uniquely move to Article 19. Now, very interestingly, there has not been a single question on Article 19 in the prelims exam. Article 19 could have been one of the options in a few questions here or there. And the reason why Article 19 is rarely in the prelims exam is because Article 19 is very open-ended, and it is therefore extremely important for the mains exam. It's a favorite of the mains papers. But for the prelims exam, Article 19 seems to have a very, very limited, you could say, usage, or a very limited form of utility. So let's quickly look at just a contextual overview, a legal overview of Article 19. Now, Article 19 effectively has some rights and some reasonable restrictions to those rights. So you have speech and expression under 19(1)(a), and you have restrictions to speech and expression under 19(2). Similarly, you have peaceful assembly without arms under 19(1)(b), and you have restrictions to those under 19(3). Similarly, 19(4) is the restriction to the right on associations, unions, and cooperatives. The reasonable restrictions to movement, residence, and settlement, which was a mains question, I think, in 2023 or 2022, is effectively the reasonable restrictions are common to 19(5), and reasonable restrictions to profession, occupation, trade, and business under 19 Clause 6 are separately mentioned. Now, what is interesting about Article 19 are the following things. One, it is one of the most detailed articles as far as Part 3 is concerned. And two, it contains the word morality in two places. Apart from here, you will also see morality in Article 25 and 26, which closely follow as our discussion right after this. Now, let's quickly go through Article 19. There really is not much to do as far as Article 19 is concerned. Article 19 is speech and expression. Speech means verbal, expression means anything in any form. Of course, it will have a close association to dissent, it will have a close association to censorship, it will have a close association to several identity driven rights. The jurisprudence around speech and expression is that it has largely been used as a right which is an instrument of democracy, and of course has had some correlations with rights pertaining to privacy, identity, orientation, autonomy, and bodily integrity. The reasonable restrictions to freedom in speech and expression, as you can see, are the longest than any other right. It has sovereignty and integrity, security, friendly relations with foreign countries, public order, decency or morality, contempt of court, defamation, and incitement of an offense. Now, do you need to memorize these? I don't think so. Out of these, sovereignty and integrity were added later, and this was largely done in, I think, 1963 as a response to the Kedarnath judgment, which had softened the sedition law, saying that you would require a direct impact on violence for it to be considered an issue of sovereignty and integrity. You will see sovereignty and integrity therefore added as a reasonable restriction in two other rights, because speech and expression, peaceful assembly, and association also have a correlation to protest, to strike, and so on and so forth. The second right is the right to peaceful assembly without arms. The reasonable restriction to the right to peaceful assembly without arms is the following: 1. Sovereignty and integrity, and 2. Public order. The third fundamental right is the right of association, unions, and cooperatives. It has 3 reasonable restrictions: morality, as I was telling you, sovereignty, integrity, and public order. Of course, there's a series of Supreme Court judgments as far as Article 19 is concerned. Movement and residence and settlement, 19(1)(d) and 19(1)(e) will have the same fundamental restrictions. General public interest, and very, very importantly, protection of scheduled tribes. It does not mention scheduled castes. In derivations and applications, you could still look at it, and therefore, what we're effectively looking at, what we're effectively looking at is this protection of scheduled tribes. So, for example, things like the 5th schedule, 6th schedule, autonomous councils, inner line permit areas, these are all applications of protections of scheduled tribes. And of course, profession, occupation, trade, and business. A, general public interest. 2, the government can lay down any qualifications for you to do any job. And 3, if the government wants, it can reserve any sector it wants to for its presence and its presence only, therefore giving effect to something called nationalization. And that's effectively what is called Article 19. What you need to know with Article 19 is that if Article 19 includes the freedom of speech and expression, it means you have the right to have a speech and expression about the government. For you to have an opinion about the government, you need to have information about the government. And for that, you need information from the government about the government to have an opinion on the government. So therefore, you have what is called right to information as an implied fundamental right under Article 19. And if you remember yesterday's Supreme Court judgment on electoral bonds becoming unconstitutional, and this is how recent I record your lectures so that you get the most updated in your lectures, it is important for you to know that right to education was a conflict area with respect to right to information was a conflict area with respect to electoral bonds. Because, very simply, if I do not know who has given how much money to a political party, then as a voter, for me to take an informed decision on who to choose in the next election could therefore be compromised, and therefore my right to information becomes a considerably difficult problem. So that was something that was discussed. It also had an implication to right to privacy, that if I have decided to vote for a political party, or if I've decided to donate to a political party. Who I am and what I have decided to donate to is a matter of my privacy. And if it is an instrument of my privacy, then therefore it should be held within myself as to who I can donate to, and I'd like to keep it confidential. So RTI and privacy were issues that were discussed in the electoral bonds judgment. But as far as the prelims is concerned, to my best understanding and to the best of my wisdom, I genuinely think Article 19 is the lesser done, the better. Now comes Article 21. Much like Article 19, Article 21, because of the nature of it being so open-ended, becomes extremely unlikely. But let's go through it because it has some key concepts that we've discussed in jurisprudence, rule of law, etc. in the earlier lectures. Now, Article 21A is available against the state. It's available only for citizens and foreigners. It's available for all citizens and foreigners. And very interestingly, it contains the words procedure established by law, which simply means if there is a procedure and the procedure has been implemented, then it is good. The government can restrict your life and personal liberty through any procedure that the government has because the law has passed that procedure. Is it good procedure, bad procedure? By a simple meaning of it, doesn't matter. It is exactly why the Menka Gandhi case in 1978 happened. We've discussed this earlier. So in that case, it was understood that the procedure established by law should also include procedural due process, which means, okay, the procedure has been passed by the law, and just because it has been passed through a law doesn't necessarily make it a good procedure. So I'd like to check the fairness of the procedure, and that's effectively what the Menka Gandhi case was about, because if the Passports Act allowed you to take someone's passport away and you were not giving somebody the right to even question that decision, the procedure seemed to largely be unfair. And because of this, it means that the procedure, if the procedure is unfair, this means effectively that there is something wrong with the procedure. So if I have to check whether the procedure is unfair or not, I would have to apply what is called principles of natural justice. Now, principles of natural justice mean two things. One, we've discussed this before, there should not be any bias in any form. And two, there should be an opportunity given to everybody to be able to access a fair hearing. So, for example, if the judge has a conflict, or for example, that let's say you have a financial stake in an administrative inquiry, or you have a relative who's going to get a tender and you're sitting on the tender committee, it is violating the first principle of rule against bias. The Latin phrase of it is called nemo juda causa in sua. The Latin phrase is not asked in the exam. You should know what rule against bias is, and the rule for a fair hearing, which effectively means, for example, if there's an inquiry against you and you don't even get to read the charges against you, you don't get to cross-question, cross-examine, you don't get to even rebut the witness or the evidence, then it's not really a fair hearing. So therefore, the second principle, the odi alteram partem principle, is the principle of natural justice. So, procedure established by law to procedural due process of law to something called principles of natural justice. This is effectively the outcome of Article 21. Because of the Menka Gandhi case, there are two things that happen. What if, and this is important, what if Article 21 tells you life and personal liberty? Article 19 says you have speech and expression, you have peaceful assembly, you have the freedom of association, movement, residence, settlement, profession, occupation, trade, and business. Now, there are obviously a lot of things in common. If I do not allow you to speak, I will also take your personal liberty away. If I arrest you, I am of course taking your movement away and your life and personal liberty by taking the dignity out of it. So therefore, in that scenario, in that specific case, what happens? There is a clear-cut relationship between 19 and 21. And ultimately, why somebody is doing it is generally through a law, which means the law has created some bias because the classification is a problem. So Article 14 also gets attached to 14, 19 and 21, and therefore you have the holy trinity of 14, 19 and 21, and that's exactly what happens as an outcome in the Menka Gandhi case. So what happens is, if there are freedoms that come both under 19 and 21, you will see if the violation is justified under the reasonable test of 19. You will see if it fulfills the requirements of Article 21, and you will also see if it is fulfilling the arbitrariness test of Article 14. Freedoms which are only about 21, you will see 21 plus 14, but if it's 19 and 21, you will definitely see 14. This is the outcome of the Menka Gandhi case. It's important for this year's prelims exam because last year they asked you principles of natural justice and due process of law. Now, Article 21 means a ton of things through ton of judgments: the right to livelihood, shelter, food, health and medical care, life with dignity, death with dignity. Post the Supreme Court judgment, which has not allowed for civil union of homosexual couples, you do have the right to marry, but only for heterosexuals. This has been a PYQ before, where the question was, do you have the right to marry? The answer was yes under Article 21. Now, do you have the right to marry? Yes, only if you are a heterosexual. Right to privacy has also been a PYQ. Right to privacy is largely a right under Article 21. Because of privacy also correlated to surveillance, it will also have an intersection with 19, and therefore 19 becomes a subsidiary right to privacy, but the primary right that privacy comes under is under Article 21. You also have something called the right to legal aid, and I will discuss this in the context of criminal justice. You have the right to fair and speedy trial and the right to clean and a healthy environment. Legal aid has also been a PYQ favorite. There have been 2 questions in the last 10 years, and the right to a clean and a healthy environment includes that the court has come up with several principles with respect to environment. For example, polluter pays. For example, sustainable development. For example, public trust. For example, intergenerational equity. These are all Supreme Court derivations on what the right to environment actually substantially should and could mean. Now, this, to my mind, again, is more than enough as far as Article 21 is concerned. Now that we've done 14, 19 and 21, and because they were related, we should now look at criminal justice rights, which I will teach you the basics of, and then I'll get you through some criminal procedures because that has been relevant as far as the UPSC is concerned. Now, let's start. When we're looking at Articles 20 and Articles 21, you've got to understand the following things. First, Article 20 gives you general principles with respect to criminal justice. It tells you the following things. 1, it's available only against the state. 2, it's for everybody, citizens and foreigners. 3, it speaks of 3 specific criminal principles. 1, a criminal law cannot be applied on a backdate. For you to be charged with a criminal offense, it has to be a criminal offense on that day. So, if today you're committing a crime, it should be a crime under some law, and the punishment of today is the punishment that you're going to get. Tomorrow, the government can't go back in time and increase your punishment or increase the severity of your crime. 2, 1 crime, 1 punishment. 2 crimes, multiple punishments. You cannot be charged or prosecuted. The 2 words are, you cannot be prosecuted or punished for the same crime more than once. Different crime? Yes. Civil and criminal? Both. The same crime can attract many sections of different criminal laws? Yes. And whatever the maximum punishment that the judge deems fit could be given to you, shall be given to you. And you cannot be compelled to be a witness against yourself. This is also a principle of natural justice. It's also a very important principle of criminal law. You can't be forced to give evidence against yourself. This is also why any testimony given before the police has to be verified in a court of law. This is also why things like narco analysis have been declared unconstitutional by the Supreme Court. Now, Article 22 is where the kicker lies. Article 22, very specifically, Article 22 refers to arrest and preventive detention. So let's understand what this is. A simple tabular comparison is more than enough. Anything beyond this is not relevant. Arrest is generally post offense. Preventive detention is pre offense. By the nature of the word, this is what it means. Now, legally, there is a difference between arrest, remand, etc., but that's not for you for the prelims exam. Whether you've been arrested or you have been preventively detained, do you have the right to be informed that yes, this is why you've been arrested or preventively detained? Absolutely. Do you have the right to inform other people that you've been arrested or preventively detained? Here's the difference. If you've been arrested, yes, but the Constitution is silent on whether you have the right to inform other people that you have been preventively detained. The Supreme Court, in the case of D.K. Basu, says that you should, and there are massively brilliant guidelines given by the Supreme Court. Now, protections against arrest is available for everyone, citizens and foreigners, but protections against preventive detention is available against citizens, it's available against foreigners, except those foreigners who are enemy aliens. Why? Because enemy aliens could be spies, could be agents, etc., etc. Now, another crucial difference. If you've been arrested, you have the right to legal representation. But if you've been preventively detained, you don't. Can you challenge your preventive detention order? Yes. But you have the right necessarily to a lawyer? No. If you've been arrested, you have the right to be presented before a magistrate within 24 hours. Now, you don't have that right if you have been preventively detained. This is simple enough to know for Articles 20 and 22, but it also gives me a pathway into criminal justice. See, what has happened is in the last few years, the UPSC has asked fairly enough questions as far as criminal justice is concerned. They've asked you who regulates prisons, what is the difference between a judicial custody and a police custody. To be very honest, any question on criminal justice could be answered in two ways. One, separation of powers, LENJ, which is rule number 3. And two, the fact that law and order is in the state list. So let's apply this. Police custody means you're in the custody of the police. Judicial custody means you're in the custody of the judiciary, which simply means that the police cannot interrogate you without the permission of the judiciary. This is essentially separation of powers. Now, similarly, prisons are regulated by state governments. If prisons are regulated by state governments is a plausible statement because law and order is the state. So administration of law and order would effectively be the state because the police manages the prisons. Police is the state list. So therefore, prisons are the state list. So by just this, you can answer the criminal justice questions very honestly. But I will still get into some basics of it so that it's easy for you to understand. First things first, when we're getting into criminal justice, there are a few basic things that we've got to know. The basic stages of criminal justice is, first, the crime has been committed. Then the crime has been investigated. Then the crime has been tried. And then, of course, the outcome of the crime. In criminal justice, these are your 4 basic trials, or these are your 4 basic stages. Now, there are effectively 6 constitutional guarantees as far as criminal justice is concerned. Guarantee number 1, if there's something that is unfairly done to you, it is a violation of Article 14. For example, if a criminal law is unfairly applicable to you, it is a violation of Article 14. 2, if principles of criminal justice are not being applied to you, if you've been subjected to diverse criminal laws, it's a violation of Article 20. 3, if you have been illegally arrested, you're fundamentally being violated of Article 21. If you have not been given adequate protections of arrest or preventive detention, your Article 22 also seems to have been violated. And 3, you also have the right to justice and legal aid under Article 39A, which is the Directive Principles of State Policy. And you have the right to go to a court, you have the right to question a bad criminal law under Articles 32 and 226. So there are effectively 6 constitutional guarantees that exist for us. Now, once we understand this, we must also then understand the basic stakeholders as far as the criminal justice system is concerned. Your basic stakeholders are, first, you of course have the police. Fairly simple, police is under the state list. Two, this is the interesting part. You have prosecutors. Now, prosecutors are effectively appointed by the state government because they are the ones who are going to try the case against the defense. Three, magistrates. There are two kinds of magistrates, judicial magistrates and executive magistrates. We've done this largely because we wanted to implement a directive principle that says separation of powers from the legislature and from the executive and the judiciary. So the judicial magistrates are appointed by the High Court of the state. The executive magistrates are appointed by the state government of the state. The difference is in the powers that they have, in the punishments that they can give, and so on and so forth. Magistrates are low to low criminal courts, and then of course you have the courts in our country, which are a very important stakeholder. Apart from this, you would have defense counsels if there are prosecutors, and you would also have witnesses just in case to cross section and to substantiate your evidence. And you would have prisons which are regulated by the state government. So this is generally what your stakeholder is. Now comes the larger question, who can punish for what? Now this is technical, so just bear in mind and just bear with me for some time. Basically, the Supreme Court can give you any sentence. Everybody has criminal powers. Supreme Court has criminal appellate powers. The Supreme Court can give you any sentence which is authorized by law. The High Court also can give you any sentence which is authorized by law. Then you have things called the Sessions Court. Now, the Sessions Court would have a little bit of a limitation, which means that the Sessions Court can also give you any sentence authorized by law, but a sentence of death. And if the Sessions Court is giving you a death sentence, it has to be confirmed by the High Court. Then you have additional sessions judge. They can give you punishments for about 10 years. 10 years, up to 10 years, and or fine. Then you have judicial magistrates who can give you punishments till about 7 years. Then you have the chief metropolitan magistrate who can also give you for about 7 years. And then you have metropolitan magistrates who can give you for about 3 years. And then you have judicial magistrate first class who can also give you for 3 years. And then you have something called a judicial magistrate of second class who can give you a punishment for about 1 year. Obviously, the fines would also reduce over a period of time. But this is largely how it works. In this entire process, when you are in trial, you are entitled to bail. What you must know under all circumstances, and this is the important part, both the magistrates and the police can give you bail. There are some cases where you have a right to bail, there are some cases where you don't have the right to bail. Now, amongst all of this, what is actually important for the exam is the fact that you have legal aid. Now, legal aid becomes extremely important. It's also a fundamental right we were discussing before. The Legal Services Authorities Act of 1987, if I remember correctly, Section 12 gives you a list of people who are entitled to legal aid. So under Section 12 of the Legal Services Authorities Act of 1987, the following people are entitled to legal aid. And it is closely related to vulnerable sections and social justice, but legal aid has been a UPSC PYQ favorite. There have been at least 2 questions in the last 10 years, and therefore they become important from that context. So the first thing is member of a scheduled caste or a scheduled tribe. 2, if a person has been a victim of human trafficking or begar. Second. Third, if the person is a woman or a child. Fourth, if a person has any form of disability recognized under law. Fifth, if there is any person under circumstances of deserved or undeserved want who has basically been a victim of a disaster. a person who has been a victim of violence, a person who has been a victim of caste atrocity, a person who's been a victim of a flood, a person who's been victim of an earthquake, of an industrial disaster, or a drought for that matter. These are people who are entitled to legal aid. Very interestingly, even an industrial workman is entitled to legal aid. Followed by the industrial workman, you also have a person who's in custody, which is why you would often hear, if you can't get a lawyer, we'll get a lawyer for you, when the police is trying to get you in custody. And lastly, there is also an economic criteria. This was where the UPSC question was. A person who makes a person who's in the receipt of an annual income which is less than 9,000 rupees or higher as may be prescribed by the state government. And if the case is before any other court than the Supreme Court, then the person should be making less than 12,000 bucks as may be prescribed by the central government. So if you're before the state government, less than 9,000 bucks. If you're before the Court, then 12,000 bucks. There's an economic criteria. So this is enough for us to understand who are entitled to effectively what is called legal aid. Now this takes care of articles 20 and 22. We are done with 18. We were done with 19 and 21. Let's quickly now move to the rest and finish it up. Exploitation. Exploitation articles are closely related to articles 23 and 24. Exploitation articles under 23 and 24 largely deal with two parts. Article 23 deals with exploitation. 24 deals with a narrower form of exploitation, which is called child labor. Now, Article 23 is available for both citizens and foreigners. Like untouchability, it's also not a self-executory act. And like untouchability, we've passed two laws, the Immoral Trafficking Prevention Act and the Bonded Labor Act. Now, both of these become extremely important because they are the ones that actually criminalize what is called forms of human trafficking. Now, Article 23 also allows the state to impose what is called conscription, which is basically compulsory service of the people. Now, there are essentially on the following grounds that the state cannot discriminate while making it compulsory for people to do something. Israel has this in the form of military conscription. So, caste, class, religion, and race. Very interestingly, women have been excluded from this because the most common form of conscription is a military conscription, and the orthodox thinking is that women don't have the physical ability to serve in the armed forces, which thankfully now is changing in due course of time. Now, to understand the basic difference, again, simple. Three variables: the consent of the worker, the legality of the work, and wages paid. With human trafficking, there is no consent, the work is illegal, and the wages could be paid. A very common form of human trafficking is prostitution, and the Immoral Trafficking Act is the regulating law on prostitution, and it basically says commercial prostitution is not permitted. What it also effectively says is that any form of, you could say, public prostitution is not okay, running a brothel is not okay, being a pimp is not okay, calling for people in public places is not okay. But if somebody is doing this in their private room, in their private residence, it's perfectly okay. Forced labor is where there is no consent, the work could be legal, and you may or may not be paid. In fact, the Supreme Court has said even if you've been paid for something you did not want to do, it is still forced labor. Third, begar is where you wanted to do this, you agreed to do the work was dominantly legal, but you were not paid for it. So it's basically unpaid labor. This is exactly what is Article 23. Now, Article 24 is available for both citizens and foreigners. It is non-self-executory in nature, which means like 23, you will also have to make a law for prohibition of child labor. What it basically says is children below 14 cannot work in dangerous places. Agreed. But there are so many ifs and buts that are left open-ended. So what happens is you have the Child Labor Prevention Act, and it gives you two major clarifications. The first clarification is if you're below 14, you can actually work in a family-run enterprise or an audiovisual entertainment industry. children below 14 cannot work in dangerous spaces means that children below 14 can work in non-dangerous spaces. So they've identified the non-dangerous places. It's as simple as that. Now, 14 to 18, they've created a new class of people, a new class of adolescents. They can work only and only, they can work anywhere except for three places. They cannot work in places which has inflammable substances, they can't work in places which have mines, and they can't work in places which have explosives. Now, interestingly, you're allowing a child to work, but under Article 21, you're making it compulsory for a child to go to school. So therefore, you have to read 21 with Article 24. 21 is, it's available for the state, it's for citizens and foreigners both. It's free if you can't pay for it. It's compulsory means if you're willing and you're able to go, which basically means your parents have given you consent. Then you're entitled to go to school between 6 to 14 years. Now 6 to 14 sort of overlaps with this. So a child is willing to go to school, is able to go to school, has the parental consent to go to school, and therefore if the child is not going to school, that means it's the state's fault. On the other hand, you're allowing the child to also work in a non-dangerous place. So therefore, Article 21A has to override Article 24, and therefore it is that theek hai, if you want to go to work, you can go to work, but the work will have several limited conditions as mentioned, as if it was a family run enterprise or it was an audiovisual industry. So that's the basic understanding of Articles 23 and Articles 24. Now, 25 to 30 has to be done together. They deal with religion and minority rights. There has never been a question from here in the exam, but given the fact that the Aligarh Muslim University case has been in the news, so minority rights could be a question. But again, the question on minority rights will only and only come if it comes from core constitutional provisions. There are, of course, tons of Supreme Court judgments on this, and they're very important for the mains, but particularly not important for the prelims. You've got 25, 26, 27, and 28. They deal with freedom of religion, and you've got 29 and 30, which deals with minorities. If you do them together, because religious minorities are associated to religion, let's quickly look at what they are. First, Article 25 is available for everyone. So basically, Articles 25 to 26 are available to everybody, to citizens and foreigners. Let's do this block first. Article 25 tells you have the right to conscience, practice, profess, and propagate. Conscience means you have the right to believe in a supreme being or not, and how you believe in the supreme being is entirely your call. Practice is, however, you want to practice the ceremonies and the rituals associated to your religion. Profess is if you want to disclose the religion that you have. That's generally through wearing religious symbols, etc. That's how you would generally be professing religion. And when you say you've got to propagate religion, you're essentially saying you have the right to encourage people to join your religion, but by law, if I remember correctly, the Stanislaus case, you do not have the right to convert anybody to your religion. Now, Article 26 gives you 4 rights under 26 A, B, C, D. Effectively, it means you have the right to establish and maintain religious institutions. You have the right to manage your own religious affairs. You have the right to movable and immovable property, and you have the right to administer property according to such law. So very interestingly, religion has the right to property. So religious institutions have a fundamental right to property, but everybody else in the country does not. That's the implication and the understanding of Article 26. If you actually read 25 and 26 together, the Supreme Court will intervene on what is an essential practice, what does propagate mean, how much can you establish and maintain, how much can the state regulate your institutions, what is the kind of acquisition that you can have. All of this will lead to what is called essential religious practices, which gets applied to cases like Sabrimala and now the recently in news Uniform Civil Code. Article 27 is extremely irrelevant for the prelims exam. It simply says that there's absolutely no tax that you have to pay if you are doing something which is a religiously promotional activity. In fact, the government for a long time had something called Hajj subsidy, and by a petition made by a member of the Islamic community, the government also withdrew the Hajj subsidy, because the principle was that if you have to go for Hajj, you've got to go for Hajj with your own money and not somebody's charity. Article 28 simply says there should be no religious instruction in fully funded state institutions. So this means that when we studied the Ramayana Mahabharata in our schools, that was essentially taught as moral philosophy, as literary philosophy, not as anything else. Articles 29 and 30, very, very interestingly, largely are two very different articles. Article 29 is for all citizens, but Article 30 is for citizens who are minorities. We've got the Minorities Commissions Act, we've got several laws which identify minorities. The latest minority to be added was, in fact, the Jain community. Now, what does Article 29 say? It effectively says two things. Minorities have the right to conserve their language, script, or culture. The best way to conserve language, script, or culture is to ensure it passes on from generation to generation. So, education becomes a very strong way to conserve. And the second part of Article 29 says there shall be no denial in state funded institutions on the basis of caste, religion, race, or language. It simply means that if the institution is funded by the state, then there should not be any discrimination on the basis of caste, religion, race, and language. Now, Article 30 speaks about if you are a religious or a linguistic minority, you can set up an educational institution if you feel like, and you have absolute freedom to do so. How can the state intervene will depend on state funding. We've got two remarkable judgments, TMFI, PA and Amdar, which get further accentuated by the Islamic Academy case, which is also why in correlation you have Articles 15.5 added to that corner. And there's a lovely triangle that gets built up because of Article 30 and Article 15 clause, Article 30, Article 19, 1 clause G, and of course Article 15. So anyway, that's not for the prelims exam. If you're an educational institution, education is a welfare commodity, so the state has the right to fund educational institutions. If the state funds educational institutions, the state cannot discriminate against your institution just because it's a minority institution. And depending on state funding, will there be state intervention, which is essentially the Aligarh Muslim University case. What you need to know are Articles 29 and 30 and nothing else apart from Articles 29 and 30. Now, quickly moving to the second last part, which is your writs. Now, we've seen two questions in writs very, very recently in the last 10 years. Let's get this absolutely right. There's a little bit of concept here. Let's get our basics of writs right. So, writs is a court order to uphold a right. Both the Supreme Court and the High Court can issue exactly the same kind of writs. There's absolutely no problem whatsoever. The Supreme Court and the High Court will issue the exact same writs. For what purposes do you issue these writs is a different question altogether. Now, if it is a fundamental right violation, then you can go to the Supreme Court or the High Court directly. But as we've discussed at the beginning of the lecture, if it's a constitutional right or a legal right violation, then in that case, you can directly only and only go to the High Court. So this means High Courts can directly issue writs for fundamental rights, constitutional rights, and legal rights. So this means the High Courts would effectively have wider powers because they can issue writs as the court of the first instance in a larger number of rights cases than the Supreme Court. What you must know is, going back to the core concept, judicial functions of higher judiciary is not state. And judgments of the higher judiciary therefore cannot be law under Article 13.2. For the same reason, writs cannot be issued against higher judiciary. Because if you're issuing a writ from a Supreme Court to a High Court, from a higher bench Supreme Court to lower bench Supreme Court, from High Court to Supreme Court, you're effectively telling them that they have violated a fundamental right. If they were to do that, then they would never be able to judge whether the right was actually violated or not. Very interestingly, without prejudice to the Supreme Court, this is categorically mentioned, the Parliament can confer the Supreme Court writ powers to any other authority or the court that the Parliament may effectively deem fit. And the Supreme Court Rules Order 38 has a list of things that you've got to do for petitions under 32. It also contains rules for public interest litigations. Now, when X is coming to a court, there has to be a locus standi, which means who are you to the case. And if the court is hearing your matter, the court should have jurisdiction. Fairly simple concepts. Now, there are 5 writs. Let's do them as far as the exam is concerned. You've got the writ of habeas corpus. The primary function of habeas corpus is what is called illegal detention. Now, if you have been illegally detained, you yourself can't come to court. And if illegal detention has happened, then the state has fundamentally failed you. So therefore, no court fees. Then you have something called the writ of mandamus. The writ of mandamus is simply to enforce any public individual, a government servant, a government body, a civil servant, anybody, to perform what is called a statutory duty. It even could be an inferior court, because an inferior court is not a constitutional court. An inferior court is effectively a court that does not look into the constitutionality of laws. So if an inferior court does not look into the constitutionality of laws, it means that the inferior court is going to commit the application of the law. So you can issue a writ in case the lower court is violating a right or not. So a mandamus is to enforce statutory duty to a public servant. Now, do you require locus standi for it? Yes. And mandamus is not applicable against a legislature or the executive for those functions for rule number 3, separation of powers. Now, why is this the case? You basically can't ask the Supreme Court to issue a writ of the mandamus to the legislature saying, hey, why don't you pass this law? You have a statutory duty to do so. Or you can't pass a writ against the executive and say, you know what, you have to make a delegated legislation, you've got to make rules to this law. That violates separation of powers. Now, certiorari and prohibition are deeply correlated, but let's understand the difference. The basic difference is certiorari is a wider writ than prohibition. Certiorari means you can have an error of jurisdiction. Very importantly, you can have an error of jurisdiction, not necessarily an error of law, which means what has basically happened is the court has exceeded their jurisdiction and delivered a judgment that they should have not delivered because they don't have the right to deliver that judgment. It could mean that you could be in jail for it, so your locus standi is relaxed. Basically, wrong court, wrong decision. Prohibition is the court is hearing the matter, and while hearing the matter, you figured out that the court does not have the powers to hear that matter. You could still be in custody because of it. So therefore, locus standi is relaxed. So the difference is wrong court, wrong decision, wrong court, pending decision. And finally, you've got the writ of quo warranto. As far as the writ of quo warranto is concerned, you're simply questioning whether a person has the right or is eligible to hold public office. It is not about whether the person is suitable to hold public office. It's about whether the person is legible to hold public office. So obviously, this could be done in public faith. So your locus standi is relaxed. The only condition is you should be holding office as far as it is concerned. And then finally, what we should be looking at is the doctrine of basic structure or harmonious construction. So let's start with this. The basic structure doctrine is correlated to the doctrine of harmonious construction. And as far as the prelims is concerned, the following points have to be paid attention to. First things first, the basic structure doctrine is based on the theory of implied powers, which means the theory of implied limitation. It means that the power to amend the constitution has to be curtailed because it is an essential instrument of something called constitutionalism. So what is it that we need to know as far as the prelims is concerned? We've had 2 questions from here in the last 10 years. 1, who was the Prime Minister during the 9th schedule? And 2, what is the 9th schedule most famous for? So what is the basic structure doctrine? The basic structure doctrine is a set of principles that are identified by the Supreme Court, and these principles cannot be violated by anyone, no matter what the case might be. So which means these principles are a part of the Constitution. So anything that violates any amendment to the Constitution that violates these principles is invalid. Not only does it apply to constitutional amendments, it also applies to ordinary law. And that was something which was discovered later by a Supreme Court judgment, which was called the Madras Bar Association case, I think of the early 2000s. Now, this also means all provisions of the Constitution can be amended as long as the basic principles of the Constitution or the basic principles of the basic structure doctrine are not violated. It also means, in the latest case of IR Coelho post Kesananda, that anything which is even in the 9th schedule can be amended, no matter when it was added to the 9th schedule, as long as it has not violated the basic principles doctrine. So you can add anything to the 9th schedule. You can challenging anything into the 9th schedule. You can challenge any law which is a part of the 9th schedule if that law is violating basic structure, no matter when the law was added. Now, judicial review, which basically means that what is violating basic structure or not has to be decided by the court, which is basically judicial review. Irrespective of basic structure, there are several instances where judicial review can be restricted. For example, the advice given by the President, by the Council of Ministers to the President is immune from judicial review. For example, the orders of the Delimitation Commission are immune from judicial review. The court has actually sometimes overturned a lot of these things. For example, in anti-defection law, the decision of the Speaker is immune from judicial review. But the court has overturned this in the Quixote Zolohan case, applied the basic structure doctrine, said judicial review is basic structure, and therefore said, you know what, you can't put restrictions like these. Now, the basic evolution is you added the 9th schedule through the First Amendment of 1951. And when you added the 9th schedule through the First Amendment of 1951, you basically did two very important things. One, you restricted the power of the courts to review any law which was in the 9th schedule, which is why it's most famous for curtailing judicial review. And two, you added an entire long list of reasonable restrictions to Article 19, Clause 1, Clause A. This was in response, of course, to the judgments pertaining to Champakam Dorairajan and Romesh Thapar versus State of Madras, where the Supreme Court had basically shot down a ban of a local publication. Now, correlated to basic structure is the harmonious construction doctrine. It means sometimes there's going to be a conflict between fundamental rights and directive principles. If that's the case, according to Minerva Mills, two directive principles under Articles 39B and C, which is basically prevention of concentration of wealth and distribution of resources, will override 14 and 19, equality and what do you call expression, if these are the only two objections. Previously, 31 was also a part of this, but the 44th Amendment of 1978 removed Article 31, which effectively said there was a fundamental right to property. So that's the case. Harmonious construction has two use cases. One is the conflict between fundamental rights and directive principles, and two is to solve center-state legislative incongruencies. So we are using it here in this context. This is absolutely more than enough as far as the exam is concerned. In the mains, this is one of my favorite topics, and I tend to spend some time with it in a very prolonged manner. Now, apart from this, the very last part, which is some basic factual additions to directive principles and duties, they have been asked previously, so we must keep them in account. So directive principles have been added through 4 amendments. It has been an original part of the Constitution. To the 42nd Amendment of 1976, there were essentially 4 things that were added. First, provisions for a healthy development of children under 38F, equal justice and free legal aid under 38A, participation of workers in the management of industries under 43A, and protection and improvement of environment and safeguarding of forests and wildlife under 48A. Now, this is under because we ratified the Stockholm Convention. The first 3 are socialistic measures because we are in the era of the emergency. The 44th Amendment of 1978 also added 38.2, which spoke of minimizing inequalities. 97th is the Cooperative Amendment, so it added cooperatives in 19.1c also, and it also added promotion of cooperatives under 43b. And the 86th Amendment, because originally 6 to 14 was in DPSPs, So we had to change it from 0 to 6. Otherwise, we'll have something optional and compulsory at the same time. So the 86th Amendment, which added 21A, also made a significant change to DPSPs. And fundamental duties were never a part of the original constitution. They were added through the 42nd Amendment of 1976. And through the 86th Amendment, you added an appeal to the parents to have opportunities for children between the ages of 6 to 14. In fact, the 86th Amendment is the only amendment in the history of this country which has amended fundamental rights, directive principles, and fundamental duties through the same amendment. So, this is theme number 5, lecture number 5, Preamble, Rights, Duties, and Directive Principles. To my mind, to my wisdom, I don't think anything more than this would be asked. Given the fact that we are in election year, given the fact that the questions are going to be fairly conceptual, so it is actually lecture 5 plus lecture 1 and 2 that actually become very, very important, where we've discussed things like constitutionalism, rule of law, etc., etc. So this is lecture 5, me signing off. Thank you for watching. I will see you for lecture number 6, which is effectively the legislature. Thank you. Bye bye.
Hello and welcome to lecture number 5A of topic number 5, which is with respect to equality in the context of our larger discussion on fundamental rights, directive principles, fundamental duties, and of course the preamble. Now, this is a lecture specifically focused on the mains, as we have previously covered whatever is relevant from articles 14 to 18 as far as the pre is concerned. We are now going to be focusing on, if at all there has to be a question in the mains exam, what can the question be and why can the question be asked in the manner it can be asked. So we'll understand that. Now, of course, articles 14 to 18 are important articles, but we will first begin by understanding how these articles or how questions from these areas have been previously asked in the mains exam. And for that, let us look at the previous year questions and then understand how much of it needs to really be prepared and to what extent. At the outset, I must tell you that the relevance of articles 14 to 18 in the mains exam is fairly low, especially when you contextualize it to the questions that have been asked in the previous years. So let us now look at the questions that have been asked in the mains exam. When we look at the mains exam and we start from a chronological sequence, we will see that there is absolutely no question which directly emanates from articles 14 in 2013, in 2014, in 2015. However, in 2015, one of the arguments, one of the legal constitutional arguments which could question the larger institutional recommendation of Uniform Civil Code could be Article 14, but it is not the principle, it is not the essence of the question that was asked in 2015 with respect to Uniform Civil Code. Similarly, in 2015 again, Article 14 can be one of the implications on understanding the right to environment and the judgment that was made with respect to banning of firecrackers. But again, it is not the primary theme. It's not the core essence of the question. It could again just be one of the points that has been asked in the mains exam. And that is something we must understand. Similarly, there is no question in 2016 which is related to Article 14 to Article 18. And in 2017, when there is a question on the right to privacy, while the primary articles that the right to privacy affects are 19 and 21, by an extension, by analysis, we could take it up to Article 14 as one of the implications. But again, it is one of the points. It is again not the core essence of what the mains exam has previously asked you as far as Articles 14 to 18 pertaining to the right to equality is concerned. If we look at the more previous years, the more recent previous years, there was no question in 2018. In 2019, again, there was no question specifically with respect to Article 14 and therefore can be left out. In 2020, again, there was no in interest or no overlap. In 2021, when we give some of the examples of the judgments where the doctrine of constitutional morality was referred to or was conceptualized or was relied upon by our esteemed judiciary, we could touch upon Article 14 as one of the implications of constitutional morality. But again, it is not the essence of it. It is only and only in 21 where we see a question specifically from the notions of equality, and this gets sort of combined with comparative constitutional law, which is comparing the constitutional scheme of India with that of the rest of the world. The question was, analyze the distinguishing features of the notion of equality in the constitutions of US and India. It was a rather difficult question because it was surprising and most people were not able to predict it or were not able to write enough of it. But this question was essentially to compare how the ideas of equality, whether it is about formal equality, substantive equality, affirmative action, these are the three notions of equality and how they are compared between the Indian Constitution and the US Constitution. Now, the reason the Constitution of the US was taken as the comparison point is because the idea of equality specifically has been taken from the US Constitution. It is one of the oldest constitutions dating back to 1776 when the country became independent, and the early 1800s when the Constitution was adopted. So that is why equality was compared between US and India. Now, this gives us a very important insight. The insight that it gives us is that now for the next few years, till 23, till 24, we must not expect a question specifically focused on equality and the principles or the doctrines originating out of equality. We will understand them in a bare minimum requirement, but nothing more than that. Now, in 2022 and 2023, in 2022, there was a question with respect to the constitutionalization of environmental problems, which primarily from a fundamental rights perspective deals with Article 21. You could extend some of the arguments to Article 14, but again, it would not be one of the primary points. So even if you don't write it, you will not lose any marks. And 2022 was specifically with respect to Article 19. So from a mains point of view, we understand that from Articles 14 to 18, there have been negligible questions, and these questions have dominantly come from a comparative constitutional basis. Now, a fundamental question must arise in your minds, and that is, why is Articles 14 to 18 not particularly asked in the exam? There is a reason behind it. Because Article 14, very particularly, specifically, which deals with the substantive right to equality, gets attached to a lot of issues in Articles 19 and 21. Article 14 becomes a carry-on fundamental right, an additional argument of a fundamental right violation. The issues would largely be questions of Articles 19 or 21, and we will add Article 14 as one of the additional violations to the primary violations of Articles 14 and 19, and to Articles 19 and 21, which is why it becomes very, very limited in its approach. And this is one of the reasons why there isn't a lot of questions in the mains exam from articles 14 to 18. Now, specifically, if you now look at the composition of the articles from articles 14, 15, 16, 17, and 18, you will see that it is actually Article 14 which has a complex and a jurisprudential legal value. The principles of equality originate from Article 14, and Article 14 gives birth to the larger discussions of reservation through Articles 15 and 16. Now, what usually ends up happening is Articles 15 and 16 allow you a certain degree of special provisions that can be made. And Articles 15 and 16 specifically deal with equality by non-discrimination. And they also deal with reservation in education and employment, respectively. 15 deals with education reservation and 16 deals with employment reservation. And Article 17 and 18, which deal with abolition of untouchability and titles. Abolition of titles has no contemporary relevance whatsoever. And abolition of untouchability is a larger problem of vulnerable sections, or is a larger problem in your social issues syllabus. And therefore, it becomes one of the contextual legal provision. But nothing substantive sort of comes out of it. It is for these reasons that Article 14 plays a very, very limited role, or Article 14 to 18 pertaining to equality play a very, very limited role. Which then brings us to the million-dollar question. Almost every year, in some form or another, we see developments in the arena of reservation. But when we see the previous year questions, we understand that not even once has reservation been asked in any form in the mains exam. Your opinion is never specifically sought. Now you must understand, the UPSC will never ask you whether reservation is a good policy or a bad policy. Because by asking you that reservation is a good policy or a bad policy, the exam is in itself creating a bias, because your opinion on whether reservation is a good policy or a bad policy would depend on whether you get benefits out of it. And the examiner's opinion on whether reservation is a good policy or bad policy would also depend on the examiner's background. Thirdly, if the UPSC gives a formal assessment key to the examiners and says this should be the opinion, that itself would create a bias in a rather opinionated question. In your essays, in your social issues, social justice questions, even in ethics, you will have a relatively higher utility of reservation. But in paper 2 specifically, your questions on reservation are going to be extremely limited. Now, having said that, we must still study a little bit of reservation. We must still understand the basics of it without getting into a lot of technical or legal complications. So we will spend a few lectures figuring out reservations as it is and some of the additional doctrines that come attached with it. And on the basis of this, when we decide to draw a circumference that these are the only topics that we are going to be preparing out of articles 14 to 18, these topics therefore become the following, and they have to be done in the right amount of detail. So as a result of it, when we're picking up topic number 5, equality, which of course is relevant for prelims, but is also relevant from a comparative constitutional law because it has been asked before and therefore will not be asked again, but is an essential feature of the Constitution. We therefore prepare the following 3 things as far as mains and equality is concerned. We will do a very simple overview of reservation policy. We will understand who are getting these reservations. Where are you getting the reservation policy in? Where can you be using these reservations? How are these being implemented? and why are these reservation policies being given. And this much is enough as far as reservation is concerned. The mains exam will not ask you to analyze a specific judgment, nor will they ask you to analyze a specific constitutional amendment, nor will they ask you to analyze specifically a precise reservation policy. But reservation is an instrument of social justice, social issues, ethics, fundamental rights, and therefore we will study it in the right manner. Apart from this, there are two very important doctrines that come out of here. Now, these are they're very complex doctrines from a legal standpoint. If this was a law optional class, I would have spent at least 2 hours on each of these doctrines. But because this is a general studies class, all you need to understand is what these doctrines mean in 1 or 2 lines so that you can quote them in the mains exam for a lot of other issues that may be based on these doctrines, right? So these are called the doctrine of intelligible differentia and the doctrine of rational nexus. You don't need to know the judgments that have used this or conceptualized this or have relied on it, nor do you need to know the specific developments in case law or the international jurisprudence on it. All you need to know are the meanings of both of these doctrines, because the meanings of both of these doctrines also have an implication on the reservation policy. So let's understand this. We are talking about intelligible differentia and rational nexus. These are two legal doctrines. Let us understand what it is. See, this is nothing but means and ends. Intelligible differentia says that if you are creating a classification, if you are creating a positive form of discrimination, if you want to provide some form of affirmative action to a certain set of people, right? Any of those. You're saying that you cannot discriminate on X, but you can discriminate on Y or a combination of Y plus X, whatever it might be. Because this is what is largely seen in Articles 15 and 16, if you remember the earlier classes, where we had spoken about on any of them or all of them or either of them. So these are the terms that hint to something called intelligible differentia. The idea behind intelligible differentia is that if you are creating a special class, if you are promoting a special class, you are creating a positive exception for a special class, it should be done for the right reasons, it should be justified, it should be reasonable, and you should be able to clearly separate them. So the basic ingredients are that they should be clearly distinguishable. This is important, that it is not something that can be homogeneous in nature. When you're saying that special provisions for women can be created, it's a very distinct identity that we're talking about. Second, there is an inherent degree of it being reasonable in itself. And there is something called the doctrine of reasonableness also, which is a part of your law optional syllabus, but it is not a part of your general studies syllabus. Third, it should not be arbitrary. You've decided it on the basis of something. There is a rational thought. There is a very objective evaluation on the basis of why you've done it. And it is, of course, finally fair. So these are the 4 criteria on which you can create certain special class or classes of people. Now that becomes the means to achieve what? The ends. And the ends are mentioned in something called rational nexus, that you're creating a special class. Let us say you are saying special provisions for women. It's because you want women to advance at the same platform and get the same opportunity as the other gender, which is the male gender. So the reason why you're doing it, the objective is very clear, that you wanted to create equality of opportunity. And for that, you needed to give some special benefits to women, for example. This means two things. One, that they both are related to each other, and there is a likelihood that by doing this, you will be able to achieve the objective for which you've created the intelligible differentia. This is all that you need to know as far as the doctrine is concerned. Anything else beyond this is not relevant for your exam. You don't need to know the judgment, you don't need to know any legal author, you don't need to know any commentary. But to begin with, you need to know all of those things. Now, in each of the four lectures, 5A, 5B, 5C, and 5D, we're going to cover specifically four parts: for who, where, how are we giving it, and why are we giving it. The last part becomes a cost-benefit analysis as to are we truly achieving the purpose as to why we wanted it to do so, right? So now let us begin with who are we giving reservation to. We'll then come to where all are we giving them reservation, and then so on and so forth. To begin with, let us start with some context. It is often misunderstood that reservation is a post-independence phenomena. That's actually not the case. Reservation in a different form has been a part of the Indian ecosystem before we became independent also. In fact, in the year 1933, the British Prime Minister at that time, Ramsay MacDonald, had presented an idea called the Communal Award. Now you can understand why this was problematic, because the Communal Award was primarily based on giving special provisions on the basis of religion. And that is why the Communal Award, which was proposed by Ramsay MacDonald, was severely opposed by Gandhi. But interestingly, Dr. B.R. Ambedkar was in a primacy sort of a support for it, because people who came from certain religions were fundamentally disadvantaged in society. It is usually because of this that the larger discussion had happened. Now, even before, say, the proper advent of British rule, even if I jog your memory a little bit before that, and this is just to give a pre-context to the context, is that in the year 1882, you may have heard of somebody called Jyoti Rao Phule. Now, William Hunter and Jyoti Rao Phule had collectively come up with the idea of something called caste-based reservation, which then thereafter translated into the Pune Act, which then led to the 1993 Communal Award. And that has been the end of it as far as the British era is concerned. After we became independent, the Constituent Assembly, whose drafting committee was chaired by B.R. Ambedkar, had largely framed the larger policies that enable reservation in the country. And that is largely how it worked. Now, to introduce the idea of reservation, there are fewer debates that have instigated more passion in this country than the debates on reservation. See, alongside land redistribution and judicial independence, these have been the two other major pillars of national debate. It is reservation policies which have also seen a a very high degree of a tussle between the court and the government, or the court and the legislature. The legislature would pass an amendment, the court would interpret it or strike it down. Then the legislature would pass another amendment which would counter the judgment of the court. So this kind of a to and fro between the courts and the legislatures have also been present in reservation. It has been present in three major pillars in this country. One, of course, has been with judicial independence, leading to tribunals. The second has been with respect to land reform, which led to the basic structure. And third is, of course, been with reservation policies. Now, these disputes can often be veering or could be hinged on two very extreme points. Now, what usually happens is these either invoke very abstract ideals, very abstract ideals, and sometimes they have a more compassionate stand. Now, as we understand, that as UPSC aspirants, as students of polity, we must be very careful, and we should prevent ourselves and safeguard ourselves from getting into a larger narrative around reservation. And no doubt, reservation policies are a part of day-to-day debate, and all of us are going to have an opinion or in the process of having an opinion on it. But we must look at it essentially from a very objective point of view. And that is why we do it in four phases. One is who gets reservation. Two, where do these reservation policies extend to? Third, how are they practically implemented? And why are they required in the first place? And it is on the basis of this that we will now understand our first segment, who gets reservation in our country. Now, the Constitution of India recognizes four main beneficiary groups of reservation policy: the scheduled castes, the scheduled tribes, the other backward classes, and most recently, the economic weaker sections, or the EWS. Now, this is the most recent, followed by this, and scheduled castes and scheduled tribes are the earliest or the oldest. They were introduced in the first line of amendments, then OBCs, and then, of course, economically weaker sections. So now let us understand who are scheduled castes and scheduled tribes, what is the difference between them, and why are we referring to them. I'm going to keep it very simple, keep it very basic, so that it is easy for us to understand, right? So, when we talk about scheduled castes and scheduled tribes, and this is the important part, the original beneficiaries, the first set of people who were identified to get reservation under the Constitution, are actually scheduled castes and scheduled tribes. Now, the term scheduled castes was first mentioned in the Government of India Act of 1935. And there were actually benefits which were being provided by the British government in some form. And in fact, some of the princely states also used to give some benefits on the basis of certain caste provisions. But when we look at post-independent India, where the Constitution has been formed, there are actually a total of 12 different places where we will see the words scheduled castes and sort of scheduled tribes being mentioned very clearly, very explicitly. And as and when we come to the relevant parts, we'll keep referring to these articles. So we have articles 15 and 16 in fundamental rights, 46 in directive principles. Then we have articles 164, 330, 332, 334, 35, 38, 341, and 342, finally closing with 366. These are the primary areas where in the Constitution, you will see the words scheduled castes and scheduled tribes are mentioned. Now, all of this is about numbers. And how do you identify that these are the total number of scheduled castes, scheduled tribes, OBCs, or whoever in the country? And the official enumeration of this is done through the census, which is why, if you remember, census has a very detailed questionnaire where the census agents ask you this in a house-to-house survey. So usually the census is conducted under a law called the Census of India Act. And a part of the census exercise is to conduct a house-to-house survey, and it usually has a detailed questionnaire. The last census in 2011 had about 29 such questions. One of them was, of course, also caste or income or profession and so on and so forth. So therefore, the census becomes the primary data set to figure out how many people in India out of the total share are actually belonging to a specific caste. Now, we will of course understand the exact numbers in just a while, but the idea here is the constitution gives the power to the president to decide or to define who are scheduled castes and scheduled tribes. Now, this power which is given to the president is actually the power which is given to Council of Ministers, and the advice of the Council of Ministers is constitutionally binding on the president. So it's not that the president has a discretion over it. The president is compulsorily bound by the advice given by the Council of Ministers to define which caste is going to be a scheduled caste or not, or scheduled tribe or not. And the Supreme Court, in a 2007 judgment called the Shri Surat Valsad Jida KMG Parishad versus Union of India. Now, this can be a complicated judgment for you to remember. You can simply remember the KMG Parishad versus the Union of India judgment very clearly said that the Supreme Court has very clearly established that the power of the president, effectively the power of the government, to define who is a scheduled caste or a scheduled tribe is not subject to judicial review. Now, this is not the case with other backward classes. That is where it becomes slightly different, which is why in the Maratha reservation case, which is not at all important, this became an issue because there the law was not very clear. Here, the Supreme Court has categorically laid down in these explicit terms that the court cannot get into who has been defined as a scheduled caste or not, because it would infringe a constitutional doctrine of separation of powers, right? Now, how has it been used is that the central government or the president has used this power to keep on adding more and more castes to this list. There have been almost negligible cases where a caste has been removed from being a scheduled caste or a scheduled tribe, and that's something that we must understand. And see, the Constitution and the Supreme Court cases, without a shadow of doubt, in very, very clear, unquestionable terms, they recognize scheduled castes and scheduled tribes as a defined legal category. And they also have a distinct social identity, which is why you will not see a lot of controversies around who's a scheduled caste and who's a scheduled tribe. This becomes a matter of debate in the other backward classes segment, because other backward classes may not necessarily have a distinct legal identity, right? But with scheduled castes and scheduled tribes, it is uniform, it is legal, it is precise, and we will understand why that is the case. And now we must look at the primary differences between scheduled castes and scheduled tribes. See, the scheduled castes are about 16.6% of India's population as per the 2011 census. We've not had a census beyond that because of the pandemic. And this include 1,206 main castes that were considered untouchable within the stratified Hindu caste system. This is very important. The idea of scheduled caste originates from Hindu caste structures, from the Hindu social structures, and also has a mythological connotation to it. For example, the Hindu god Brahma has been depicted as a hierarchical system wherein the Brahmins come from the head, the Kshatriyas come from the shoulders, the Vaishyas come from the thighs, and the Shudras come from the feet of Lord Brahma. So Hinduism has played a very strong role in identifying who is a scheduled caste or not, because it's largely endemic to the Hindu religion. So that is why we often look at the Hindu caste system, right? And these castes have at different points in history been called very different things. Like, for example, some of them have been called depressed classes or Harijans, but the modern day, the contemporary word that we use nowadays is, of course, Dalits. Now, it unfortunately is something which is a matter of great abuse. There are several instances of caste abuse, and we'll come to that when the time is right. But this is the larger ecosystem that works in totality in consonants. Now, as I was mentioning before, scheduled caste is a legal category of reservation beneficiaries. And only those Dalits, which are Hindu, Sikh, or Neo-Buddhists, are considered scheduled castes. Hindus, Sikh, or Buddhists are considered scheduled castes. Very rarely would you see some Jain communities also considered the same, but that's rarely ever, never the case. It's largely three basic religions. Christians and Muslim Dalits do not qualify under scheduled castes. You will see a few, very, very few Muslim sort of castes or subcastes looking at an ST status. But as a matter of law, Muslim communities are not given a scheduled caste status. Now, whether this is right or wrong, and why have you excluded Christians and Muslims? Do they not have socially ostracized classes? I'm sure they do. But the Supreme Court has not given clarity on it yet. And why have we done this is, of course, a matter of challenge. And let us see what time has for us in the future as far as this is concerned. Now, scheduled tribes, on the other hand, consist of about a 700 plus tribes, and they constitute about 8.6% of the population, again, as per the 2011 census. Now, there are no clear defined terms, and there are several Supreme Court judgments. Some call them Adivasis, some call them Girijans, and they will largely be present in the central, southern, and the northeastern part of the country. In lesser numbers, you would find them elsewhere, but you would largely find them in the northeastern, central, and the southern part of the country. And a fundamental difference is, while there is a religion-based layer to scheduled castes, scheduled tribes can be from any religion, a Muslim, a Christian, or anybody for that matter. And that's what makes scheduled castes, in their own way, slightly more inclusive, because any religious community can therefore be a scheduled caste. Right. Now that we've understood this, we should now understand who are other backward classes. Simply, who are. Now, the most amount of controversy will, of course, come with other backward classes. Now, see, the SCs and the STs, the scheduled castes and scheduled tribes, were originally thought as backward classes. And that is why the third group is referred to as other backward classes, or OBCs. Now, unlike scheduled castes and scheduled tribes, other backward classes are not a distinct social group. It could be across different stratas, different castes, different occupations, different sort of identities. To put it very simply, a simple way to sort of think this is that they are sort of middle castes with mainly a Hindu religion, who are in between upper castes and scheduled castes. So OBCs are somewhere of a midpoint between scheduled castes and upper castes, which is why they have a very, very unique position in the social structure of this country. Now, when we look at the data around it, some of these castes are in numbers very large, and they may also be controlling some agricultural land. And therefore, some of these large castes can also have a little bit of political dominance. which is why you will see some of the movements that happen, which gain a lot of political traction, originate from OBC communities. But one thing is absolutely sure as a matter of fact, that they are absolutely underrepresented in higher education and also professions, which is why there is a legitimate need to give them a degree of reservation. However, in terms of where they are and what is the percentage or what is the number, that becomes a little bit of a confusion. That becomes a little bit of a difficult understanding. Because when we look at one estimate, a specific estimate, this was done by the National Commission of Minorities and also co-authored by the Central Ministry on Social Justice and Empowerment. They constitute about 52% of the Indian population. But the problem is that several sociologists, several cultural experts have argued that they consist of socially or economically heterogeneous castes, which means they could transcend from one caste, move into the other. There could be an economic angle, there could be a professional limitation angle, and so on and so forth. Right? Now, we should not get into all of this, largely because this is an element of caste. This is an element of social structure, and we are not studying sociology. We are students of the law. And as students of the law, we must be looking at very specifically 4 constitutional questions around OBCs. The first is, we don't have a universal name. How scheduled castes are scheduled castes everywhere. OBCs have different names in different parts of the constitution. Secondly, scheduled castes and scheduled tribes are uniform throughout the country. But when it comes to OBCs, there is a different list. There's a different set of castes that the center recognizes as OBC. There's a different set of castes that the state recognizes as OBC. So there is a little bit of a clarity that is required. Third, there is a massive debate that if you're looking at caste, why is caste the primary criteria of defining who's an OBC? Right, which is why later on you will see the non-cream layer being attached, and we'll come to that. And fourth, when we actually look at the empirical data on the number of people or the number of castes, what is it that we come to? What is the clarity that we're looking at? So therefore, from a constitutional point of view, these are our primary questions that we must be looking at, and we should look at them one by one. Our first question is, that why are they called different names in different places, and let's understand what are they. See, for example, Article 15 Clause 4. Article 15 Clause 4 refers to provisions for socially and educationally backward classes. If I show you the constitution here itself, this is Article 15 Clause 4. You will see advancement of socially and educationally backward classes of citizens. But when we look at Article 16 Clause 4, they use a completely different term. They use a term called backward classes of citizens, right? Now, this is the starting point of confusion, because law is nothing if it is not precise. Now, there have been some cases in which the courts have said, for example, in the Janki Prasad versus Jammu and Kashmir judgment, the Supreme Court very clearly said that this difference between socially educational backward classes or OBC, they are more or less the same, or even backward classes, they are more or less the same. While there have been a lot of other judgments, and a primary judgment called the Indira Sawhney judgment, which becomes one of the most landmark judgments. It's also called the Mandal Commission case, which we will understand a little later. But judgments like the Indira Sawhney case have very clearly stressed that, see, Article 15 Clause 4 specifically refers to educational backwardness, while Article 16.4 is only concerned with social backwardness, as the highlighted portion suggests. So there must be a difference in its implementation. There have also been some legal experts such as Didi Basu, MP Jain, Pratap Bhanu, the HMCY, sorry, all of them have also, some of them have also argued that a backward class under Article 15 could also be a numerical majority. There would be more in number. But Article 16, when you want people to be given reservation for employment, the fundamental reason is that there must be lesser representation. There must be inadequate representation. So while Article 15 could be that there are so many people and they have not been able to get into college, so we need to give them reservation. But the purpose of Article 16 is that there aren't enough people in government services who come from a certain section, so they must be given representation. So the purpose can also be looked at it from a different point of view. But our beloved government looks at it in a rather lenient manner, looks at it in a rather overarching manner. And the government has usually treated most of these phrases in almost the same way, and has therefore evolved what is called a very simple and a single criteria for backward classes. So that is why when we look at implementing it, socio-economic backward classes, OBC or backward classes in terms of reservation policies are exactly the same. They're interchangeable. You can use whatever name you write, like there is no problem at all. There are no questions to it. So this is why this happens. And I also told you how it is used differently across different provisions of the Constitution. Now that we understand this, we should now understand why specifically in OBCs, you will see different OBC central government lists and you will see different OBC state government lists. And this often causes a lot of confusion amongst the people in the country as well. So let's understand this. See, unlike scheduled castes and scheduled tribes, the union and state governments define OBC differently. A person who is an SC for central government institutions and central government employment as well as state. A person is a scheduled caste throughout the length and breadth of the country, no matter what state the person goes to, no matter where the person is. But that's not the case with other backward classes. What happens with other backward classes is there is a central OBC list. There is also a state OBC list. The central OBC list will have certain castes and the state OBC lists will have certain castes. Some of the castes can also be common, but they can also be different. This is also true when we look at EWS. There can be a different EWS criteria for central employment. There can be a different EWS criteria for state employment. Sometimes it can be the same also. That freedom is there because the Constitution is open-ended on that front. Anyways, so the union list, to which sort of the OBC phrase is typically referring to, will apply to largely union employment and education, central government employment and central government education. Whereas when we look at other backward classes, right, when we're looking at, say, other backward classes for the states, they can also be defined by the states for the purposes of reservations in state education and employment. Now comes the interesting part. There are several examples where there are several caste groups which are backward class in one state, but are not in another state, or nor according to the union government. These permutation combinations, these lists can also be drawn up at different times. There is no compulsion in this. In fact, there have been several initiatives that have been taken by several governments also. For example, southern states such as Tamil Nadu actually had originally pushed for state backward class reservation in their own states in the 1950s. India's first ever reservation case, the Champakkam Dorairajan case, which is also the starting point of understanding the conflict between fundamental rights and directive principles, is India's first reservation case where the Supreme Court strikes that policy down and the government then enacts the First Amendment, through which we add some specific details, which we will talk about later. But this is largely the purpose of it. So you will see states adding their own layers. But Finally, we found some degree of concretization in 1991, that the reservations were sort of um, uh, implemented in other backward classes, were also being implemented in the state government. What was basically happening was, before 1991, it was only through state governments OBC existed. So before 1991, you would have a sort of OBC reservation only at the level of different states as per different state laws. But post 1991, which is the Mandal Commission, we saw OBC to be applied to central government as well. That is the key taking out of this entire discussion. And the courts have time and again held, again through a landmark judgment such as the Indra Sawhney case of 1992, where the union and the state governments are free to revise these lists, and they should be revised. But in practice, in a sense, they don't get revised very often. They don't get revised as frequently as they should be. So the basic history is, we start with SC/ST reservation in the 1950s. Until 1991, we may have a few instances of OBC reservation in the states. Then in 1991, we have SC/ST and OBC reservation, both at center and the states. In 1950s, we had OBC reservation for center and states both. Then the Indra Sawhney judgment comes in. There are a few conditions that are attached. Then later on, we look at the quantum of reservation. Then we look at whether reservation should be given in promotions or not. And then we finally add a new layer called EWS through a constitutional amendment in 2019. This is the general timeline, but the timeline is not really important as far as the exam is concerned. Anyway, we now look at the third constitutional nuance, or the third constitutional question with respect to OBCs. That is it right to keep caste as the sole definition of what is an OBC? Because this is where the judiciary steps in and tries to give a very, very clear and a very, very nuanced understanding of what it is. Because this is one of the most critical parts of who is an OBC and who is not. See, today, the law is very clear that the union and the state governments have defined backward classes solely on the basis of caste. But why is that the case? Technically, you could look at reasons beyond caste as well. See, the constitution nowhere says it has to be done on the basis of caste. But the larger legal question is, has the constitution sort of enabled that it should be done on the basis of caste? Has the constitution sort of given a little bit of a hint that it should be done on the basis of caste? Does the constitution steer you on the basis of on caste being the basis of it? Right now, of course, ultimately, the Supreme Court has said that if caste is the criteria on which you're deciding OBCs, that is constitutional. There is no problem. But there has been a massive amount of judicial confusion because Supreme Court judges have looked at it from a different point of view. They've tried to come up with, we understand caste is important to define OBCs, but how important is caste to define OBCs has been a process of judicial evolution itself. And I look at it from 3 points of view: that A, caste is relevant; B, caste is the only criteria; C, caste is the dominant criteria. So the current idea is dominate, but we start from relevant, and anything more than this again is not relevant for your exam. So the relevancy factor was looked at in the MR Balaji case. The case also again is not important for your exam because it's an old case. So in the MR Balaji case, it was held that caste should not be the sole or the dominant criteria. It should just be a relevant factor. It should never be the primary reason why you would want to do it. It should be a contextual reason, a tangential reason, a parallel reason. Okay. Now, this was largely because social backwardness is ultimately an outcome of poverty. And if this judicial standard had to be followed, if M.R. Balaji's case had to be followed, then what would happen is almost all other reservation policies would be invalidated eventually, because then you would only look at economic as a criteria, which is why we looked at a second Supreme Court judgment, the N.M. Thomas case. The N.M. Thomas case is very, very important because it looks at several elements of reservation. So what happens in the N.M. Thomas case? In this case, the majority of the Supreme Court very clearly said that caste should be the only criteria for identifying a backward class. Now, that in itself is not particularly wise, because there could be other reasons fueled by caste, influenced by caste, or parallel to caste that may cause a degree of backwardness. And which is why, through the Indra Sawhney case, originally 1992, and then much later in the Ashok Kumar Thakur case, the principle of dominancy was evolved. That while caste cannot be the sole criteria, it can therefore be used as a dominant criteria. It could be one of the major reasons, but it cannot be the only reason for you wanting to give OBC reservation. Which is why, on the basis of this, we add the non-creamy layer to OBC eventually, because we follow the dominancy theory which was laid down by the court in this, right? Now that we understand this, you must understand, since Indira Gandhi, it has been the most important judgment on reservation. Now, over a period of time, there are going to be revisions, revisitations. Even the EWS case that we will talk about will eventually be based on certain decisions that were taken by Indira Gandhi, and we'll come to that eventually. But this is the larger discussion. This is the larger process around it. Now we look at the fourth criteria, the fourth constitutional nuance. The fourth constitutional nuance is that how do we know that we have the right number of people who are other backward classes? That is a major point of conflict. Let's understand this. See, the actual state of backwardness, their numerical percentage, needs to be very clearly empirically identified. And the Constitution allows, through a constitutional article, allows the central government to appoint commissions to investigate the conditions of backward classes. And in our history, there have been two major commissions that have been appointed, the Kelkar Commission and the far more important one, the Mandal Commission. But neither the Kelkar nor the Mandal Commission were able to gather any new data on the number and the socio-economic conditions of OBCs. In fact, the Mandal Commission, which is the primary base of everything OBC, is actually based on the 1931 census, a fact which is commonly not known to most people. And the fact that they've used the 1931 census as the base factor has also drawn a lot of heavy criticism, because you could have looked at earlier census records. Now, the people who counter this argument that no, it is fine, they will often say that even if you say that the OBC percentage is not 52%, because the Mandal Commission was then also accepted by the government Ministry of Social Welfare also. Even if you say that let's understand that, okay, OBC population is not 52%. The Mandal Commission eventually recommended 27% reservation for OBCs. Even if you use the most recent census, it will not be less than 27%. And that has been the final recommendation of the Mandal Commission. So therefore, the extent of the OBC quota today is about 27%. And we've discussed about 16 and 8% there as far as your SCs and STs are concerned. Now, there was a little bit of an attempt in the early 2000s, in sort of early mid 2000s, where you wanted to collect more data And this was in response to the union government, which made an amendment to the constitution where they wanted to give reservation in higher education institutions also, or in higher education institutions which were owned by the government. And of course, this was a major issue. Now, this was, of course, challenged. And then the Supreme Court, in this particular instance, in this particular case, noted that no doubt you need better data on whether you need to give reservation in central government owned universities and colleges, and the data must be made better, must be made more representative, must be made more accurate. But there is no denying that there must be reservation. So in principle, allowing for reservation in higher education was principally allowed. Now, see, generally what happens is the Supreme Court, for most purposes, says get more data to prove your point. But in principle, the policy sounds about right. The one of the few times the Supreme Court raises an objection on data is when we look at promotions in reservation policy, which we will understand a little later. Now, a recent sort of an exception where, despite poor data, uh, and the Supreme Court sort of did not agree to a reservation policy, was with the OBC reservation for Jats. Now, the Jat community, as we would understand it to be, are a socially and a politically, might not necessarily be educationally. They're a landed caste in northern India. They may also be politically powerful. They also may have a little bit of might, but they were underrepresented educationally. So, in 2014, this is also around election year, the central government, in the face of massive political lobbying, protests, movements, they agreed to notify Jats as other backward classes in 9 states. And the National Commission for Backward Classes had very clearly said that that was not the reason, and they should not do it. And therefore, in the judgment of Ram Singh, which is not a judgment that is important for you, but in the 2015 Ram Singh judgment, the Supreme Court actually struck down the policy, and Jats no longer get OBC status in central government jobs. State government, well, it depends on states to say states, and of course they do. And therefore, the Supreme Court relied on the NCBC recommendations and said, boss, it was very good for the NCBC to recommend that if you don't have enough data, then extending a reservation policy could fundamentally be problematic. And it was acceptable for NCBC to say what it should. Now, the whole idea of other backward classes can go beyond the notions of caste. And through Indra Sawhney, through a lot of other judgments, the court has always said, we understand that reservation is necessary, but it should be done for the right reasons, for the right people. Which is why when we look at the Nalsa judgment of the Supreme Court, which recognizes transgenders as the third gender, the Supreme Court also recommends and informs the Parliament that the Supreme Court wants the Parliament to add transgenders to the OBC list. The Parliament has not done yet. We've had a national transgender law. We provided all sorts of protections and rehabilitation benefits, but we haven't given them OBC reservation as the Supreme Court wanted to in the Nalsa judgment. So the idea is that we should look at expanding what could be a cause of backwardness, and we could look at caste, and we could certainly go above and beyond it. And that's the positive way to look at it. Now, see, ultimately, a reservation is a scheme, and there are beneficiaries. SC/ST reservation has to be backed by law. So it's a scheme which is backed by law. OBC reservation has to be backed by law, but EWS reservation does not have to necessarily be backed by law. It could be done. It could be done through an order. Now, identifying beneficiaries is very important. It is important in governance. It is important in polity. It is important everywhere else. So how do we make sure that the right people are getting reservation benefits? And for that, there are some targeting techniques that the government has, which sometimes they use well, sometimes they don't. One of them, of course, is list revision. Second is adding creamy layer. And the third is caste within caste or sub-quotas. So let's understand what are we talking about. So as we understood that the 2011 census said that there are about 1,200 scheduled castes, 700 scheduled tribes, and together they're about 25.2% of the Indian population. Now, if there are so many people, let us say, who are scheduled castes, there'll be a few who are more prosperous than the other. There'll be a few who are more backward than the other. Now, depending on numbers, depending on population, depending on so many factors, how do we know that the person who's the least affected is actually getting the benefit out of reservation, right? This wide range of groups that we're talking about, these individuals that we're talking about, this would mean some are less backward than the other and some are more backward than the other. This could be because of income, education, land, representation in public life, or even social status. And what happens as a result of this is that some castes are a little wealthy within each caste, and therefore they get more benefits, and they're disproportionately doing better than the other castes, other people of the same caste. And there have been a few empirical studies, statistical studies, which have confirmed this phenomena. So whether there is somebody who supports reservation or there is somebody who is against reservation, they fundamentally agree that this is a legitimate concern, that the right people are not getting reservation benefits. They will disagree on how can we make this right? How do we solve the problem of making sure that the disadvantage of the disadvantaged are able to take the benefits of reservation? And there are largely three sort of solutions that are given. One is to reclassify or declassify the castes. If the caste has been doing well, the person should not be, their caste should not be considered a scheduled caste or a scheduled tribe. That is one of the primary ways to go about it. So that's number one. Number two is, if people are financially well off, then you could add a creamy layer component to it. The third is, you could create a reservation within a reservation. So for example, there is an SC quota. Within the SC quota, there could be a few castes which get a higher representation percentage and a few castes that get a lower representation percentage. All SC castes should not get equal access to the SC quota. Some should be given more, some should be given less, is another way of going about it. So let's understand each of these in just about 2 minutes each so that we get a basic sense of it. What we are referring to is called list revision. This is the simplest technique, that you should remove those castes or tribes that have disproportionately benefited from scheduled caste, scheduled tribe, or OBC lists. And there are several Supreme Court judgments, including Indra Swamy, that have spoken about this. But what actually happens in practice is there are very few, almost negligible, that have actually been removed from the list, because this has now become a politically very, very sensitive issue. In fact, forget about removing, more castes and more tribes have been added to these lists. Now, of course, the Supreme Court generally hasn't questioned this policy, and it is also not particularly very aggressively challenged in politics. But you will see that caste or tribe groups that are actually already benefiting from these quotas are now fearing that if there are more people who are added, or if they're not given the right amount of proportional benefit, then it is a disadvantage to them. And over the coming years, this is only going to intensify. This is only going to get worse, which is why it becomes important for us to understand it in the right manner for the right reasons. So that's number one. Number two is, if you could create a caste within a caste, or a quota within quotas. So all castes are not to be given equal share in the scheduled caste quota. If the scheduled caste quota is say X percentage, then some castes who are scheduled castes should have a higher percentage of that scheduled caste quota, basically a quota within quota. Now, to ensure that, now the Supreme Court in these exact words, and I'm quoting the Supreme Court judgment here, it's again Indra Sawhney, that one or two classes, quote unquote, do not eat up the entire quota, leaving the other backward classes high and dry. The thing is, in the Supreme Court judgment of Chinaya versus State of Andhra Pradesh, Supreme Court has very clearly held neither the state nor the court can subclassify within the SCs and the STs. No, you can't do that. However, especially in Indra Sawhney, the Supreme Court made it very clear that it has not only permitted it, it's also encouraged, it has also sort of promoted that you must have some form of subclassification in OBCs on the basis of social backwardness. The government has not done it at a national scale, at a union government scale, but it is legally allowed. If the government wants, they can do it. Now, several sort of state governments, such as Andhra Pradesh and Tamil Nadu, have actually started to do this. They do have a quota within a quota sort of a concept. And politically also, the demand for subclassification has really shot up. The demand for enhancing all of this has really shot up. Now, what ends up happening is this demand for having subclassifications or sub-rationalizations is actually justified. It is justified because you're trying to get the people who really need reservation to actually get reservation. And in fact, some states also subclassify, while some of the other states take another route to it. They say that we will give some additional benefits to the most backward amongst OBC castes. And some have actually tried to give additional schemes for the more backwards among the scheduled castes as well. So there have been some interventions. In the coming years, I can assure you this is going to be a significant issue. But the answer to this question is not going to come from the judiciary. It's not going to be an answer derived from judicial construction, as opposed to an answer driven by electoral politics, right? So that is something that we must understand. Now, apart from this, we also have the concept of something called a creamy layer. Basically adding another layer to the entire ecosystem. The idea is people who are better off by property, by finance, by status, they should be kept out of reservation benefits. This is a very, very nuanced and an application of declassification of castes. That if you can remove an entire caste entirely, at least those people in the caste who have certain benefits should be not given reservation at all. And it was the N.M. Thomas judgment which for the first time used the word creamy layer. And it says it is those individuals within the backward classes who are themselves advanced. Now, as I was telling you, the fundamental difference is, unlike list revisions or sub-quotas, this is specifically to an individual. It's not to a caste. So this means if there is a caste 1, and there is a person A who belongs to caste 1, and person A has XYZ, and this means the person A is better off, then person A should not be given reservation benefits of caste 1. This is what is called this person A, therefore then belongs to creamy layer. And let us say this person B who does not have ABC continues to be in the non-creamy layer. So this is the basic explanation out of it. This is why we do it. Now, this was decided, and why we should do this is because of the Indra Sawhney case. The Supreme Court very clearly said that creamy layer should be excluded from the benefits of reservation. But it did not mention creamy layer for what castes, for what categories. And the courts also, in my opinion, purposely, but anyways, did not give a clear definition of what is a creamy layer, because it would also mean infringing upon government policy. but have often struck down a lot of government definitions for being sometimes unreasonable or sometimes not even present. But since the fact that creamy layer is a necessary factor of principles of equality under Articles 14 and 16, because we talk about equal protection of law, it becomes very, very important for us to deal with it in the right manner. Right? Now comes the larger question: who is the creamy layer applicable to? Honestly, the answer is very uncertain one. There is no clear legal answer to this, whether it applies only to OBCs or only to scheduled caste or scheduled tribes. Now, there's again a very, very important case called the M. Nagaraj case, which we will also deal with later. The M. Nagaraj case was primarily dealing with quotas given to SCs and STs. And Nagaraj case very clearly said that the concept of creamy layer was absolutely constitutional and it should be applicable to SCs and STs, but it has not been implemented by the government. In fact, the people in the scheduled castes who are demanding for creamy layer to be added to scheduled castes are actually people from scheduled castes, because they're the most disadvantaged and they're not able to get the benefit so that they can compete and they can be more advanced. But eventually what happened was, when the court gave such a brilliant judgment in Nagaraj, the court then reversed the judgment and said that in Ashok Kumar Thakur, it very clearly said that creamy layer will not apply to scheduled caste and scheduled tribes. So therefore, what ends up happening is it only is applicable to OBC. It was originally supposed to apply to SCs and STs and OBCs as per the Nagaraj case, but Nagaraj case was overruled by the Ashok Kumar Thakur case, and now only OBCs have the concept of a creamy layer, and only non-creamy layer people who belong to this are given the kind of benefit that we are looking for. Now we are done with OBCs. Comes the fourth major category. Now this category comes out of the general category. So the idea here is, if there are 100 seats, you have reserved and you have unreserved. Reserved includes scheduled caste, scheduled tribe, and backward classes. Unreserved includes general and EWS. This cannot be more than 50% as per Indra Sawhney, and we'll discuss this. We'll discuss the 50% rule and all of that later on in the subsequent lectures. So how did the EWS reservation come about? How did the EWS quota sort of come about? Let us understand it in the right amount of detail. So it all happened in the year 2019, when the Parliament passed the 103rd Amendment to the Constitution. And it said that 10% of seats in educational institutions and government jobs should be set aside for people who were from the poorer sections. This could be done on the basis of land you would hold, the monthly income, or the size of the dwelling. Now, like OBC, the criteria for EWS for center and state can be different. There is no uniform. And unlike SC, ST, OBC, you do not necessarily need a law to implement it. Article 15.6 and 16.6 allow you to have EWS, but it does not necessarily mean that it has to be done in a specific manner. It does not necessarily mean that you need a law for it. The source of these two very good sort of infographics was this news website called News 18, which I found to be very good. It's not something that you should read, but from an infographic point of view, I was very happy about it. Now, EWS very, very specifically, does not include scheduled caste, scheduled tribes, and OBCs, and socially, educationally backward classes, anything that you would like to call or even backward classes. It is a completely separate class. So what is the 103rd Amendment? And of course, this was challenged very recently. I'll walk you through it also. It essentially it originated from Article 15, that you cannot discriminate only on the basis of religion, race, caste, sex, or place of birth. But if I can add economic backwardness, this is reasonable enough because it satisfies the principle of intelligible differentia and rational nexus. And Article 16 also talks about equality of employment. And this therefore allows for an additional 10% reservation. This was the basic idea behind it. And it was this which was actually challenged in the court of law. It was this judgment, it was this constitutional amendment, because there was a provision primarily that said that you cannot exceed more than 50%. Now, it was questioned as to why EWS would be taken out of the general category. It should not, and therefore it was a violation of the Indira Sawhney judgment. This recent judgment is absolutely not important as far as the exam is concerned. The judgment is called the Janhiz Abhiyan versus Union of India. It was recently decided in I think last week of November or something, which essentially was when the EWS judgment had originally come out. And that is something that I very categorically remember. Right? So this is the EWS amendment. This is why it has happened, and this is why it is absolutely necessary. Now, what is the primary argument that we often discuss with respect to this EWS issue, this EWS problem? The primary argument that we want to discuss, the primary argument that sort of comes into power, or the primary argument that is a matter of grave concern for us, is in fact, is this fundamentally legal? Is this fundamentally okay? Should it actually happen or not? Or is there a larger problem that we are dealing with? Now see, the issue is, and we must get this part absolutely correctly, and this is important from a specific point of view as well. It is important because, see, the primary arguments against the EWS quota, as we would understand it to be, were whether the amendment was breaching the basic structure of the Constitution. That was the first one. The second was specifically the basic structure. Does it even contain reservation? If it contains reservation, then do we have to be bothered about it? And thirdly, if you are making economic criteria, is that criteria justified or not? And the second major theme of arguments were that if you are taking SC, ST, OBC out of the whole economic criteria, is that justified? Because ultimately, an economic layer, or in another way, a creamy layer, would apply to each of these. Now, on 7th November 2022, the judgment of the Supreme Court came out, and the judgment was very, very clear about this. It was essentially about the fact that the EWS is constitutionally valid, and therefore it is perfectly legal, and therefore there is nothing wrong with the EWS judgment. Now, there have, of course, been several discussions, there have been several debates around it, and they, of course, become important. But let me just walk you through this as to what the judgments were, what were the discussions around it. See, it all started in 2019. I'll give you a little bit of a context into this. The Parliament had enacted something called the 103rd Constitutional Amendment. Now, the 103rd Constitutional Amendment, which empowered the states, which enabled the states to make reservation in higher education through an amendment to Articles 15 and 16, was conceptualized. Now, therefore, Articles 15 Clause 6 and Articles 16 Clause 6 were added because of the 2019 amendment. Now, Article 16 Clause 6 enabled that you could have a reservation for up to about 10%. This was excluding the other sort of reservations. And this is something that was fundamentally agreed on. There were more than, I think, 15, 20 petitions that were filed, saying that there were essentially four primary arguments, as I was discussing before. First is, how can the economic criteria be a primary criteria, be the only criteria? Caste has to be a dominant criteria. It cannot be as if you completely ignore it. Therefore, the Indira Sawhney question. Second, how is it violating the 50% limit the Indira Sawhney judgment had set up? Third, if you're giving reservation on the basis of economics, then why are SC, ST, OBCs also left out from that further reservation? And fourth, if you are imposing reservations on educational institutions that do not receive money from the government, you're essentially violating the right to equality, because if they're not the ones getting money from the government, then why do they have to give you economic-based reservation? And therefore, it becomes an issue. See, at present, today, about 49.5% of seats in education and public employment are reserved. 15% of it is for scheduled castes. I'll put this number in front of you. We have a total reservation of actually 49.5%. Indra Sawhney says you cannot have more than 50%. Out of the 49.5%, as we could understand it to be, 15% is for scheduled castes, 7.5% is for scheduled tribes, and 27% is for other backward classes or OBCs or whatever you would like to call it. So this is the general composition. And all of this essentially led to, very simply, 4 basic questions. The first question was, a very simple question was, can there be quotas, as we discussed, primarily on the basis of economic criteria? The majority of the judgment, 3 out of 2, says yes, because poverty is an adequate marker of deprivation, and the state can address through reservations, and therefore it is something that must be done. And when the Supreme Court had earlier said that economic criteria cannot be the sole basis, it was restrictive in nature, and that is why EWS is considered to be a separate and a distinct identity, right? And that was the primary argument. The second question was, is the exclusion of SC, ST, OBC from the quota discriminatory? The answer to that for the majority was no, it is not, because there is no competition. The reservation cannot be denied to one section, the EWS, because the other section is not suffering from the other disadvantages. I'm sure SC, ST, OBCs are also suffering from economic disadvantages, but they have been given a dedicated reservation bucket, so it is not discriminatory. Third, is it violating the 50% rule? Now, the answer to that question was that boss, if you're doing this, you're essentially making Indra Sawhney a joke. The answer was 50% ceiling was for backward classes, and it was overstretched to reservation to provide almost an entirely different class. Now, this ceiling limit that we are creating for 10% is for a completely different class. We want to keep EWS separate from your other caste divisions. And lastly, can private colleges be forced to have EWS quota? The answer to that question was that under Article 15, Clause 5, the state has the power to do so, and therefore there is not a problem as such, and is not persuasively violative of basic structure, because the Constitution specifically permits you for doing so. Now, a fundamental question that you should have is, why is this an issue even with private colleges? Why are private colleges sort of being discussed here? It's largely because it was been applicable to private unaided government colleges, and that's why it became a larger discussion. And as a result, the verdict of the court was this. It was decided in I think the last week of October, first week of November, I think around that time. And these were the larger results. And this is what EWS is for you. Is it important for the exam? The answer is absolutely no. There are essentially 4 questions that were raised. Now, apart from this, apart from EWS, this is one layer of it. We're looking at SC, ST, OBC, and of course, EWS. There is another layer which brings us to the concept of horizontal and vertical reservation. This is one layer, and in this, you could have another layer of reservation on a different reason integrated. And that brings me to the other grounds, the other ways in which we can reserve. And some of them are in this. So, of course, women, Muslim religious groups, they all become a certain amount of beneficiaries here. So let's understand this. So apart from scheduled castes and scheduled tribes and other backward classes, the Constitution also permits reservations for other groups, such as women. Another category is reservations for religious groups as well. but this sort of remains constitutionally contested. Now, these categories are not only illustrative, but these are also allowing the states to make special provisions around it. Let's start with women. You would remember, as we had discussed under Article 15, Clause 3, that nothing in this article shall prevent the state from making any special provisions for women and children. And this includes all forms of affirmative action, including reservation. Now, in practice, the government has, of course, chosen to give reservation to women in a very, very limited number of instances. This is largely because gender and gender equality as a form of political identity has not been given that kind of importance. It is ironic because 48% of people in India are women. Now, that is why we're also looking at women reservation bill, which essentially is to give 33% reservation to women in the legislative assemblies, to give reservation to women in Lok Sabha as well. We will see how women will later on get reservation in a form of a local legislature, which is your panchayats. But that is number one. The second is, can reservations be given simply on the basis of religion? See, reservation beneficiaries have been identified by the government to, to sort of solely be on the basis of caste. And to have reservations which are solely based on religion is something which judiciary has always had a lot of objections to. See, reservations already extend to some members of non-Hindu religions. For example, you'll see several state governments who classify some, we can't call it caste, so some subgroups of the Muslims, of the Muslim religion, who are eligible for reservation, because the argument is that caste hierarchy or social hierarchies extend beyond Hinduism to other religions also. And the courts also on multiple occasions have held or have constitutionally upheld the quotas and the sub quotas for some backward Muslim groups. Sometimes they have abolished certain also because of certain technical grounds. All of that is not particularly relevant because these are two technical cases, and religion and reservation together in UPSC is never going to be seeing the light of day. The thing is, more controversies have started being around on quotas which are solely based on religion. If it's religion and backwardness or subgrouping, it still has no issues. See, the makers of the constitution were very, very clear that this is something as very similar to communal electorates, which was a feature of the previous governments in a lot of places. So therefore, it becomes a problem. And they didn't want to sort of continue that practice because it would effectively cause a lot of communal disharmony. Now, having said that, what usually then ends up happening is that if you end up doing it now, it is largely for political reasons, trying to garner the Muslim vote bank. And the courts have generally opposed these reservations, which were being primarily for all Muslims. In fact, the Andhra Pradesh High Court, I remember correctly, had repeatedly held them to be unconstitutional. The Supreme Court did not eventually quash them. See, what generally happens is, uh, unlike caste-based reservations, for which there is a broad political consensus, religion-based reservations are often politically disputed. And you will specifically see several parties such as the BJP, etc., often opposing it. There are arguments on either sides. There will be arguments on either sides. The whole discussion on religion plus reservation is a strict no, no, no as far as your exam is concerned. So therefore, it will never ever be asked in the UPSC. Just wanted to give you a basic idea around it. Now in lecture number 5B, we'll understand where can reservation be given from public schools to public colleges, private schools, private colleges, legislatures, and so on and so forth. And what about private employment, which was the Haryana issue that happened some time ago. So this is lecture 5A. Let's now move to lecture 5B. Thank you. Hello and welcome to lecture number 5B of topic number 5 pertaining to theme number 3, which is preamble rights, duties, and directive principles. We are at the moment studying reservation, and in lecture number 5A, we very clearly and specifically studied who gets reservation policies. Now in lecture number 5B, we are going to study where are these entitlements at, where are these benefits at. So let's begin with the concepts and the analysis. To begin with, there is a directive principle called Article 46. And Article 46 reads that it directs the state to promote with special care the educational, economic interests of the weaker sections of people, including scheduled castes and scheduled tribes. And we understand directive principles are a non-enforceable part of the Constitution, which basically means that you cannot take the government to court if the government is not implementing a directive principle. So the real power that the government gets to give a reservation in public education or education which is owned by the state, that power comes from Article 15, Clause 4. And that is the important part. So if you read Article 15, Clause 4, and I'll take you to Article 15, Clause 4, it will very categorically tell you that Article 15, Clause 4 very specifically says nothing in this article or under Article 29 shall prevent the state from making any special provisions for the advancement. And then from here, it gets further specialized into education through Articles 15, Clause 5, and then, of course, Articles 15, Clause 6, and so on and so forth. But the idea here is the origin is Article 15, Clause 4. Then, by extension, is, of course, Article 15, Clause 5, as we know, was added through the 93rd Constitutional Amendment, 2005. Now, let's understand this. Very specifically, if you read Articles 15, Clause 4 and Article 15, Clause 5, I will open this up and magnify it so that it's very easy. If you read the articles with me, nothing in this article shall prevent the state from making any provision for the advancement of any socially and educationally backward classes of citizens or for the scheduled caste or tribes. And then if you read Article 15, Clause 5, nothing in this article or Article 19, Clause 1, Clause G shall prevent the state from making any special provisions by law for the advancement of any socially or educationally backward classes of citizens or for scheduled caste or tribes insofar as these special provisions relate to the admission to educational institutions, including private educational institutions, whether aided or unaided. So if you notice carefully, firstly, 15 Clause 5 has been added through the 93rd Constitutional Amendment 2005 that we had discussed. It specifically does not mention public education, but it is derived to mean public education, right? It has been interpreted to constitutionally protect reservations in public education. Now, you must understand, why is this important? It is important because Article 15, Clause 1 says that you cannot discriminate anyone from public spaces or education or general instances of public interest. But 15 Clause 4 and 15.5 are trying to create a special provision where you can make special advances or special cases for a special set of people. And that becomes very, very important in that segment. Now, Article 15, Clause 4 was not a part of the original text of the Constitution as we had originally discussed. And it was added later because of a case that we have been already discussing called the State of Madras versus Champakkam Dorai Rajan in 1951. Now, what had happened was that because of the Champakkam judgment, to counter the Champakkam judgment, the government enacted the first constitutional amendment and inserted Article 15, Clause 4. And much later, because of another set of issues, it then added Article 15, Clause 5 and several other articles. Now, why was this the case? As we would remember, that state governments could have reservation policies as they were constitutionally doing so. However, when the government of Madras enacted a reservation policy to provide a reservation on the basis of almost religion lines to educational institutions in Madras, the Supreme Court declared that reservation order completely invalid. It had some special provisions on the basis of religion, caste, for state educational institutions. And therefore, to counter this, we came up with Article 15, Clause 4. So before this, there was no mention of any advancement provisions. When the government tried to reserve on the basis of, let us say, caste or say with a degree of religion interfaced in caste, the Supreme Court struck it out. The Supreme Court basically struck down a government reservation policy of the state of Madras. To respond to that, we enacted the first constitutional amendment, and then we added Article 15, Clause 4, which very clearly stated that if you are creating any special provisions for the advancement of scheduled caste, scheduled tribes, or socially educationally backward classes, it is completely okay. There is no problem at all. This was a counter reaction to the Champakkam judgment, right? And that is why there is a little bit of an interest to this, right? Now, when the Parliament, in its response to the First Amendment, invalidated in a way the Supreme Court judgment to allow for public reservation, for allow reservation in public education for scheduled caste and scheduled tribes and socially and educationally backward classes, because Article 15, Clause 4 refers to SEBCs that we've understood in the previous lecture. Since then, generally the principle for education has been, principle of reservation in education has been generally accepted. However, there are certain conditions to this principle of education. You don't need to know anything more than these conditions. There are essentially three conditions. Condition number one, education reservation does not apply, or reservation policies do not apply to minority educational institutions. Simple as that. Now, these minority education institutions could be linguistic educational institutions, religious educational institutions, it does not matter. Secondly, the court has always tried to limit reservation in super specialty education, like a post-graduation in medicine. However, we will see when we discuss this in a lot more detail, there was an all India quota issue where in postgraduate medical education, the reservation on the grounds of EWS and OBC was actually upheld by the court in a judgment. We'll come to that. So the court has always tried to do so, and has always tried to limit it for reasons that we will discuss. The third is that the entire process of the extension of reservation, how you have gradually moved to reservation or how you've expanded the ambit of reservation, has also been a fairly simple one. So you start reservation from center to getting a national reservation. Then you wanted to extend reservation from SC/STs to OBCs. And then the third is you wanted to expand reservation from higher education to schools. So these have been the three dimensions in which education-based reservation has been expanded. And this is largely to do with a reservation in public institution. And we'll understand all of these in the right amount of detail. So let's first understand the issue of minority educational institutions. See, the Parliament has consciously chosen not to apply reservations to educational institutions which are established as religious or linguistic minorities. And Articles 29 to 30 specifically address this. In fact, very specifically, Article 30 of the Constitution give special autonomy to these minority institutions. Now, no doubt, there have been several Supreme Court decisions. None of them are particularly important for you at this moment. They're not even relevant for you in the syllabus. Have interpreted this autonomy to include freedom on administration, fees, design curriculum, internal quotas that they might want to have. And there has been a high degree. This kind of autonomy is not given to non-minority institutions per se. And while the Constitution was amended through the 93rd Constitutional Amendment, wherein we allowed for reservation in aided and unaided educational institutions, the Parliament here also very clearly has exempted educational institutions from the reservation. So 15 clause 4 was a general provision. 15 clause 5 was specifically with respect to education, and it defined the kind of education that we wanted to give, as it is very clearly given. See, you will not see the word education mentioned anywhere originally under Article 15 clause 4. But in Article 15 clause 5, you will see education which is being mentioned. You will not see the technical word public education, but you will see that it is inclusive of public and private and so on and so forth, as long as it is aided or unaided, but it does not apply to minority institutions. The parent article, Article 15 clause 4, very interestingly, does not mention the word education, or this is what the purpose of the reservation is. Anything more than this is particularly not relevant as far as the exam is concerned. Now, what about super specialty posts? See, the court has historically opposed reservation in super specialty posts such as higher medical degrees for that matter. And the reason is Article 335 gives you the rationale and the reason to do so. Why is that the case? Because Article 335 says that if there is an efficiency reason, if there is a necessity reason, then you can have certain exemptions from reservation. And this is the reason why super specialty posts are considered to be vital for the requirement of efficiency. That if there was reservation to super specialty posts, it was argued, it was understood, it may not be true, it is certainly questionable, that if you would have reservation in super specialty posts, it could necessarily hamper the efficiency, it could hamper the process. In fact, in the 2013 Ames case, the very famous case, the Supreme Court had reiterated and had sort of established this view. It is one of those rare cases where the court has taken a very strict sort of a contrary policy to reservation. However, most recently, there has been an issue of all India quota. This issue of all India quota again is not particularly relevant for us in the exam. It is essentially about how in a state medical college, there could be a certain number of seats on which domicile provisions do not apply. And anybody can get into these colleges, doesn't matter if you're a domicile of that state or not. And in these states, you could have some reservation in the form of, let us say, EWS or OBC. It was upheld in a very recent Supreme Court judgment. Again, is not particularly relevant for the exam, but you should know. Now comes the extension or the expansion of reservation policy in public education. Now, it has happened in three ways, as we were discussing. We extended it from the states to the center. The second is from giving reservation only to scheduled castes and scheduled tribes, we extended it to other backward classes. From giving reservation in higher education, we now give it also to primary education, which is through the right to information, right to education through Article 21A. We'll come to that. Now, reservation for scheduled castes and scheduled tribes, as we understand, has been a part of the Constitution since 1950 in some form or another. Reservation for backward classes, very specifically in the southern states, through the Champakkam judgment and so on and so forth, it started in the 1900 and it started in post 1950s. It started specifically in the mid 1950s and so on and so forth. And eventually it was expanded in the northern states in the 1980s also. But what was a landmark moment was in 2005, where the central government extended OBC quotas to central government educational institutions, such as your Indian Institutes of Technology. This was done through an order. Now, the final extension that has been done so has been by expanding it to schools as well, right? Because when you look at public education, you have basic question. When we talk about public education, is it schools, colleges? Is it by the center, by the states? And at the same time, is it government or private? So the answer to these questions are through these topics. So this takes care of primarily the education part. We'll come to school education in just a while. Apart from this, from public education, public employment also becomes a very, very strong reservation recipient. See, since Indian independence, especially because of how conservative we were, a very small private sector with diminishing returns on land had made public employment very lucrative. In fact, government jobs were often considered to be a tool of social mobility. And even today, government salaries, especially at the lower end, are far higher than a private equivalent. Like a peon in the government would make substantially more money than a peon in the private sector. And government jobs in some form or another have some legal or constitutional protections. It makes it very difficult to terminate government employees. Therefore, it gives incredible stability of tenure. And it is very, very rare in other forms of employment. And these factors have therefore made public employment an absolutely prized possession when it comes to redistributive politics in the country, when you want to give back by distributing benefits to the people. Now, very specifically, you have Article 16, Clause 4, as we can see, for scheduled castes, scheduled tribes, and backward classes. In education, it was socially, educationally backward classes. But if you look at Article 16, Clause 4, it very clearly says that nothing in this article shall prevent the state from making any provision for the reservation of appointments or posts in favor of any backward class of citizens, which in the opinion of the state is not adequately represented. So, adequate representation becomes a very important philosophical undertone of Article 16, Clause 4. Now, 15.4 when we look at employment, when we look at education reservation, 15.4 was not an original part of the Constitution, but 16.4 was always an original part of the Constitution. Now, in addition to this, Article 16, Clause 6, which was added very recently through the 103rd Constitutional Amendment, gave reservation to EWS. And apart from this, Article 335 also spoke of special provisions that could be made for scheduled castes and scheduled tribes. So it was actually Article 335 which actually permits the reservation for scheduled castes and scheduled tribes, and Article 15, Clause 3, which has been interpreted by the courts to permit reservation for women in employment. So if you add Article 15, Clause 3, where it says the government can make special provisions for women and children, and you read it with Article 335, which speak of special provisions for scheduled castes and scheduled tribes, which is how you have horizontal and vertical reservations added, merged, and you're able to give reservation for women in employment, specifically at the local legislative level. See, it's very important to understand that, and we discussed this before also, that these are not self-executory provisions in the sense that they are enabling provisions. And when, how, and to what extent does the government implement it is left to the discretion of the government. It allows the government to have a reservation policy. It does not necessarily compel the government to do so. And that is a very, very interesting way to look at it. See, in practice, the state has always used this provision, specifically Article 16, Clause 4, 5, and 4A, 4B, to, in one form or another, to execute affirmative action, giving employment to multiple classes of people. And therefore, you have the reservation of public employment in this country. Now, a question is, if you compare Article 16, Clause 1 to Article 16, Clause 4, it says Article 16.1, Clause 1 says there shall be equal opportunity for all citizens. But here it says you can make special provisions. So the question is Article 16, Clause 4 an exception to Article 16, Clause 1? Or is it an extension or an illustration of Article 16 clause? And this is it is essentially a judicial debate which still happens today. The reason why we talk about exception versus extension is because there has to be numbers and numerical limits on these quotas. And when we look at the implementation efficiency of it, there have been several studies that have shown that reservations, especially in your entry-level government jobs, have been very, very well implemented, especially in recent times. For example, there was a survey that was done of Class 1 employees in 2015, and it was found that there was a 15% quota for scheduled castes for that particular set of posts. 12.4% was actually being occupied by your scheduled caste candidates. So it is great. But having said that, the principle of reservation has certain conditions, have certain qualifications, have certain terms attached to it. Let's understand what they are. The first is, the courts have often used the limitations of efficiency of administration, which is in Article 335, to prohibit reservation in public services that require the highest level of intelligence, skill, and excellence. Now, this is a very debated issue on how do you know which job requires skill and which job doesn't require skill. Secondly, the courts have categorically prohibited reservations for single post jobs. If there is only vacancy for director of a specific government institution, there is only one post and the one post has to be filled, then you cannot have a reservation for it particularly. And thirdly, the courts have had a limited sort of reservation in the judiciary. They have limited reservations to the largest extent possible as far as judiciary is concerned. Now, specifically, when we look at it in terms of the lower judiciary versus the higher judiciary, the Supreme Court has always held that if you're looking at recruitments or reservation in the lower judiciary, it must necessarily be done in consultation with the high courts. And the power of the government to mandate reservation in higher judiciary cannot happen because it is limited by various provisions and case law, which say that independence of judiciary is in fact what is called basic structure. And if independence of judiciary is basic structure, then if you add reservation to higher judiciary, you are essentially violating the basic structure called independence of judiciary. If the Supreme Court can strike down NJAC, it can certainly strike down a reservation law that allowed for reservation in higher judiciary. Now, I don't think there is going to be a change in these basic principles. These conditions, these terms are actually fairly puzzling. And let's understand why that is the case. Since these are all jobs in public employment, and all jobs in public employment by definition are offices of what are called public trust, then the question is, why should efficiency matter in one post and not the other? Because under Article 335, on grounds of efficiency, you can limit the application of all of this. For example, a judge requires as much efficiency as a district collector does. So why is there reservation in the civil services but not in the judiciary? Now, when there are people who want to propose or who are supporters of this theory, they will say that reservations must be extended to all forms of public employment and not just a randomly or an arbitrarily decided form. Another way to look at it is that this inconsistency is essentially because how judiciary has placed several conditions in our reservation policy. So you have understood public education, you understood public employment. Now we must understand the extent to which all of this can happen in the private sector. See, reservations in private sectors are one of the most contested political issues in India. See, economic reforms since 1990s, 1991 onwards, have led to a growing number of jobs in the private sector, while government jobs have always more or less remained the same. Private schooling and higher education has also boomed. In fact, we have more private-owned universities than government-owned universities. And there are several studies, in fact, which have shown that private funding of education has outstripped state education, not only in terms of quantity, but to a large degree in terms of overall quality. And this has often led to political parties and several sections of society argue that reservation must be given in the private sector as well. And therefore, it is important for us to understand what is the legal architecture and where all in the private sector can reservation be applied. We're essentially looking at private colleges, private schools, and private employment. It is private employment which is particularly difficult. It is particularly complex. Let's start with private colleges. The decision of private colleges has essentially been the Supreme Court basically said no, and then we ended up reversing it by the 93rd Constitutional Amendment by adding reservation under Articles 15 Clause 5 and so on and so forth. So Article 15 Clause 5 is a response to the 93rd Amendment. Article 15 Clause 4 is a response to the first Constitutional Amendment, which resonates with what our initial remarks with the reservation was. That like land distribution and judicial independence, this has seen a lot of to and fro between the judiciary and the legislation. So the Supreme Court had initially held that mandating reservation in private colleges was utterly unconstitutional. The landmark judgment was the 2002 TMA Pai Foundation judgment versus State of Karnataka. This judgment, in fact, was further clarified, was further detailed in another judgment called the Islamic Academy of Education versus the State of Karnataka. And then finally, in a major judgment called PA Namdar versus State of Maharashtra, the court gave very clear understandings. It said, and I can quote the judgment, the imposition of quota seats in unaided professional institutions are acts of constituting serious encroachment on the right and the autonomy of private educational institutions. See, when there is a private college, the person who has set up that private college has set up because the person has a fundamental right called Article 19, Clause 1, Clause G, the freedom to work, have any profession you would want to. Now you are saying in that private college, you need to have reservation. You are fundamentally questioning that fundamental right. And that was essentially what PA Namdar wanted to get into. That it was a violation of our private institutions. They had the right to occupation protected under Article 19, Clause 1, Clause G. And the reservation, the reasonable restrictions to Article 19, Clause 1, Clause G, as you would remember, are under Article 19, Clause 6. And therefore, this reasonable restriction is not valid. Reservation was never a reasonable restriction under 19 Clause 1, under 19 Clause 6 for 19 Clause 1, Clause D. It was a straight, simple reading of the law. But the parliament or the government understood the potential benefit of doing this. And therefore, the 93rd Amendment of 2005 was introduced, where Article 15, Clause 5 was added. And it constitutionally enables the state to mandate reservations in private educational institutions, which effectively overrides the PA Inamdar judgment, which is why when you read Article 15, Clause 5, you will understand it very clearly says, insofar as such provisions relate to their admission to educational institutions, including private educational institutions. This was to counter the Inamdar judgment, whether it is aided or unaided by the state. That's why it becomes important. Now, of course, this does not apply to minority educational institutions. That's the basic difference we understand under Article 30, Clause 1. And very interestingly, no political party sort of objected to this pseudo-nationalization of private institutions. Of course, people had issues with objections with why were minority institutions left out. Now, although it is not relevant for you to know this, but just to complete the story, the Ashok Kumar Thakur case that we constantly keep talking about, it was a 5-judge bench, and 4 of the 5 judges left the issue open as to left the issue unaddressed. They said we will not get into this, whether reservation in private educational institutions was constitutionally valid or not. Although one of the judges in this Thakur case, a minority judgment, said that this provision is violating a basic structure because the freedom to work should be basic structure. But it was a minority judgment, so it does not hold account. But recently, of course, a very recent judgment of the Supreme Court has held the entirety of Article 15, Clause 5 completely valid, and it is not a violation of the basic structure of the Constitution. So that has been the judgment, that has been the larger discussion as to why this happened. Now, very, very important, and why was this the case? And let's understand the larger discussion around it. It's because private education is never just about education. Private education is also largely to do with the ability of entrepreneurs to build sustainable education practices, which is why it becomes a slightly more complicated issue. The judgment that we were talking about, which upheld Article 15, Clause 5, is the Pramati Educational Trust, which is the common judgment for private schools also. Now, with private schools, we've been very, very clear about it. When we look at private schools, we went out of the Article 15 domain. And this reservation in private schools is a very, very recent phenomena. And it only happened because of the 86th Constitutional Amendment, which inserted Article 21A, and that allowed for the creation of the Right to Education Act, which was enforceable from 2009. And it basically gives you a 25% reservation for weaker sections and disadvantaged groups in private unaided schools as well, as per the Right to Education Act. Article 21A basically says there should be free education, there should be compulsory education for ages between 6 to 14, and all of this has to be regulated by a law. And since education is in the concurrent list, the Parliament makes a law called the Right to Education Act, and therefore we start giving these specific provisions. Now again, Article 21A and its constitutionality was challenged, that why are private schools suddenly supposed to follow this? Why are they supposed to bear the burden of all of this? What is the larger reason behind it? What is the intent behind it? But in the Pramati education case in 2014, the 5-judge bench unanimously held that it is not a problem and Article 21A is completely constitutionally valid. Now, the reason that the court gave was actually a very interesting one. It largely said that as long as the law is forcing the admission of poor children, weaker children, children from backward sections of society, to a small percentage of seats in private educational institutions, to achieve a larger constitutional goal of equality of opportunity and social justice, which was actually set out in the preamble to begin with, this law should not be destructive or should be violative of the right of private educational institutions under Article 19, Clause 1, Clause G of the Constitution. So a very, very interesting judgment. From here, we then, of course, understand the issue of private employment. Now, this is something which is a slightly difficult problem. See, political parties have long advocated reservations in private employment. And currently, there is no constitutional provision, there is no Supreme Court major judgment, and no currently pending government bill of this. It's not that it can't be done. The question is, it should or should it not be done? The people who believe that there should be reservation in private employment, it's essentially saying that it is only a matter of time. You have to extend reservation in private employment. It is only a matter of time. It should be done under all circumstances. Because given the advent of the economic reforms of 1990, it is actually the private sector which has seen the massive growth, which has seen massive blasts in jobs and all of those things. And on the other hand, government jobs have, of course, shrunk. And there have been dedicated, statistically sound studies that even in the private setup, even in private organizations, there are discriminations which are actually based on caste. So if there are discriminations, then we must try and end those kind of discriminations. Now, there are some companies who have already, or some industry groups who have already started, implementing some forms of voluntary affirmative action, where they give some special training or some special schemes to candidates from disadvantaged groups. But the people who fundamentally disagree with this say that there is no systematic case of caste discrimination. It could be once in a while, it could be a one-off case. And if you systematically apply private employment reservation, it could hurt the economy because it's driven on talent, it's driven on market, and the private sector is supposed to aid in the global competitiveness of the Indian industry. But very recently, we have seen some states look at some local reservation laws. And I wanted to just talk about this. Earlier in 2022, the Punjab and Haryana High Court actually have stayed the implementation of a law which gave reservation in the private companies, to basically understand it. That 75% of the jobs of a specific set, of a specific type, in private establishments must be reserved for Haryanvis, for localites. Let's understand what it was. See, I think the law goes back to November 2020, November 2020. The Haryana Assembly had actually passed the Haryana State Employment of Local Conditions Bill. This was passed in the year November 2020, which provided for 75% reservation for local people in private sector jobs, which offered a monthly salary of less than 30,000, which was originally supposed to be 50,000. I think it was eventually, I think it was passed in March. The governor gave the assent to the bill in March 2021. And the law finally came into effect, I think, earlier in 2022. Especially post-pandemic, it became even a more vital necessity and a larger debate also, that on one hand, the companies are struggling post-COVID, and on the other hand, the people have lost jobs and therefore they are also struggling. So this local reservation issue is not only a legal issue, it's also an ethical dilemma. And it's not as if Haryana has been the only one who's done it. I think in November 2019, Andhra Pradesh had also tried to do something very, very similar. And they had passed the Andhra Pradesh Employment of Local Candidates in Industries and Factories Bill, where they wanted to reserve, I think, about 3/4 of the jobs for local candidates within 3 years of the commencement of this act. This Andhra law was also challenged in the relevant High Court, and it observed that this law fundamentally seems unconstitutional. And several other states, Madhya Pradesh, etc., have also popularly called the Sons of the Soil law, have been in the process of formulating very, very similar laws. So when we specifically talk about the Haryana law, I think it was the Faridabad Industries Association with a lot of other associations in Haryana who challenged the law. One of the other association, I think, was the Gurgaon Industrial Association, who essentially had contended that he wanted to create reservation in Haryana by introducing a policy of what is called Sons of the Soil, which was an infringement on the constitutional rights of employers under Article 90. Who have the right to run a business, have the right to decide who to hire in the business and who to not. One of the primary arguments that were also made was that private sector jobs are purely based on skill, with a degree of an analytical bent of mind. So therefore, employees had a fundamental right to work in any part of the country, wherever they got a skill set and a job match. And when the government was forcing the employers to employ locally, it was a violation of what was called the federal structure of the constitution. That now Haryanvis could necessarily get work here in Haryana, stopping them to work anywhere else. And it could also be a class divide. From a larger point, several top industrialists also in Haryana kept on advising the government that it could essentially restrict employment to people from Haryana, and it would not eventually work out in the overall interest of the industry. And when we looked at the kind of sectors that we were talking about, the scope was sweeping. All companies, societies, trusts, limited liability partnerships, partnership firms, large individual employees, most of them were covered under this act. The definition was that if you are a company registered under Companies Act or a society or anything, or a liability firm under the Partnership Act or a Societies Registration Act, or a trust under the Indian Trust Act, or a partnership firm under the Partnership Act of 1932, you would come under this. as long as you employ 10 or more people on salary or wages or any other form of remuneration, and it was largely for, say, manufacturing or providing any service, as long as that the government could notify from time to time. Now, central and state government institutions, PSUs, were obviously outside the scope of it because you already have government employment there. Now, a local candidate is somebody who was supposed to be domiciled in the state of Haryana. And that also was a constitutional objection. Now, the question was that if a company has a total of 100 people, does that mean 75 people are going to be Haryanvis? No. It was only for those people whose salaries were not more than 30,000. So out of the total people whose salaries were not more than 30,000, 75% of those people would have to be locally from Haryana. There could be cases where exemptions could be taken up, but it is a very long and a complicated process. So private employment, as far as education, reservation benefits are concerned, is something which is a little bit of a shoddy area. Which now brings me to the next one, which is far more clear and far more direct. We look at legislatures. See, Articles 330, 32, and 334. They enable reservation of seats in union and state legislatures for scheduled castes and scheduled tribes. Now, this has happened in the Lok Sabha and the state legislative assemblies in direct proportion to the population of scheduled castes and scheduled tribes as per the census. So, for example, in the 16th Lok Sabha, previously, they had about 540 seats. 79 were reserved for scheduled castes, 41 were reserved for scheduled tribes. So, it basically meant that there are going to be some seats which are going to be specifically reserved for scheduled castes and scheduled tribes. But there are also going to be several other seats which anyone can contest, including scheduled castes and scheduled tribes. This became important. So scheduled castes and scheduled tribes could not only contest the seats reserved for them, but any other seat which were open seats. Now, constituencies are generally sort of chosen if they have a relatively large proportion of scheduled castes and scheduled tribes. And the local administration plays a very strong role. In fact, when you become administrators in the district, this is going to be one of your primary jobs. Now, the 73rd Amendment, which was the Local Self-Government Amendment of 1992-1993, extended this. And now we give reservations in local representative bodies such as panchayats and municipalities through the 73rd and the 74th Amendment for scheduled castes, scheduled tribes, women, and OBCs in a vertical horizontal framework. So, for example, out of, let us say, 5 Gram Sabhas, 2 Gram Sabhas will be declared as scheduled caste Gram Sabhas. The Sarpanch has to necessarily be from scheduled caste, and let us say one of them, the Sarpanch, has to necessarily be a woman who's a scheduled caste and can contest for the post of a Sarpanch. Now, this idea of reservation in legislatures has 4 basic terms and conditions, 4 basic sort of qualifications. First, it was extensively debated in the Constituent Assembly. And it was generally agreed that under Article 334, these reservations would be phased out after every 20 years. But in practice, as we've seen very recently, this 334 has been repeatedly amended to extend reservations, and as we all know, it is not going to likely be discontinued. Secondly, because of reservations in legislature, and that's a good thing also, it has created a consolidated political grouping. And that grouping is essentially a collection of MPs or MLAs respectively, who would largely be voting collectively in laws in favor of scheduled castes and scheduled tribes, And these laws could, for example, be, say, reservation and promotion, which was also done later through a constitutional amendment. Now, OBCs do not have reservations in union or state legislatures, and there have been several demands for it. But 73rd and 74th Amendment, Articles 243D6 and 243D6, they enable reservations for backward classes in local representative bodies such as municipalities and panchayats. And no doubt, reservation for women does exist in local bodies. There is, in fact, as we were discussing before, there is a move to have reservation for women in the national and state legislatures as well. So, legislatures, private employment, public schooling, private schooling are 5 of the major applications where you can avail of reservation policies. Now that we understand this, we then move to understanding how can these be implemented? What are the different principles around it? This can get legally slightly complex. Like, for example, the principle of entry-based reservation, the principle of quota limits. For example, you have a 50% rule, you have a carry-forward rule, you have general seats for reserved candidates, you have the 9th schedule, which protects. Then you have reservation in promotion, which includes consequential seniority, some relaxations of minimum standards if the needs might be, or, for example, needs of organizational efficiency. And of course, other ways in which it can also be implemented. So we're going to talk about all of this in lecture number 5C, which deals with how reservation is actually implemented in the country. Thank you. Welcome to lecture number 5C of topic number 5, which is equality, with respect to theme number 3, which contains the preamble, rights, directive principles, and fundamental duties. In this particular lecture, we will continue with our discussion on reservation. And in this, we have already understood who gets reservation. We understood where is reservation given. And now we are going to focus on how is reservation actually implemented. This is where there is a lot of technicality. And this particular lecture will demonstrate a constant tussle between the legislature and the judiciary, more specifically the parliament, because the parliament is empowered and the parliament has been constitutionally given the powers to make most of the policies on this front. So let's now start by understanding the how of reservations. See, perhaps the most controversial aspect of affirmative action is the method that is used to implement it. With a few exceptions here or there, affirmative action has generally taken the form of what is called numerically mandated quotas or numerically mandated numbers, which means that under all circumstances, you would follow a statistical methodology. And it generally sort of extends, or it is applicable to entry-level promotions or entry-level positions and promotions as well. And when we look at promotions, we understand certain concepts. So it is generally at entry-level positions. It also now is applicable to promotions as well. And with promotions, you have certain follow-up concepts such as consequential seniority. And sometimes you may have to relax your minimum requirements or your minimum standards as may be needed. Now, the general idea is that a Supreme Court judgment called Indra Sohni in 1992 had categorically laid down the not more than 50% rule for SC, ST, and OBC. But EWS was largely kept out of the purview of it. So let us now start understanding each of these provisions in the right amount of detail with clear, unquestionable, simple statements. See, the most prominent of it all are entry-level reservations. Now, Articles 15 Clause 4 and 15 Clause 5 have been interpreted to permit entry-level quotas in public and private educational institutions. Article 16 Clause 4 permits entry-level quotas in public employment. It's very clear, it's very simple. See, currently, as we've understood in our earlier lectures, there is no national level quota in private employment. It is extremely sort of important to know that the words quota or the words reservation, both of these words, quota or reservation, are not mentioned anywhere in the Constitution. The Constitution always uses a larger and a more overarching term called special provisions, because this could have a larger sense of applications. But the executive and the legislature have usually sort of defined this or used this phrase in the terms of numerically mandated quotas, and the Supreme Court has validated, has agreed with this particular interpretation. Now, the general understanding or the general allowance that you should have entry-level quotas in public employment and education is subject to a few conditions. It is subject to a few guidelines. We've already done them before. Just to give them a simple structure all over again. See, the court has always resisted, and this is very important, the courts have always resisted entry-level quotas in specialized posts. We were discussing the medical exam as an example in the earlier lecture, but it also has sort of not allowed for reservation in the defense services as well. The courts have also banned entry-level quotas in single posts where there is just one specific vacancy for a designated designation. And third, the courts have permitted unfilled quotas of seats from 1 year to be filled in the next year. And this principle is called the carry forward rule, which we will of course understand in a lot of detail. The fourth one is actually very, very interesting. See, it has allowed the government not only to prescribe a general percentage in each form of employment, say X percentage of faculty positions in a university, it has also allowed for a specific position to be reserved. That, for example, you have reservations specifically for the post of an administrative law teacher at a law university. This system is actually called the roster system, which is often not talked about. And this system has led to actually a lot of litigation and a lot of consequences here or there. See, generally, the principle of entry-level reservations has been more or less judicially uncontroversial. Nobody has really questioned fundamentally that should this exist or not. But the controversies that have actually existed have been on how much are you giving reservation and are you relaxing minimum standards for a certain section of people because of inherent disadvantages. So we need to spend some time on quota limits. And the backbone of quota limits is actually the 50% rule. So let's understand this right away. The debate over quota limits in India is one of the principal features of reservation in India. And therefore, it is very important that when we discuss how much should be reserved, we must first understand what is the 50% rule. Is this right or wrong? Second, if you can carry forward unfilled vacancies to the next year, are they subject to the 50% rule? Third, what happens if a reserved category candidate is getting a general category seat, because that is also permissible? And fourth, if you have such a strict rule that 50% reservation cannot be breached, then why do states like Tamil Nadu have a 69% quota? That's largely because of the ninth schedule, which we will understand. So we're essentially going to be looking at four very important concepts under the discussion of quota limits. Let's first start with the 50% rule. Now, the 50% rule is essentially an understanding of how do you look at the relationship between Article 16 Clause 1 and let us say 16 Clause 4, right? When we say that, and this is of course specifically with respect to employment, 16 Clause 1 says you cannot discriminate against people and everybody should be given equal opportunity in matters of employment. But 16.4 says that you can create special provisions. So the basic question is 16 Clause 4 an exception to 16 Clause 1? Or is it an elaboration or an extension to 16 Clause 1? We will see some judicial evolution here. We will first see that it is considered an exception. Then we will see that it is considered an elaboration. And then we will see that it is considered a combination of exception and elaboration through various judgments. So therefore, the logic of why does this 50% rule even come into existence is based on three different visions of the relationship between affirmative action and the equality provisions of the Indian Constitution. On one hand, you're saying everybody is equal. And on the other hand, you're saying you should treat like people alike. And if like people are not treated alike, then you have to do something special for them. So what is the relationship between both of these principles, which start right from Article 14? The first version, and this is called the balance between competing constitutional principles of formal equality, social justice, and efficiency. Now, what is essentially this is that you are saying that there is an internal conflict. One has to be an exception over the other. For example, when we look at Article 16 Clause 4, it allows for reservation in employment, and it is looked at as an exception to the provision of Article 16 Clause 1. You're saying that equality, social justice, and efficiency cannot all be given absolute importance. A balance has to be maintained. No doubt, social justice is about giving people the push to undo a historical wrong. But should that be at the cost of reducing efficiency in governmental workings? And that becomes a very interesting sort of a balance you would want to maintain. Now, if 16 Clause 4 is considered to be, for example, an exception to 16 Clause 1, then the exception cannot ever be greater than the rule. The rule is treat everybody equally. But you're saying as an exception, you should treat some people with some degree of specialty. And therefore, it would make sense to have a 50% limit. This kind of an understanding was also what B.R. Ambedkar spoke about in the Constituent Assembly when he was originally talking about tomorrow if there is a possibility of reservation, because at that time 50% or anything of like that did not exist in the Constitution. But there were debates in the Constituent Assembly that tomorrow, if there could be reservation, there could be a numerical understanding of it. And interpretation of B.R. Ambedkar's speeches and what was the hint behind it was done by one of India's most foremost constitutional scholars called H.M. Sirvai. In fact, a lot of the material that you see in the class that I discussed with you comes from the original text of H.M. Sirvai. And one of the Supreme Court's earlier judgments on reservation was Balaji case. It's not sort of relevant also echoed a similar principle. Now comes the second principle, that equality's true meaning is substantive equality's true meaning is treating right people the right way, or treating special people with a special degree of attention. So it is not an exception, but an elaboration. So that therefore becomes the second way to look at it, as the Constitution expounding or enunciating the principle of what is called substantive equality. And therefore, Article 16, Clause 4 becomes a mere elaboration of Article 16, Clause 1, which includes within its idea that unequals cannot be treated the same way as everybody else. And one must also understand that reservation does not limit the equality provisions of the Constitution, but is actually extending it. It is extrapolating them. And when we look at the N.M. Thomas judgments, where creamy layer and everything else was spoken about, the N.M. Thomas judgment, among other judgments also, there was another judgment called the Railways judgment, which is called the ABSK Sangh judgment. They both generally spoke of this kind of a vision. And both of these principles, both of these arguments were synthesized into a single argument and was given some degree of closure in the Indra Sawhney case, wherein the majority of the Indra Sawhney judgment held that Article 16 Clause 4 was merely an extension of Article 16 Clause 1, but it also held that balancing the provisions of the Constitution, or balancing the provisions of equality of the Constitution, also was important, and therefore you could not cross 50% in any given year. And this effect is essentially the Indra Sawhney effect. It has also recreated the principle of N.M. Thomas, the judgment of N.M. Thomas, with a little bit of sprinkling of Balaji. Now, since it is very clear that your SC/ST percentages are based on census very clearly, so it is fixed at 22.5% for scheduled castes and scheduled tribes. That means you cannot go beyond this because the limit is 50%. And OBC therefore cannot be more than 27%. So today, though the limit is 50%, the total reservation cannot exceed more than 49.5%. That is the general understanding, that is the general principle behind it. Now, we look at the carry forward rule, which is beyond or an application of the 50% rule. The basic carry forward rule is that suppose in year 1, there were 100 seats, out of which 50 were reserved and 50 were unreserved, and only 45 got filled. And now in year 2, can these additional 5 seats be added to the reserved 50 seats, making the total reservation 55? And if this happens, does it violate the 50% rule that we are so strict about? So this phrase called the carry forward policy generally applies to reserved seats in an institution that are not filled in a given year. The question really is, can these unfilled seats be carried forward to the next year as reserved seats in addition to the seats reserved for that year? It generally doesn't happen that unreserved seats are left vacant, which is why that issue doesn't come up. And this issue specifically becomes controversial because while the seats reserved for that year might be within the 50% limit, which is mandated by the courts through Indra Sawhney, the addition of carry forward seats might push it beyond the 50% rule. Now, what has basically happened here in this case is there was a Devdasan judgment, there was an Indra Sawhney judgment. That Indra Sawhney judgment was overruled by the parliament by passing a constitutional amendment. So let's understand what it was. A 5-judge bench of the Supreme Court in the Devdasan case, first debated this issue in 1964. And it held without reasonable doubt that the concept of a carry forward is unconstitutional by nature. It should not happen. And it was very clearly established that it should not be done. And this 50% reservation should not be breached in any year, no matter what the circumstances might be. Then the Indra Sawhney judgment happened, and the Indra Sawhney judgment gave a slightly different variation of this. Indra Sawhney overruled the judgment of Devdasan, saying that while we understand that there is some substance to what we are saying, but it said that carry forward should be allowed, but it should be subjected to the 50% rule. You carry it forward, no problem, but it cannot go beyond 50%. So if it is going beyond 50%, then you cannot carry forward, which essentially was the same thing. Now, this was not acceptable to the parliament of the day. So then the parliament said that this balance that you're trying to maintain, on one hand protecting the 50% and the other hand trying to advance the interest, this is not working out. And therefore, the parliament chose to amend the constitution, and the 81st constitutional amendment happened in the year 2000. And through this 81st constitutional amendment, you allowed for carry forwards even if it breached the 50%. And this is the law today. And for that, Article 16 Clause B was specifically inserted in the Constitution. And I'll show you something very interesting. If you see Article 16 Clause, when we're talking about Article 16 Clause 4B, if I very specifically show you Article 16 Clause 4B, you will see that it very clearly mentions everything that Indira Sawhney's judgment was trying to ascertain. And it very clearly, it addresses that nothing will prevent the state from considering any unfilled vacancies as a separate class of vacancies in any succeeding years or years, and they will not be considered together with the vacancies of that year for determining the ceiling of 50%, which is what the Constitution is now giving recognition to the Indira Sawhney judgment on the total number of vacancies for that year. Just see how remarkable this is. And as a result of this, this continues to be today. The reason that the parliament gave for enacting something like this was that, especially after the Mandal Commission and the 27% quotas for OBC candidates, the total was anyways now close to 50%, which means if I have to carry forward, it is obvious that it is going to go beyond 50%. So therefore, there is no need. It is an obvious reason. It is a logical outcome of the same. We don't have an option but to breach the 50% rule. Now, this amendment was passed in the parliament with hardly any debate. And one of the few people, in fact, the only vote against this amendment in the Lok Sabha was by a gentleman called Prakash Ambedkar, who was a scheduled caste leader, who was also the grandson of Dr. B.R. Ambedkar, who was worried that by doing this, you're essentially making scheduled castes and scheduled tribes political pawns. You're not really helping them, but you're getting political capital by exploiting policies around them. But that is the general principle. This is what is called the carry forward principle. Now, let's understand the basic understanding of the general seats for reserved candidates. What we're basically talking about is that a feature of the 50% rule, this was also established in the Indira Sawhney judgment, and this judgment essentially facilitated this, that if SC, ST, and OBC candidates qualify in general merit, they are getting marks which are in the general cutoff. right? They will no longer be considered reserved candidates. They will be considered as qualified in general candidate. And in practice, it has generally led to seats for reserved groups, especially for OBC candidates, who often make it closer to the general list, to be expanded. And the seats which are available for individual candidates from non-reserved categories to be generally limited. Now, this entire transferring policy is a classic case of confused adjudication. Confused adjudication. And one justification that is generally given is that the beneficiary group is underrepresented, which makes sense. A parallel and a competing justification that is given is that if individuals from a backward group are systematically getting enough marks in the general category, should they be qualified or should they be called backward classes in the first place? So there is no right answer to this. So there are two ways to look at it. So not only is this a legal issue, it therefore also happens to be what is called an ethical issue. Now, above and beyond this, how are there certain states, such as Tamil Nadu, which have a 69% rule? This is the next feature of the 50% rule of the Indira Sawhney judgment. And that has something to do with the 9th schedule of the Constitution, which was actually added in the first constitutional amendment itself, largely to protect certain land reform laws from judicial review. That was the original purpose of it. But the 9th schedule has been used for a variety of reasons. So basically what had happened was that a basic feature of the 90% rule is that some legislations have been considered absolutely immune from it. Now let's understand why is that the case. The Supreme Court's decision in Indira Sawhney had placed reservation in a few states such as Tamil Nadu, where the quotas were about 69% in jeopardy. And Tamil Nadu said we will have 69% because our population was such. And to protect these reservations, the parliament therefore placed the Tamil Nadu state legislation for reservation in the 9th schedule. And what happens is, if a law is in the 9th schedule, it is thought to be immune from judicial review. But thankfully, because of a judgment called Yr Coelho versus the state of Tamil Nadu, the blanket protection that was given to the 9th schedule was taken away because of Yr Coelho. So Yr Coelho said laws under the 9th schedule could also be judicially reviewed if they were violating basic structure, of if they were violating certain core principles of the Constitution. And if they were violating, say, fundamental rights, you could also even take them up. However, the Supreme Court is yet to apply this judgment to the Tamil Nadu law. It has not made a decision. And the court has also not even gotten into the laws of other states, such as Andhra Pradesh and also now Maharashtra, that have quotas that exceed 50%. And that is not in the 9th schedule. So you have Andhra Pradesh and you have Maharashtra, which have laws which are not in the 9th schedule, but are they constitutionally compliant or not? And they are also breaching the 50% limit. The court has not really got into it. Maharashtra has had another issue of the Maratha reservation. And the Maratha reservation issue of Maharashtra has been a very, very important one. We will discuss this in a very limited aspect later on. But as of now, this is more than enough. And the Maratha reservation has been the closest we've come to a Supreme Court adjudication. From an exam point of view, the Maratha reservation for UPSC is absolutely irrelevant, no matter what the case might be. Okay? Anyways, because it's specific, it's state-centric, and it's fairly controversial. So the idea here is, if the parliament could do so much, does the judiciary really matter in helping the evolution of reservation policies? That is a question that we all have to wonder. And then we understand, apart from entry level, we look at how reservation is executed in promotion. And here again, we see a massive sort of a tussle between the government and the judiciary. See, no doubt, reservation in promotion is one of the most controversial debates with respect to reservation. The judiciary originally has sort of sorted out, or the general judgment by the judiciary have been opposing, or they have not favored the principle of reservation in promotion. But in the Rangachari case, the court had, and you don't need to know the details of the year because it's a very old case. It gets further structured by the Indra Sawhney case, which is why the Indra Sawhney case becomes important. The court had held that the constitution permitted reservations not only in entry-level posts, but also in promotion. So that's where the departure starts. And the matter was then conclusively decided in Indra Sawhney. Now, Indra Sawhney completely changed its stand. And that's why the principle of the judiciary being opposed to reservation promotions is a very strong one. In Indra Sawhney, the court unequivocally held that reservations in promotion were unconstitutional. In fact, the court gave a 5-year deadline to the states to phase out existing policies if certain states had them going on. But just in about 3 years, in 1992, the judgment came out in 1990. Just 3 years later, in 1995, the judgment came out in 1992. The parliament enacted another constitutional amendment and added 16(4)(a) to Article 60. And here you allowed for reservation in promotions, as it is very clearly said that nothing in this article shall prevent the state from having any provision for reservation in matters of promotion with consequential seniority. So we see consequential seniority to be a very, very important element of it, which I will discuss with you in just about a few minutes. Then there was another judgment called the Nagaraj judgment. The Nagaraj judgment then said, all right, we understand, and therefore these promotions were held to be valid. But the Nagaraj judgment then also held that the courts can look into each promotion reservation policy, can judicially review each of these policies, and you have to ensure for each specific policy that there was a demonstration of backwardness. There were the people that you were giving reservation in promotion, they were genuinely backward. 2, they were genuinely inadequately represented. And 3rd, you would ensure that this will not hamper the efficiency of it. Later on, the Pavitra Kumar judgment eventually said that there is no data required in general, and you can look at general principles of underrepresentation. But again, this is not going to be specifically asked in the exam, so just a general understanding is more than enough. Now, this Nagaraj judgment gave the power to the courts to then start striking down or looking at certain policies which were not constitutionally sound. The Rajya Sabha in 2012, this is Nagaraj is a 2008 judgment or so. 2012, they tried to pass a bill in the Rajya Sabha and move it to the Lok Sabha, but the bill eventually had lapsed. But the idea of reservation in promotion today is legally present, and you have to prove that it has some function before you actually implement it. You can promote a reservation as long as there is a genuine backwardness, inadequacy of representation, and you will not hamper efficiency, which is why it has not been implemented across all government posts, and it is a slow process taking its own time. Now, if there is a reservation in promotion, this means A can be getting a promotion faster than B because A comes from a reserved category. So A could therefore become a senior. And that's what led to a larger discussion on consequential seniority. Now, consequential seniority has also been constitutionally recognized. See, why does this matter? It matters because promotions in the bureaucracy are made after factoring in the number of years of service, sheer number of years of service. So if a reserved candidate is promoted to one post, may not be eligible for a second promotion because he may have fewer years of service than a competing candidate from a general category. So that is why under consequential seniority, if you have been promoted than somebody else and you have reservation and you've been promoted because of reservation, you will retain that seniority and that number of years wala issue will no longer be an issue for you. That was the reason behind it. Now, the Supreme Court has sort of had contradicting, differentiating judgments on this issue. And all of its sort of discussions, all of its delicate arguments have been about balancing the political push for accelerated seniority with the demands of constitutionalism. But to put the final sort of nail on the coffin, the 85th Amendment to the Constitution very expressively sought to overturn these judicial decisions that were being made in Indira Gandhi, and therefore, in Indira Sawhney's case, I'm sorry, and you provided accelerated seniority to promote reserve candidates without any caveats whatsoever. So today, consequential seniority is a very, very important factor, a very important feature of our reservation policy. Now, we understand that the basic principle of reservation is everybody doesn't come from the same ecosystem. Everybody doesn't come from the same backgrounds, doesn't come from the same set of circumstances. So is it okay to have a lesser entrance criteria or a lesser qualification for somebody who is structurally disadvantaged? And therefore, we often discuss the principle of relaxation of minimum standards. The key judgment is the S. Vinod Kumar judgment, the S. Vinod Kumar versus Union of India judgment. Now, in this judgment actually was after Indira Sawhney and it followed Indira Sawhney's guidelines. It essentially said that you cannot give any relaxation in minimum standards, especially during promotion of reservation of candidates, because of efficiency that you cannot take away from as far as Article 335 is concerned. And that was also echoed by Indira Gandhi. That was also echoed by Indira Sawhney. That worst case scenario, you will have to then look at some form of efficiency, certainty, which later on Nagra judgment gives more clarity in. The judgment, this judgment that came after Indira Sawhney, essentially held that, for example, lower qualifying marks or lesser level of evaluation in matters of promotion was constitutionally impermissible. Entry level, you're anyways giving lesser marks and lesser cutoffs. That's okay. But at the promotion level, this becomes an even more difficult understanding. Whether it's consequential seniority or relaxation of minimum standards, these are applications of the reservation policy in promotion. Of course, the Parliament had to take an action. So in response to S. Vinod Kumar's judgment, the Parliament amended the Constitution through the 82nd Constitutional Amendment, and through an overwhelming judgment, through an overwhelming majority in the Parliament, you added a proviso to Article 335 saying that the state can make any provision for scheduled castes and scheduled tribes for relaxation in qualifying marks or lowering the standards of evaluation for reservation in matters of promotion to any class or classes of services or posts. So it's never just about Part 3, it's about articles which are scattered all over the Constitution. And that was the final word. In 2014, we had the Rohtas judgment, the Rohtas Bhankar versus Union of India judgment, where the Supreme Court confirmed that relaxation of minimum standards is now constitutionally permissible. And in fact, in this judgment, I remember reading the judgment many, many years ago, the Supreme Court used the words per incurium. That Vinod Kumar judgment was per incurium. It was without due regard to law. This is again another instance where any attempts of the courts to balance provisions in the Constitution has been overturned by the Parliament. So when we often discuss the judicial supremacy, we must understand that sometimes it isn't the case of judicial supremacy or judicial superiority in the modern times that we live in. Which then brings me to a larger discussion on organizational efficiency. At the end of the day, the debate of reservations in promotion is a good place to understand how unique India's affirmative action policy is. Now, reservation in promotion is qualitatively different from reservation in entry. See, what happens is all organizations, all government organizations are largely structured around hierarchies, which is a very, very prominent factor in the number of years that a person spends in an organization. And this is particularly true, especially true for Indian public employment, where we've seen several government officers resign if they have been superseded by a junior officer, even on merit. When the junior batch officer is made chief secretary and the senior batch officer is not, they go to court. And a very prominent sociologist, Max Weber, once said that this strict hierarchy, or ironically, sort of creates a very strong sense of cadre, that there is a structural hierarchy in a given ecosystem. And that cadre becomes the key to organizational efficiency in article as considered and discussed under Article 335. And reservations in India, specifically with promotion, have had a very strong impact on this. And there have been many examples that have been presented before the courts, and the courts have pointed out that reservation and promotions have in fact led to candidates who've joined at the same time, considered each other as equals within the organization, but have been treated unequally. Now, is this fundamentally okay or not is a different question. But the fact remains that there is a massive underrepresentation of people from lower castes in senior bureaucracy. Why are we assuming that people from lower castes in senior bureaucracy will not be efficient? There's a very good chance they would be. And we have to allow for this social integration to take place, which is the essence of it all. And apart from this, there have also been several other forms in which reservation has been given. For example, you will often hear of reservations that are given in government contracts, certain government scheme implementation contracts as well. Many state governments also provide a lot of scholarships that you would have often heard of. So you would hear of scholarships that are given by state governments, which are often based on caste, often based on need, often based on gender, sometimes often based on merit also. There are often sometimes special hostels that are actually created by state governments, schools specifically, exclusively for people from a specific set of groups. We have seen, for example, specific schemes where we've created schools exclusively for students of the ST community. We would have heard of something called the Eklavya Model Residential Program. I often teach this when I teach governance and inclusion of educational governance in our governance topics. So these are reservations which transcend across government land, subsidies, state provided goods, also sometimes petrol pump allocations. The list is honestly sort of endless. And these examples actually just reiterate a very simple philosophy as to how ubiquitous affirmative action has become in every aspect of public life. When I say ubiquitous, it simply means how unique, how sui generis it has essentially become. And this is largely how we do it, which then leads me to the final lecture, lecture 4D, where we understand the why behind it. We spoke of our three principles: balancing equality, social justice, and efficiency, uh, substantive equality as a principle, and democracy generally by majority rule. So therefore, why do we do it is essentially an implied understanding that we should do it. And that's the general opinion that we must have anyway. So that ends our lecture number 5C. Thank you. Welcome to lecture 5D of topic number 5, equality, pertaining to theme number 3, which is Preamble, Fundamental Duties, Directive Principles of State Policy, and Fundamental Rights. In lecture number 5D, we are going to now understand the most important question of them all: the why behind the reservation. We've understood who gets it. We've understood where do you get reservation. We understood how does the reservation policy work. We now need to understand the most important question of them all, which is why. I don't think this will be asked directly in the UPSC in GS paper 2, but you will use the arguments here in your essays very strongly, I'm sure of it, and also in social issues in paper number 1. That is why I have to spend some time and discuss this with you. Let's first start with the most basic arguments for and against reservation, and then we'll get into the more nuanced arguments. The basic arguments that we look at as far as reservation is concerned, and why reservation makes sense, is that India is a classic example of historical injustice. This historical injustice has been in the forms of caste prejudice, gender discrimination, and all of that. And therefore, you need to create what is called a level playing field for tribal communities, for women, for other vulnerable sections. This historical injustice spans more than 100, 200, 300 years. It's a multi-century problem. It's a problem which is endemic to a religious structure to begin with, as we've understood in our earlier lectures. And therefore, this will not go off easily. We may not see it in our daily lives. We may not understand it in our daily lives, but it is something which has affected and altered the very fabric of this country. And the simplest and the most effective way of solving historical injustice is enhancing representation. This could be in employment, in education, in politics, in corporate, in any field. So reservation essentially is a tool to create equality, a tool to solve the problems of social justice, a tool to emancipate equity to begin with. And therefore, it definitely helps uplifting backward classes. And while it is solving the problem of equity, most of us do not understand what is equity. Equity and equality mean two very, very different things. Equality is equal treatment. Equity is ensuring that everybody has commensurate access. The opportunity is fair. The opportunity is reasonable. And when reservation helps in uplifting backward classes, it then creates a system of social cohesion. These are largely the arguments that are in favor of reservation. And while there are arguments in favor of reservation, there are also some principled thematic arguments which are against reservation. The problem perhaps is not with the idea of reservation, but the way it is being used. People who generally are against the policy of reservation generally look at reservation as a tool for gathering vote banks by the politicians of India. And that is a reality. That is why we often see political statements, we often see notices which are issued during elections, we often see caste votes. It's often said that you never cast your vote, you always vote your caste. That is a common saying when we understand voting behavior in the country. And within the backward classes, the dominant and the elite class has appropriated the benefits of reservation, while the people who really needed it, the people who are truly marginalized, continue to be marginalized. Scheduled castes category are generational in nature, is one example. And therefore, reservation has in fact become a mechanism of exclusion rather than an inclusion. Who should not be given reservation policy as opposed to who should be? Because injustice and indiscrimination is faced not only by the poor of the upper caste, it has also led to a massive frustration in society across people from lower and upper castes. And it's always easy to blame something which seems to be fundamentally going against you. And therefore, what often happens is often argued is reservation also results in eventually the destruction of self-respect as people compete no longer to determine who's the best, but to determine who's the most backward. We're not looking at becoming the best, we're looking at becoming the least, is one of the arguments that are often placed. Now, with such extreme arguments for and against reservation, it is my duty to present a quote that I read in a magazine many, many years ago. And this quote will perhaps make you understand the essence of what we're trying to talk about. Often, when we talk about reservation, the urban upper class argues that caste no longer exists. Most of us generally argue castes don't exist. And for everybody who's in the upper caste or the advantaged class or the non-disadvantaged class, and a lot of people just don't understand and often say that there is nothing called caste discrimination. It's all a fiction of the mind. But there is a genuine lack of realization amongst the upper class that because people are from the general category, because people are upper class, they have been able to be away from caste. People from upper caste are able to say that there is no caste discrimination because the fact that they were upper caste shielded them from caste discrimination in the first place. And therefore, you could look at new identities of choice. But if we pretend that caste does not influence our life, we're just kidding ourselves. However, those from lower middle class or lower middle caste, sorry to be more specific, they have been rendered socially immobile. They're stuck in the same ecosystem across socio-economic structures. And therefore, it is only human nature to intensify a form of their identity, which is caste identity. This is essentially the crux of it all. Having an opinion on reservation is your choice. But to say that caste discrimination doesn't exist is essentially a privilege of the upper caste. And therefore, to truly understand why reservation or why does it exists, we must understand the three thematic arguments around it. Now, you don't have to get into a lot of details. Just listen to the monologue that I'm going to present before you. Whenever we're trying to understand a constitutional logic to reservation, it is very important to avoid a utopian discussion or utopian ideas. The question is not what is the best constitutional model of reservation? Or what should the best constitutional model of reservation be? It is the question really is, what is the best description of the constitutional vision that a policy has? It's never about reservation. It's about what the Constitution envisioned us to do and how close are we with that vision. To sort of simplify this rather poetic discussion, the debate is never whether, for example, the carry forward rule is correct, or whether the consequential seniority idea is correct, or that principle is correct. It is about a constitutional vision, a constitutional philosophy, which justifies the carry forward rule, that enables constitutional consequential seniority. And that is why we will understand the competing visions that exist in the Constitution, because the Constitution in itself speaks about equality, speaks about special protections. And therefore, the whole discussion of reservation is based in a democratic setup. So let's begin with the first one. Balancing equality, social justice, and efficiency. See, the initial understanding of reservation, as we understood in the earlier lectures, was that we wanted to balance constitutional aims of formal equality, of social justice, of efficiency. You had Articles 14, 15.1, 16.1, 29.2, which generally spoke of formal equality, that everyone's equal before the law, there will be no discrimination, everybody should be given opportunity to equal status in matters of public employment. 29.2 was about minority institutions. Whereas Articles 15.4, 16.4, 46, they were essentially socialist in nature. They were pushing for social justice. And 15.4, 16.4, Article 46, which is essentially a directive principle and is not enforceable, was therefore an exception to this general principle of formal equality. And while all of this was happening, Article 335 wanted to balance social justice with maintaining efficiency in administration. And these three competing ideas, one spoke of equality, the other spoke of social justice, the other spoke of efficiency in administration. How do you balance each of these? Was not a seamless exercise. It was never easy. Any form of protected discrimination, any form of substantive discrimination or protective discrimination would inevitably have a clash with merit or efficiency. Reservation, by definition, is going to question merit and efficiency. And therefore, reservation policies must balance these principles and must ensure that one is not dominating over the other. Equality, social justice, and efficiency were in a proportionate manner. One should never dominate one over the other. And this, ladies and gentlemen, was the vision of the makers of our Constituent Assembly, of the makers of our Constitution. This was what our Constituent Assembly debates was all about. See, the problem is the Constitution of 2022 and the Constitution of 1950 are remarkably different. The kind of balance the makers of our Constitution had today, 75 years plus later, it is a very difficult balance to maintain. This logic of balance, whether it was through the N.M. Thomas case or the Indra Sawhney case, they have essentially ensured that the courts, the Supreme Courts, have a parallel vision, a completely parallel vision of how things are, of how they run. And judicial attempts to sort of balance this has also been very erratic. On one hand, the courts say this, and then after an amendment, the courts change their view. And while this should be balanced, it should be balanced in the context. And the parliament has played a very strong role in validating this balanced theory. Reservation in India has actually been shaped mostly by the legislature and the executive, not majorly by the courts. The executive orders and the parliamentary debates on reservation rarely, ever, if at all, even mention the ideas of formal equality or efficiency, which will value or which will limit their desire for social justice. It has never been a part of our parliamentary discourse. And while some judges do try to talk about it, it doesn't give any further clarity to reservation policy. The second most important understanding out of this is the notion of substantive equality. And this is a more sophisticated sort of explanation for why reservations in India exist. This is a formal legal doctrine called the Doctrine of Substantive Equality. It is entrenched in a lot of the provisions of our Constitution. The basic premise, the basic emphasis of this doctrine of substantive equality is not to claim equality or not to reach a state of equality by transcending caste, but it is to claim equality by recognizing caste. It's never about transcending caste. It's about recognizing caste. And this distinction is a very important one. And therefore, in doing so, supporters of this doctrine or people who believe in this doctrine have said that reservation policies have in fact reduced inequalities in a lot of ways. For example, reducing the education gap between SC/ST students and others, creating a Dalit middle class today, which is a reality was unthinkable of 100 years ago. And there is a substantial increase in the transfer of wealth to the lower castes. The opposite argument to this is, why are you even comparing apples and oranges? People come from different circumstances, and therefore to see them do better with respect to each of them is also a flawed discussion. But the idea here is we're looking at recognition of it. See, there are also a lot of people who argue that caste is the primary social reality of India. They would also agree that there are also multiple forms of inequities. See, government policies have never taken the other forms of inequities into account. And therefore, there is a lot more work that has to be done in a lot more detail. Whether we look at the exclusion of the creamy layer, whether we look at revising our lists, whether we look at subclassification and subquota processes, or the absence of reliance on data, all of this needs to be implemented to make our reservation policy more effective. See, there are unofficial studies not mandated or agreed to by the government, which say that SC/STs, OBCs in general are backward, but we don't have a lot of comprehensive data around it. And therefore, we have to look at some form or some ways of doing this the right way, which we haven't been able to for a very, very long time. And thirdly, when we discuss all of this in the context of democracy by a majority rule, there is a genuine deficiency of theories of constitutional balance and substantive equality when we are trying to explain reservations, because both of these theories don't fit wholly. So the most coherent argument for reservation is that the will of the people, as numerically significant but socially and educationally disadvantaged, as these people have started to rise to political power, they have used reservations through elected representatives and have also gained educational and professional power. There are groups called elites within these disadvantaged groups, and they are working together to form a majority, pushing their collective through, limited elected institutions. Now, will this make India more equal or less equal? Time will only tell. But the real test or the real driver of constitutionally permitted principles of equality is essentially through rule of majority. Democracy has its advantages, has its virtues, has its vices. And more than any legal doctrine, more than any Supreme Court judgment, it is eventually going to come down to the people of this country. Reservations affect and improve the life of a majority of people in the country. That is absolutely clear. There are no two doubts about it. Even more so for people who are OBCs. But even scheduled castes today are large political blocs in India's rather fragmented polity. And therefore, when we look at these contentious issues of how do you define backward classes, promotions, minimum rule dilution, all of this have been solved very simply through a parliamentary law, nothing else. The judgments can go and do what they want to. Ultimately, the parliament has had the ultimate say. The only place where the courts have actually played some role is through the creamy layer concept. And second is through the 50% of this, the 50% rule. Both of them have been given or have been supplemented with plenty of exceptions. And even in fact, the timing of reservation policies sort of speaks of the electoral politics than the role of, the evolution of the law. The debate is never between constitutional visions of balance or substantive equality. India's reservation policy is neither about balance nor about substantive equality, if you look at it that way. The real debate is between those who support reservation as a tool to further democracy and those who question majority rule and say that a policy which is mediated through, say, smaller groups is not necessarily the will of the people. So when you look at reservation from a democratic angle, it solves a very important anomaly in the democratic discourse of the country. This might sound a little fancy for you, but this is the truth, or this is at least my understanding of the truth. Several controversies, whether it's about women reservations, reservation in the private sector, subclassifications, all of this could be solved simply through a majority framework, nothing else. See, reservation policies reflect the contingencies or the problems of a group rather than the will of the majority. And the second is that if policies reflect majority will, then they itself are non-democratic because they are not taking into account the interests of the people who are backward. And therefore, this debate of whether reservation should be there or how it should be there is worth having between those two people who think on one hand constitution as an enabler of power through democracies, or those who see this as a problem with the liberal ideas of the constitution. But for UPSC, your answer, your opinion on reservation is very clear. It is that reservation in its current form must be improved. It should be made more efficient. It should be made more transparent. It should not be political in nature. And we must try to truly help the people who need the benefits of reservation. And that's how your reservation policy argument should be. Nothing else. Anything beyond this is irrelevant as far as the exam is concerned. And that's particularly where my role also ends. So this is reservation policy. Thank you. Hello and welcome to lecture number 6A of topic number 6 pertaining to theme number 3, Preamble, Fundamental Rights, Directive Principles and Fundamental Duties. Now topic number 6 specifically deals with Article 19, freedoms pertaining to the 6 freedoms that are mentioned under Article 19. And topic number 6 pertains to how much of this is required as far as the mains exam is concerned. So to begin with, let us first analyze the previous year questions and understand how the UPSC has asked questions from Article 19. And we must at the very outset be okay with the fact that Article 19 is an extremely important provision, at least from a mains point of view. From a prelims point of view, it may not have that kind of relevancy because Article 19 derivates into a lot of issues that are commonly seen in everyday life and almost on a yearly basis are of contemporary relevance. So now let us understand what kind of questions have been asked pertaining to Article 19 in the mains exam from 2023 to 2022. 2023 onwards because the pattern changed in 2023. Now, firstly, when you see the question in 2013, this question specifically and singularly deals with Article 19. This question pertains to the Shreya Singhal judgment. Now you must understand what the question is. Discuss Section 66A of the IT Act with reference to its alleged violation of Article 19 of the Constitution. This alleged means that the Supreme Court still has not decided on the Shreya Singhal case when the question was asked in 2013. This gives you a very important insight when you prepare these topics for the mains exam. If a contemporary issue is pending before the Supreme Court, then your opinion can be asked whether that issue violates a fundamental right or not. But if that issue has been decided by the Supreme Court, then it is very rare that your opinion would be asked. Instead, what would be asked is the impact of the Supreme Court decision, as we will also see in this particular PYQ analysis as well. So this 2013 question was essentially about this major conflict pertaining to Section 66A of the IT Act, which allegedly violated Article 19. And the Supreme Court later on in the Shreya Singhal versus Union of India case categorically held that Section 66A is a violation of Article 19. And the Supreme Court effectively struck Section 66A down. This means that Section 66A can no longer be enforceable and cannot be implemented. It is still a part of the IT Act, but it is a non-operable part of the IT Act. So we definitely see a question pertaining to Article 19, which was a massively important issue. It was across all the newspapers on the front pages and was a very major development of that year. And this particularly relates to a digital expression of freedom. It deals with freedom in the electronic space. It deals with individual expression on the in the electronic space. So that is something you have to keep in mind. Now, the very next year, because also it was an election year, so there were obviously some major developments. But the question was, what do you understand by the concept of freedom of speech and expression? Does it cover hate speech also? Why do films in India stand on a slightly different plane than the other forms of expression? Discuss. Now, as you can see, this is a 12.5 marker question, and this question has 3 parts. The first part is a theoretical, constitutional, jurisprudential, or philosophical question. That what is the meaning, what is the purpose, what do we understand by the freedom of speech and expression? What is the meaning of speech? What is the meaning of expression? Why do we have this here in the first place? A theory question, a very limited part of the question. But the next 2 parts are your opinions on issues which are controversial. The controversy has not been asked, but the underlying issue has been asked. Because of it being an election year, there will always be several instances of political speeches which could be very insightful in nature. And as it happened very recently in India also a few months ago, this issue of hate speech always comes back to the fore, always comes back to light. So the UPSC is very carefully not asking you your opinion on a specific incident pertaining to hate speech, nor is it asking you whether hate speech should be criminalized, not criminalized, is it a reasonable restriction, is it not a reasonable restriction. It is not getting into all of it. What it is getting into is hate speech is technically not mentioned in the reasonable restrictions to Article 19. So therefore, if it is not mentioned as one of the reasonable restrictions to Article 19, can it be considered as a reasonable restriction to Article 19 as an interpretation of the existing reasonable restrictions? One of the first things that you must do on your end is, before you start watching this lecture, you must read the entire text of Article 19 just for revision. If not, you should re-watch the previous prelims-oriented lecture in this course itself on Article 19. So the UPSC has been very careful about why this question has been asked. In your solutions, in our recommendations, we will get into the idea that hate speech is technically not defined anywhere. There have been Law Commission reports which have recommended that the Indian Penal Code must be recommended to introduce hate speech as a specific crime. And there is a functional difference between hate speech and sedition. But the question is, do you think that hate speech is a reasonable restriction to freedom of speech and expression? This question does not mean that if you have the right to speech, you have the right to hate speech. You obviously should not have the right to hate speech. But the question is, can your freedom to speech and expression be restricted on the grounds of hate speech? That is the real essence of this question, which a lot of candidates who appeared in the year 2014 were not able to decipher or not able to understand. Then the third part to the question was, why do films in India stand on a slightly different plane from other forms of expression? Now, this question was asked because of certain leadership changes that happened to the Censor Board of India, which led to a lot of resentment, a lot of discontentment, a lot of cross questions in the country. That the independence of the Censor Board was under light. And not only was the independence of the Censor Board under light, some of the decisions that were taken by the Censor Board around this time to allow or not to allow certain films were also questionable. So in 2014, with respect to films, there were actually 2 practical questions before the country, and they were again rampant right before you all over the news. The 2 questions were, is the Censor Board truly independent? Is it a politically biased organization? And second, is the censor board curbing film freedom? Is it curbing the creativity of the films by disallowing or recommending cuts or shortening or banning some films over the other? And is the reason given by the censor board, is the justification given by the censor board, is that justification or is that reason valid? So for all these reasons, you would therefore understand that the UPSC has still asked a very neutral question. The UPSC hasn't gotten into the politics of whether the censor board was right or wrong in banning a film, nor has it gotten into whether the censor board is a politically biased organization or not. What the UPSC has fundamentally gotten into is what is so special about films, that films have to be understood as a separate form of expression. How are films any different from a speech, a painting, a novel, a cartoon? How is it any different? Is it because of the reach of the films? Is it because of the content of the films? Is it about the distribution mechanism of the films? Is it about the social messaging behind the films? Why are films to be treated with a lot more precision, with a lot more care, with a lot more sensitivity when we're looking at the questions of Article 19 vis-a-vis that of the films? And that is why you will notice again in 2014, while the issues are very controversial, the issues are in your face, you cannot choose to ignore them even if you don't read the newspaper. But the questions that the UPSC has asked are the underlying principles behind the issue. If censor board is in the news, the UPSC is asking you, why are films to be so important? Why are they to be treated differently than any other forms of expression? So from the 2014 question, we are able to interpret two very important conclusions. The first conclusion is that while an issue might be very controversial and might be rampant in the newspapers for days and weeks on end in the form of editorials, what the UPSC is going to ask is the sheer basics behind it. The UPSC is never going to get into technical arguments with respect to a controversy. That is the first element, and that's the first learning. The second learning is that the UPSC is never going to ask you directly your specific opinion on a controversial issue. What the UPSC is fundamentally concerned with is, do you understand why an issue is an issue? Because the UPSC also in itself cannot cross a line by asking a question which could be slightly more complicated than the other. So therefore, in 2013 and 2014, we see highlights of Article 19 to be the primary focus of questions coming from this topic. Now, apart from that, as we were discussing with respect to Article 19, you will now see Article 19 to be one of the arguments, but definitely not the primary argument, not the focus of it, not the epicenter of it. So even if it is about answering questions with respect to Uniform Civil Code, there is a relationship between Uniform Civil Code and Article 19. But Uniform Civil Code fundamentally deals with Article 25 because the freedom of religion. Then by a remote extension, it deals with Article 21. And then by an even further remote extension, it deals with Article 19. The point I'm trying to present before you is rather simple. That Article 19 is not the backbone of Uniform Civil Code. Article 19 is one of the tangential, one of the circumferential arguments that we will be making while understanding Uniform Civil Code. So technically, this question is not even a question with respect to Article 19. Similarly, when we look at the second question in 2015, which specifically deals with the fact that the Supreme Court had banned crackers. Now, when the Supreme Court is banning crackers, it is also stopping those persons from manufacturing crackers. So if it is stopping people from manufacturing crackers, it means that you are somehow stopping their fundamental right to work, which is guaranteed under Article 19? So in the second question in 2015, you will see Article 19 to be an important argument to be made. You must write the argument around Article 19. It is again not the primary argument behind this, but it is certainly one of the important arguments that go beyond it. So therefore, the two questions in 2015 give us another very important learning. The learning is that there will be questions in the exam which will be a combination of Article 19 and something else. And the most likely companion of Article 19 inevitably will always be Article 21, which is why topic number 8 of theme number 3 is the relationship with Article 19, 21, and also 14. Because there are several issues which will have an impact on 14, 19, and 21, which is why 14, 19, and 21 is called the Holy Golden Trinity of Fundamental Rights. Why is that the case? We will understand in topic number 8 through the Menka Gandhi judgment and other things that are also extensions to Article 21. Now, apart from this, when we also look at the next set of questions, you also see in 2016, there is a question which says, discuss each adjective attached to the word republic in the preamble. And here we talk about sovereign, socialist, secular, democratic, republic. The word socialist will have an interpretation in Article 19 because one of the last sub-clauses of Article 19 gives the government the power to reserve any sector exclusively for the government, thereby creating exclusive state monopoly. Not only this, it can also compel people to compulsorily work in a given ecosystem with respect to conscription. And not only this, by exclusively reserving a sector for the government of India, you can also compromise the right to work, business, occupation, which is under one of the clauses of Article 19. Article 19, Clause 1, Clause G. So here also Article 19 is an important discussion to be made. And whenever there is a general question with respect to something to do with rights, our next learning is, it should be a second nature to see how Article 19 applies to this issue. How Article 19 could be an extension to one of the reasons that have been mentioned in the question. So this is why 2016 also becomes important. Now in 2017, the question reads, examine the scope of fundamental rights in the light of the latest judgment of the Supreme Court on the right to privacy. Now here again, it becomes important. Now, why does it specifically become important? Let us understand. It specifically becomes important because we go back to our original learning that if the Supreme Court has decided on an issue, if the Supreme Court has delivered on an issue, then in that scenario, you will be asked the impact of the Supreme Court judgment. You will not be asked to question the Supreme Court judgment if it's a rights-related issue. If it is a general tiff between the courts and the legislature, then yes, you would be asked your opinion. That opinion could be, let's say, have the courts curtail the power of the parliament to amend the constitution? Or can the doctrine of judicial review be changed or revived or deleted? Those are fundamental questions of judiciary versus legislature. But more importantly, when this is a question of a Supreme Court judgment delivered on a rights issue, you will always be asked the impact of it. So why is right to privacy an Article 19 issue? See, right to privacy becomes an Article 19 issue because right to privacy also should ideally include the right to be forgotten. It should also include the right to a degree of secrecy. So whenever there is an issue of Pegasus, where there are allegations of surveillance, and those surveillances compromise the privacy of people, and if one of those people are journalists, by putting surveillance on journalists, you're compromising their journalistic right of press freedom. So privacy could then also extend to Article 19. In fact, in the Puttaswamy judgment, the Supreme Court has categorically said that though privacy has primarily to do with Article 21 as the primary fundamental right, under which privacy has been made a fundamental right through an implied manner, but privacy will also have an implication to Article 19 as a subordinate article, as a sidekick, as the second lead, which again reinforces, for questions, we must always do an Article 19 check. That is there an implication, is there a perspective where Article 19 could be asked? So as you can see, almost every year, in some form or another, there seems to be a question in and around Article 19 in different forms and different means. Now, especially if we look at the last 5 years, there is a slight difference in the way the pattern has been formed. Now, very specifically, if you look at 2018, there were no questions from here, so it is out of question. But in 2019, when there is a question on compare Indian secularism with French secularism, and an element of secularism is also the freedom of costume. Costume is also an element of expression. So the hijab issue is not only an issue of Articles 25, 26, 27, 28, specifically 25. It is also an issue of Article 19, Clause 1, Clause A, because clothing is also a form of expression. So here also you will see Article 19 to be an important argument, a necessary argument, but not the primary argument. Here 25 takes the lead, and Article 19 is supporting Article 25 in a certain manner. Now in 2019, this is largely a question of a dispute or an altercation or a tiff between the judiciary and the legislature. In 2020, again, there are no questions. But in 2021, when we're referring to the doctrine of constitutional morality, the word morality has been mentioned 4 times in the Constitution, out of which it has been mentioned twice under Article 19. So it becomes a necessary ingredient while answering this question in 2020. So therefore, the importance of Article 19 for the mains exam cannot be more stressed upon. Especially when we're looking at the doctrines of constitutional morality, and we're going to give some examples of constitutional morality, whether it is the Sabrimala judgment or any of the other judgments, it will also have an impact on Article 19. Sabrimala, no doubt, is an issue of Article 25. It is also an issue of access to public places, but it is also an issue of Article 19. So therefore, in 2021, again, we have to apply the Article 19 check. That does this issue have any impact on Article 19? Please remember very carefully the learnings that I'm giving you while analyzing these previous year questions. Because these learnings are going to play a very important role when you get a mains question, which would be about something completely unrelated, but Article 19 would apply to it. So if Article 19 would apply to it, we must study it in the right manner, to the right degree. Now in 2021, it was essentially an equality comparison between India and the US constitutions, so we are sorted. But what you can now see, that there have been 2 questions, one with principles of secularism combined with comparative constitutional law, and the second with principles of equality combined with comparative constitutional law. So a natural question emerges that can there be a question comparing the freedom of speech and expression between the Indian constitution and any other constitution of the world? The answer to that is a categorical no. The UPSC will never ask you a question comparing Article 19 related freedoms to freedoms elsewhere in any other constitution of the world. See, the reason behind that is Article 19 is precise. Article 19 is one of the most detailed written articles. There are no doctrines, there are no tests, there are no judicial precedents which could serve as theories of law that come out of Article 19. To put it in a rather crude manner, Article 19 is one of the most rampant articles in and around us, but it is not a particularly deep article. It is not a particularly philosophical article. And because it is not a particularly deep article, and it does not lead to the creation of constitutional theories or doctrines or philosophies or concepts or jurisprudential arguments, Article 19 to be asked in a comparative constitutional manner is extremely unlikely. It is extremely impossible. And that is a very key learning that we must understand when we are studying Article 19. Now, the next question in 2022 again had the application of Article 19. The most significant achievement of modern law is the constitutionalization of environmental problems by the Supreme Court. And when we look at the constitutionalization of environmental problems, what is it that we finally address? What is it that we talk about? We talk about protecting the environment. We talk about curtailing business activities that can harm the environment. We talk about penalizing industries that are hurting the environment. And all of them can have an impact on Article 19. So if the National Green Tribunal bans diesel vehicles in Delhi beyond 10 years and petrol vehicles beyond 15 years, you are adversely affecting the businesses of automobile industries, thereby affecting Article 19. If the Green Tribunals or the Supreme Court, while delivering a judgment on pollution of rivers or contamination of rivers, is penalizing or banning a specific organization, it is having an impact on Article 19. So the idea of constitutionalization of environmental problems has an Article 19 implication, has an Article 19 understanding. It's not the primary argument, but a necessary argument secondary to the primary argument. And this year in 2022, the UPSC asked a very clear, concise, direct question on the same learning patterns that we have developed thus far. So in 2022, the UPSC asks, the right to movement, which is one of the rights under Article 19, Clause 1, and the right to residence throughout the territory of India. This is Article 19, Clause 1, Clause D. This is Article 19, Clause 1, Clause E. Are freely available to Indian citizens, but these rights are not absolute. And this is given in Article 19, Clause 5 as the reasonable restrictions in the interests of general public and, let us say, for the upliftment of or to protection of weaker sections, specifically the lower castes. So here also, there were reasons in 2022 why the UPSC has asked this question. And specifically, this leads to larger questions of, say, how can your movement be restricted? It could be through a lockdown. It could be through curfew. It could be through not allowing in some special states in the country. It could be through Schedule 5, Schedule 6. And residence also in the context of Post 370. But if you see, none of these issues are asked. It is a very general question that these are rights, but these are rights are not absolute rights. So tell us how they are not absolute, why are they not absolute, and give us the applications of these rights and the applications of their exemptions. That is it. So Article 19 was the highlight of 2022 as well. Which means in 2023, the focus on Article 19 would be rather limited. But in 2024, we might see a revival of the same. So this kind of a learning is very, very important before we actually start studying. Which therefore makes us understand that when we have to draw a map, when we have to draw an analysis as to where does it all begin and where does it all end, we must first understand the ambit of it. So when we have to prepare Article 19, we have to prepare issues exclusively or majorly or dominantly pertaining to Article 19. This becomes the first learning. So issues around it. The second part is we must do the theoretical backing of Article 19. The third is we must have an example matrix of each of the rights mentioned under Article 19 and its contemporary provisions. So when we just study Article 19 under topic number 6, these are the three major things that we must cover. And through a theoretical understanding, we can do a little bit of sprinkling of the Constituent Assembly debates behind Article 19 and also bring in some limited international perspective and comparison. But Article 19 story does not end here. In addition to all of this, we have to do the combinations with respect to Article 19. So our first combination would be issues which collectively have issues of Article 19 and 21. Second would be with issues of Article 19 and 25. The third would be a combination of 14, 19, and 21. Now, the way to do this is, when we do Article 21, then we will add 19 to 21. When we do 25 related issues, religion-related issues, we'll bring in an Article 19 perspective. And as I said, topic number 8 exclusively deals with the golden trinity of fundamental rights. This exercise is extremely important to separate the wheat from the chaff when it comes to the newspapers. And that is why it has to be done with the right degree of precision. So, when we look at Article 19 related issues, what do we understand? Article 19, first and primarily, has an implication on media. This media could be looked into from a print perspective, from a cinema perspective, from a broadcasting perspective, and due to technology nowadays, from an OTT perspective. This becomes the first major theme of Article 19, dominantly, exclusively, or majorly. Either of the three would apply. This is the first part. The second part are issues pertaining to dissent. It could start with something as simple as a protest. Then we would look at issues pertaining to strike. Then we would look at issues pertaining to hate speech, though this has been asked in the exam before, so we will do it in a very limited context. Sedition, and the application of a law called the Unlawful Activities Prevention Act. So these become the four major outcomes of dissent. And media performs the function of dissent. So a lot of times, while discussing sedition, we will look at the cases against journalists of a few newspapers. So this kind of an overlap will certainly exist. Over and above this, we have occupational related issues. So when we have occupation related issues, we will look at specifically certain occupations that have been in the news, but they're too controversial to be asked. So I may give you an overview of it, but I will certainly not get into the details of it. This could be, for example, with respect to, say, prostitution, could be with respect to drugs, it could be with respect to, say, online gaming, or even cryptocurrency. So I will pick up each of these issues relevantly to a larger parent problem, because prostitution is an outcome of human trafficking, which our Fundamental Rights 23 primarily deals with. Should drugs be legalized or used, or should they be allowed, or the consumption be allowed, is an impossible question in paper 2. You can use this as an example in paper 4, so should be dealt with in that angle. Online gaming and or online betting as a sector is too minor to be asked, doesn't fit into the UPSC syllabus, and is not nationally relevant enough to be asked in paper 2. And allowing or not allowing crypto, as much as it is a legal issue, it also is an issue of economics, so should be jointly dealt with majorly in paper 3. So by simple deduction, when we look at issue applications of Article 19, we primarily deal with these two: media and dissent. And once we are done with media and dissent, we will do a separate smaller lecture on the theory of Article 19 and the debates around it. And of course, an example matrix shall be provided to you. But this analysis was extremely important to begin our discussion, to understand our discussion in the larger domains of Article 19. This lecture will save you at least 50 hours of hard work before the mains exam, because if at all there has to be a question from Article 19 directly, exclusively, wholeheartedly, it will be an issue from here. Even the section 66A issue is an issue of broadcasting. It ultimately is an issue of expression of thoughts. So we will, of course, get into it. We'll do them in the right manner. And the first step to understanding the media is to first understand how media works. And that is what we're going to start with lecture number 6B. Thank you. Hello and welcome to lecture number 6B of topic number 6, pertaining to freedoms, of theme number 3, which is the Preamble, Fundamental Rights, Directive Principles of State Policy, and Fundamental Duties. Now, in extension to what we understood in the previous lecture, we will begin with our first sub-theme under Article 19 for the mains exam. And the first theme is media. And the first element, and this is very important because there might be some contextual questions from here in the mains and also the prelims exam, is to first understand the regulatory framework of the media. And after this, we will understand specifically each of the branches, their intersection with Article 19, and the Supreme Court judgments that have given some direction to the relationship with specifically issues of Article 19. So let us begin and let us start our discussion by understanding how does media in our country run? How does media in our country is structured, is regulated? So let's begin. First things first, it is collectively called the media entertainment industry. Okay. Now, one may have a negative connotation to the word entertainment, but because we're talking about a larger umbrella framework, so we collectively call it the media entertainment industry. So the media and entertainment industry, as we would understand it to be, it stands for media and entertainment. This industry is primarily regulated by the Ministry of Information and Broadcasting. That is the primary ministerial agency. So the Ministry of Information and Broadcasting. It is also called the MIB Ministry. Now, depending on the branches of the media industry, there might be some other players that will come into play. There might be an additional ministry attached. There might be a specific set of laws. There might be a set of institutions. Some of them may be backed by law. Some of them may not be backed by law. There might also be instances of self-regulation as well. But broadly, there are four very simple categories of the media industry. Four very, very simple categories or classifications. The first of them is called print. The second, commonly known as films. The third is called broadcasting. And the fourth is called digital media. It is important to classify them in this manner because the content may overlap across each of these. There can be news in print, there can be news in broadcasting, there can also be news in digital media, which is why it becomes very important to understand them in the right manner. Broadcasting will have certain subdivisions also, such as cable TV or radio and all of that, and we're going to come to that. See, each of these categories is regulated by the Ministry of Information and Broadcasting and is often assisted and supported in the activities of the Ministry of Information and Broadcasting by some subordinate organizations, autonomous organizations, statutory bodies, and sometimes in very rare cases, public sector undertakings. And given the fact that digital media involves the usage of information technology and the usage of information technology platforms, digital media is also partially regulated by the Ministry of Electronics and Information Technology. So what is very interesting is that there is a joint ministerial regulation. The parent ministry, the bigger ministry is Information and Broadcasting, but specifically with certain aspects of digital media, the Ministry of Electronics and Information Technology, or it is called popularly the MeTI Ministry, is also in play. Similarly, the Telecom Regulatory Authority of India has a dedicated broadcasting and cable division, cable services division. So here you will see a statutory body playing a role and try through its Broadcasting and Cable Services Division, is responsible for laying down the overall regulatory framework for broadcasting in the TV sector in the country. It primarily looks after the interconnection, the quality of service, and in fact, even the tariff aspects as well. So let us begin by first understanding the oldest and perhaps the most structured branch of media and entertainment, called print. Now, print as compared to everything else is dominantly news-centric, is dominantly centric on current affairs, is dominantly centric on broadcasting issues of contemporary relevance. And one of the divisions, one of the departments, one of the wings of the Ministry of Information and Broadcasting is called the Information Wing. And this Information Wing of the Ministry of Information and Broadcasting directly regulates print media in India. Now, print media is regulated by two very, very specific laws. These are old laws, but are very important laws. The first is called the Press and the Registration of Books Act. This law is dated to be 1867. And second, the Registration of Newspaper Rules of 1956. The registration of newspapers rules. Now, this is not a law, but this is a form of an executive order, a delegated legislation dated 1956. Apart from this, we also have an organization called the Press Council of India. This Press Council of India is a statutory body. This may be important for your prelims exam. It is established by a law of the Parliament. And the Press Council of India is responsible for preserving the freedom of the press, maintaining and improving the standards of newspapers and news agencies, and being a larger qualitatively driven organization. If somebody has issues with what has been written in the newspapers, it is the Press Council of India that one goes and complains to. And the Press Council of India, therefore, has the powers to conduct inquiries. Also, inquiries could be against newspapers. They could be against news agencies. If they were offending, say, journalistic ethics or journalistic standards, if there were issues of misconduct by the editors or by the journalists, it is the Press Council of India that you go complain to. It is the statutory body which is supposed to maintain a degree of quality and standardization. Now, in 2022, something controversial happened. What happened in 2022 was we released something called the Central Media Accreditation Guidelines. These are called the CMA guidelines. These guidelines were slightly controversial. Prior to these guidelines, we used to have the Central Newspaper Accreditation Guidelines dated 1999. As the name suggests, the purpose of these guidelines was to enumerate or to formulate or to stimulate or to stipulate the eligibility conditions for the accreditation of working journalists. Now, who could be labeled, classified, accredited as a functional professional journalist is governed by the Central Media Accreditation Guidelines, not by a law. So the very fact that a press card, a press ID is issued to you through a set of rules, not an act, rules which are released by the government, is in itself an indicator as to how controlling, and not only controlling, how discretionary and arbitrary these guidelines can be. Now, the reason they have attracted a lot of criticism is because the grounds on which a journalist's accreditation can be taken away. Now, these grounds are extremely diverse, open-ended, and vague. So if a journalist acts in a manner which negatively affects the country's security, the country's sovereignty, its integrity, foreign relations with other countries, or even public order, or if the journalist has been charged with a serious cognizable offense. A cognizable offense is an offense where you can be arrested without an arrest warrant. That is what is called a cognizable offense. And if you hear the words carefully, security, sovereignty, integrity, friendly relations with other countries, public order, they sound like reasonable restrictions under Article 19. So that tomorrow, if these guidelines are challenged in a court, the grounds on which these guidelines are going to withdraw journalistic accreditation are in strict conformity, literally speaking, with that mentioned under Article 19. Now, when we study press freedom or print freedom or journalistic freedom, and when we do this in the subsequent lecture, you will understand that the press has played a significant role, especially in the emergency years. In the era of emergency and a brigade of nationalization and heightened socialism through the press policies or the newspaper policies which were released by the government has tried to control the percentage of advertisements that could be in the newspaper, and that also affects Article 19. The government has tried to control the costing of the newspaper, which is also against Article 19. Apart from larger issues of what can the newspapers write and what they cannot write. Of course, newspaper writings or print writings can lead to several other outcomes, such as they may be defamatory in nature, or they may be contemptuous of court in nature, they may be inflammatory in nature. So we will look at that in a fair amount of detail, starting right from the Romesh Thapar case of 1950, which often gets quoted in the newspapers. It is the first case with respect to freedom of speech and expression, and it concerns newspapers. Very specifically, it concerns an editorial journal, which was banned in the state of Madras, affecting Article 19. So, print media has seen a historic intersection of the government in a regressive manner and the judiciary in a positive manner. The courts have continuously upheld the value, the status, and the sheer rationale as to how important is print media in the country. Of course, today in the age of digitization and internet, one could argue that the print media is slowly losing its relevance. But even in a country like India today, newspapers, magazines, journals play a very, very strong role. And especially with the advent of information technology, the same newspaper that you get in the form of a hard paper in front of you every day in the morning also has a digital footprint. There's a digital newspaper nowadays. So the walls have thinned. They have been diluted. But print media is one of the strongest pillars of what is called media and industry. Now that we understand this, we now move to the next one, which is films. Films are governed by a parent law, a law which till today is applied in its exact form. There have been several amendments to it nonetheless. And that law is called the Cinematograph Act of 1952. This act also provides for the creation of the cinematograph rules, which were propounded in 1983. And these rules give you guidelines on the certification of films and the categories of certification. And the censor board, as it is popularly called, is because of the Cinematograph Act of 1952. So the censor board is also a statutory body, and it is officially called the Central Board for Film Certification. And it gives you multiple certificates, A, UA, U, SA Special. There are special categories of movies that can only be seen by scientists, adult, all ages, parental supervision. And this certification today has been given additional layers of certification because of the IT rules for digital media. So if film certificates are of 5 types, digital certificates for digital content online are, of course, far more in number. So once a film is made, the film is then submitted to the censor board. And the censor board first either accepts or rejects the film, says that, okay, we will let the film be launched. It can outrightly ban a film also. It can recommend certain cuts in the film. It can recommend muting certain dialogues, removing certain scenes. And it is the censor board which gives you a lot of guidelines. Like, for example, every time there is a smoking scene in the newspaper, you have to very categorically say that smoking is injurious and harmful to health. Every time there's a smoking scene in the film, sorry. Similarly, if there is a movie wherein an animal is playing a role, you have to say that animals were not harmed during the making of the film. So a lot of this has happened. So in a way, the censor board is sort of a quasi-judicial authority because it decides whether a film can be released, if yes, in what form, or not be released. So it is performing a quasi-judicial function, which is why back in the day, we used to have something called the FCAT, the Film Certification Appellate Tribunal. This Film Certificate Appellate Tribunal has been abolished through the Tribal Reform Ordinance of 2021, which in itself is an issue of tribunalization and separation of powers, which we discuss subsequently in other themes. But through the Tribal Reforms Ordinance, which was later on also made into a law, in 2021, this Tribunal Reform Ordinance, which converted into a law, abolished the Film Certification Appellate Tribunal. And amendments were therefore made. And as a result, today, if you have a problem with the censor board, or a decision of the censor board, you have to now go directly to the ministry. Now, this abolishing of FCAT coincided with an amendment to the Cinematograph Act also around the same time, where the Act in 2021 was amended, again in a degree of criticism, that anyone and everyone could file a complaint against a movie, no matter what stage the movie is in. Even if it has been released, you can. And the government will have the powers to recall a movie if they find the objections worthwhile. Now, these are technical details that will not be asked in the exam, but it helps you establish context. And if the government recalls a movie, stops a movie midway after it's been launched, you can only imagine the financial cost and the implication to the makers and the producers of the movie, which is why it has also been under a lot of criticism. But having said that, the Cinematograph Act still continues to be the parent law. And how we have the info wing, we also have a films wing. Under the Ministry of Information and Broadcasting, which administers cinematograph films and activities. So there is a ministerial oversight, there is a legislative oversight, there is a statutory oversight, there is a delegated legislation oversight. So it is safe to say that films in India are one of the most heavily forms of regulated media in the country. And why is that the case is something we can discuss much later. Apart from this, we now move to broadcasting. Now, if you have an info wing or films wing, you also have something called a broadcasting wing as well. And this broadcasting wing is also under the Ministry of Information and Broadcasting. This is called the broadcasting wing. And the broadcasting wing is therefore in charge of regulating broadcasting, which includes cable TV and radio, the two major forms of broadcasting. Therefore, let us understand exactly how this works. First, let us understand cable TV. Now, for cable TV, we have, very interestingly, a law and a set of rules. But in this case, the rules have come before the law. So the law is the Cable TV Network Act, called the CTN Act. The Cable TV Network Act, officially it's called the Cable Television Networks Act. This is a 1995 law. And it is supplemented, or it is preceded by the Cable TV Network Rules of 1994, which makes it very interesting. The rules come before the law, and they largely regulate the operation of cable television networks in India. This includes the licensing requirements, the registration requirements, prescribing a program code, regulating advertisement content, all of those things. Now, under the cable television rules, in 2021 again, very interestingly, and this was not covered a lot in the media, we amended the cable television network rules. And now we have an updated set of cable television network rules of 2021. And through this, the Ministry of Information Broadcasting allowed for, very interestingly, slightly greater freedom, but through self-regulation. It set up a three-tier mechanism. This three-tier mechanism would first include of a self-regulation by broadcasters, that they will come up, there'll be a broadcasters association, and this broadcasters association will then come up with a set of guidelines. And this broadcasters regulation, or this broadcasters association, there are several such associations in India, they also make self-regulation guidelines for digital media as well. We'll come to that. That's number one. And not only will you have self-regulation policies, you will also have self-regulation bodies in the form of these associations that we were talking about. And third, as the last man standing, there is going to be government oversight. Now in cable TV, because you get foreign channels also and Indian channels also, and there is a lot of internationalization in place, all Indian and foreign companies are actually bound by policy guidelines for uplink and downlink. Now, what is uplink and downlink may be important for science and technology, but not for polity. I'll still give you a little bit of reference. See, the uplinking guidelines or the uplinking provisions are essentially about licensing, operating, or broadcasting of television channels uplinked in India for Indian viewers. And the downlinking guidelines are for regulation and licensing for foreign channels in India or through an Indian entity. So uplink is an Indian channel in India is uploading content on a satellite, which is therefore then getting us through your DTH devices. And downlinking is there is already a foreign channel from a foreign land of a foreign company, which now has to be implemented in India. So these are called uplinking and downlinking guidelines. And these guidelines are also released by the films wing, which is why they can be changed at any given point of time. Now, apart from this, as far as radio is concerned, radio is a forgotten entity, but is one of the most powerful sources of media because of its reach. Again, the Ministry of Information and Broadcasting has guidelines for setting up community radio stations in India. It also has guidelines for FM stations in India. And both of these guidelines primarily govern how your licensing will happen, regulation of content will happen, what is prohibited and what is not prohibited. And because we have forgotten a very interesting element of radio in India is that even today, private radio channels are not allowed to broadcast the news. You may hear about issues, you may hear about debates, but you will never hear private news radio channels, private FM channels ever broadcasting the news. It is a rarity, it is never seen. Apart from this, our final leg in the domain is digital media. Now let us understand how digital media works, because this is the media of today and perhaps the media of tomorrow. Now, when we want to understand digital media, there are a few underlying concepts. Digital media would include online news publications, online curated content publishers, OTT platforms, social media platforms. They are all regulated by the IT Act, read with the intermediary guidelines issued under the IT Act. So you must understand that there is the IT Act, and then there are IT rules. And in addition to the IT rules, there are some guidelines. The rules and guidelines are issued as orders, but the IT Act has been passed by the Parliament. And it includes online news, For example, The Wire, News Laundry, Scoop Whoop to a large extent, to online content publishers, people who make content to only be delivered online. So, say production houses who only make content for online platforms. Third, online platforms such as Netflix, Amazon Prime, Disney Hotstar, etc., etc. Fourth, social media in itself. So what happens here is there is a user, there is an intermediary, and then there is, of course, the content owner. User is you and I. Intermediary could be the platform. It could be Facebook, it could be Instagram, it could be Netflix, it could be WhatsApp. And the content, who has created it. In WhatsApp, individuals are content creators on both ends. In Netflix, a production house is a content creator. Netflix is the intermediary, and you and I are users. And therefore, it is a growing sector. It is being developed as we speak. And these IT guidelines that we are referring to, these intermediary guidelines that we are referring to, they impose certain due diligence requirements. And these due diligence requirements are essentially keeping a check. It is not only on intermediaries, but also social media intermediaries. For example, your user policies have to be displayed. If there is illegal or obscene content, then there must be a warning before it. There must be a very robust grievance redressal system. There must be certification for a higher and a wider variety. 14, 12, 14, 16, 18, so on and so forth. And these guidelines also establish a code of ethics for online news publishers. Like broadcasting, these self-regulation practices also apply here. And the bodies, the broadcasting bodies are the same. This is also stipulated in the IT Act. As much as it is here in the 21 rules, it is also in the IT intermediary guidelines as well. That you will have a 3-tier system, you will have a self-regulatory body. So the National Broadcasters Association, which consists of, let us say, Netflix, Amazon Prime, Z, all of those, will form one body which will regulate, which will self-regulate, will give certain policies for all the platforms together under one. And the one law which applies to the entire sector of the media and the industry, that one law, which we often forget about, is the Copyrights Act. Because at the end of the day, you're dealing with creative originality. This Copyrights Act goes back to 1957. Of course, there is a distinct difference between a patent, a copyright, and a trademark. A copyright is usually over creative productions. Patent is usually of something which is for an idea. It is an idea. It could also be a process. It could be a technology. Trademark is the final execution. So copywriting is mostly applicable here because you're looking at creative works. There are 3 different legislations. There's a Patents Act, there's a Trademarks Act, there's a Copywriting Act also. And of course, there are legal differences between the 3, but now is not the time to get into the legal differences. In your notes, you will find the legal differences as a short note. And this is how it works. Now, the larger question is, this is a simple regulatory structure. But this regulatory structure now will have another layer of policies. And the other layer of policies, therefore, that become important are policies pertaining to foreign direct investment in the media sector. Now, we have a consolidated FDI policy of 2020, which is applicable to the media sector and it hasn't changed since 2020. And this policy was issued by the Department of Promotion of Industry and Internal Trade, DIPP, which comes under the Ministry of Commerce and Industry. So the Ministry of Commerce and Industry, and a department under it called the Department of Industrial Promotion and Internal Trade. Department of the Promotion of Industry and Internal Trade. So we generally call it DPIIT, Department for the Promotion of Industry and Internal Trade. Now, this FDI policy is also regulated under a larger law because it is the money which is coming in India. So you have the FEMA Act, and under the FEMA Act, you have the FEMA rules of 2019, which actually govern the specifics of it. The Foreign Exchange Management Non-Debt Instruments rules, by the way. So this is the general understanding of the FDI policy on the media industry. However, when we look at specific sectors, we will understand that the policy is very, very different. For example, we are very, very protective about the FM radio sector. And in the FM radio sector, when you're getting foreign investment at the time of application, at the time of the license, there is a limit of 49%. And this can only happen through the government route, which is the approval route. Because the reach of FM radios is very, very sensitive. Then, what about newspapers? So newspapers and periodicals, including Indian editions of foreign magazines, and any Indian edition of a foreign magazine which deals with news and current affairs. With fashion foreign magazine, it's a different issue. We're talking about newspapers and editorials and current affairs magazines. So newspapers, magazines, etc. These are largely current affairs magazines. Not your compilations, but legit news magazines. You'd be very surprised to know that FDI is only permitted to a degree of 26%. Again, government approved. Thirdly, when you're looking at scientific journals, specialty magazines, your business journals, your foreign investment journals. So these technical journals, these scientific journals, here, because it is expertise, it's knowledge, it's precision, in this case, 100% FDI is allowed, and that also through the government approved route, which means you need to take permission from the government. You don't have to memorize this. This is just to give you context. And if you're in the business of uplinking of news and current affairs TV channels, so if you're talking about news TV channels and uplinking, which means from India to India, in this case, you have 49%, and again, approval is needed from the government. If it is uplinking of non-news channels, so non-news channels, in this case, it's entertainment, 100% FDI is allowed, and this is through the automatic route. You do not need government approval. Then your digital media agencies, your digital media streaming entities, current affairs websites, apps, platforms, news aggregators, any of those which are located in India. Here again, you will see 26%. on the government approval route. And apart from this, your final setup, your DTH companies, direct to home, your Tata Sky cable networks, your Delhi Sports, your mobile TV. Here also, generally 100% through the automatic route, because this is an infrastructure heavy investment. But if you are infusing fresh foreign investment in a company which is not particularly seeking a change in ownership pattern, then about 49%. So there are some terms and conditions attached to it. But what do you understand from here? You understand that when it comes to news, current affairs, then we have more restrictions in the form of media. This is the key takeaway to understand foreign policies. Clear? Understood? And this is how your media policy runs. Apart from this, there are, of course, a lot of technical guidelines and all of those things, which we don't have to worry about it. They're not particularly important. But this gives you a setup or an understanding of how most of these work. Otherwise, allocation of spectrums, allocation of licenses, allocation of frequencies for radios, these are all legal frameworks. And if you were a telecom lawyer, I would have given you a lot of these guidelines, but this is more than enough to set the base right. Now, in the forthcoming lecture, we'll pick up print, and then we will understand what the law is, journalism related, and print journalism related, what the judgments have been, because the general understanding to freedom of press, because this is the oldest concept, so you will find most amount of Supreme Court judgments around print journalism. So the notions of print journalism will lead to heightened Supreme Court judgments, which will give us better meanings of the freedom of press. Clear? And therefore, that makes it all okay. That makes it all understandable. So this is lecture 6B. We now move to lecture 6C. Hello and welcome to lecture number 6C of topic number 6, freedoms, under specifically Article 19. And this is a lecture pertaining to the mains exam. In lecture number 6B, we understood the broad framework of the media policy in the country. And this lecture is going to fundamentally focus on print media and how print media has a correlation with Article 19 and what are the Supreme Court judgments around it. Let us understand first that ultimately we are preparing this topic for the mains exam, which means we must be very sure of the kind of questions that the UPSC might ask with respect to print media. So, the general relevance of print media is something which is obvious. The UPSC is never going to ask you a question as to why is print media important. The second is, the UPSC may ask you the evolution of how print media has been safeguarded through various Supreme Court judgments. So this becomes the specific topic that we have to prepare as far as print media is concerned. At the outset, let us first understand how print media as a concept overall interacts with the fundamental rights ecosystem. When we are referring to something called print media, we understand that print media primarily contains two different types of entities. One, which are news, current affairs related, and the second are non-news, current affairs or non-current affairs related. These could be books, magazines, posters, any other publications which are not of the nature of dispensing news. And Article 19, Clause 1, Clause A becomes the primary article because it contains the word expression, and print is a form of expression. So from a non-news perspective, we understand that we are going to be looking at several cases involving certain books, certain magazines, certain posters, which have also built the judicial discourse of the country. But news outlets become the primary understanding, the more important understanding of print media. And within news, there are essentially two classes that we must understand. First, people who are in the business of delivering news, journalists, editors, reporters, contributors. Nowadays, of course, we are also seeing notions of citizen journalists, people who are ordinary citizens but contribute to the newspapers on a recurring basis, or even on a non-recurring basis. They could be guest contributors, guest editors, or guest writers. But our primary focus is always going to be on journalists and editors. The difference between a journalist and an editor is a journalist who is tracing the story, curating a story, and the editor is a supervising authority under whose supervision the story is actually being published in a current affairs or a newspaper or a news magazine. Now, at the end of the day, these newspapers or news magazines are also organizations. And while people pay for magazines and pay for newspapers, the user payments are not a major source of revenue for the newspapers or the magazines. Their primary source of revenue is the advertisements of it, are the advertorial pages that you add into it. So therefore, advertisements become very, very important. And therefore, the ability to decide how much advertisement can be given and how much advertisement cannot be given, because ultimately news is also a national function. It is a civic function. You are curating opinions. So does the government have any business in telling you whether this is the amount of advertisements you can have in the newspapers or not? So it becomes important. And second, newspapers also perform a larger function of public awareness. So the cost of the newspapers also becomes a relevant factor. And can the government put implications or restrictions on the cost of the newspapers? So both of these become very important aspects of understanding how print media works. So when we talk about print media, we understand that first, print media is news media and non-news media. Within news media, we look at newspaper journalists or editors or contributors. And second is the issues around the newspaper companies, which also becomes very, very important. But therefore, we should now be able to understand that these are the stakeholders. Now, specifically, if Article 19, Clause 1A is our fundamental right, the restrictions to Article 19, Clause 1A are given under 19, Clause 2. I have clubbed some of the restrictions together because they're of a similar nature, of a similar perspective, or a similar objective. So sovereignty and integrity of the nation, security of the state, friendly relations with foreign countries, public order, decency or morality, relation with respect to the contempt of court, defamation or incitement to an offense. These are the primary restrictions which are given under Article 19, Clause 2. So our first question here is, how do we ensure that while the print media needs to be given the freedoms that they deserve. In the course of doing their job, they do not violate any of the reasonable restrictions under Article 19, Clause 2. Secondly, what are the specific implications under Article 19, Clause 2, which often come to light? As we would ordinarily notice, mostly the objections are around public order, decency, or morality, or around defamation inciting to an offense, or with relation to contempt of court. Now, contempt of court, and we will do this as a separate topic under judicial reforms, but contempt of court essentially relates to civil contempt and criminal contempt. It is defined under the Contempt of Courts Act. Civil contempt means that you are not following a judgment. Criminal contempt means that something has been said or done which is questioning the reputation of the judge. The consequences of civil contempt is a fine, but the consequences of criminal contempt could be fine and imprisonment both. That is the simple understanding of it. There have been larger questions on whether contempt of court within itself, is this a reasonable restriction or not? Because if the press has the right to analyze a Supreme Court decision, or is the press has the right to analyze, say, appointments to the judiciary, or the functioning of the judiciary, or the efficiency of the judiciary, how do you know that that analysis is not contemptuous in nature? So does contempt of court inherently restrict the freedom of the press or not, is a question which has always been present, has been debated, but we do not have a clear, simple answer on it because there aren't enough judicial pronouncements on the same. But contempt of court within itself becomes a conflict directly with the concept of speech and expression, and not only for the print media, but for anybody. So if anybody wants to say anything, tweet anything, write about anything, how do you know that it is not causing a contempt? A similar application is that with that of defamation. Now in India, defamation is not only a civil issue, but it is also a criminal issue. It is defined as a specific provision under criminal law, which is the Indian Penal Code. There have been arguments, there have been Supreme Court cases where the Supreme Court has looked into whether defamation should be decriminalized as an offense, because sometimes it is used for the wrong reasons. But the fact is, if you're writing about a specific politician or a major person or a public individual, how do you know that your analysis of it, or your speech of it, or your understanding of it is not defamatory in nature? And for that very reason, you may of course be facing a higher degree of problems. So therefore, defamation, like contempt of court, also become sort of inherent limitations on Article 19 in itself. Will the UPSC ask you such a nuanced question? The answer is no. But it would be one of the arguments in the larger answer of print media, because the media is the one, through their publications, through their writings and their reports, could analyze the work of the judiciary, could analyze the work of politicians, the legislature, the executive, and so on and so forth. Though it is not categorically mentioned under Article 19, Clause 2, but another way to look at it are parliamentary privileges. And parliamentary privileges are given to our MPs and MLAs under relevant articles of the Constitution. And they give them an additional and heightened freedom of speech. So to put it very interestingly, the MPs and the MLAs have been given a higher degree of freedom of speech and expression than ordinary citizens, than even journalists. And the Constitution specifically protects their freedom to speech by giving them parliamentary privileges under the Constitution. The rationale behind that is very simple, that they are in the temple of democracy and they need to have a fearless discussion of issues that affect in the country. Which leads me to a fundamental question. Does everybody have the same freedom of expression in the country? The answer to that is our elected representatives have more freedom of speech and expression specifically guaranteed in the constitution as opposed to everybody else. And that is the key takeaway. Now, apart from this, because we bring in the company's angle, the organization's angle, the news industry angle, we must understand if the government is putting limitations on the advertisements, on the pricing, is putting limitations on certain accreditations, and so on and so forth, it is ultimately also affecting the right of these organizations to, for example, function as organizations. So if you are telling a company that this is the rate at which you can run a newspaper, and these are the only advertisements, and this is the percentage of advertisements you can have in your newspaper, you're fundamentally compromising the fundamental right of business, trade, occupation, profession under Article 19 Clause G. And the reasonable restrictions to under Article 19 Clause G is Article 19 Clause 6, which is in the interest of general public, reasonable restrictions can be made. So if the government says that you cannot have more than X percentage of advertisements in your newspapers, the government believes it to be in the interest of general public. And Article 19 Clause 6 also allows for certain sectors to be fully controlled by the government, which is why for a very long time private news channels did not exist, which is why even till today private FM channels are not given the legal authority to broadcast news. So it is a very complicated intersection of different issues that come into light. In fact, when we understand from a historical perspective, and if you think that these reasonable restrictions are already too high, in fact, Article 19 Clause 2 has the largest number of reasonable restrictions compared to any of the other reasonable restrictions under 3, 4, 5, and 6. So the reasonable restrictions under Article 19 Clause 1, Clause 2 for Article 19 Clause 1, Clause A are the highest amongst all other reasonable restrictions mentioned in any other fundamental right, including those under Article 19 Clause 1, Clause A. So that becomes a very, very interesting point, and it is a very, very interesting takeaway from our discussions. In fact, if you go through the Constituent Assembly debates and you see the draft article, the original article, which was then through Constituent Assembly debates that article was changed, you will see that one of the reasonable restrictions was also sedition. That you cannot write something or say something which could be seditious in nature. But the members of the Constituent Assembly debated that seditious activities are evolving and the courts are going to give different judgments about it. It is not appropriate to write sedition as a reasonable restriction, which is why sedition, though was in the original text of the Constitution, the draft version, it never reached the final draft which was released. It was voted out to be removed from the draft article. That is again an interesting trivia that we must know, that when we understand Article 19 Clause 2. Now the focus of what we are studying in this lecture is the print media. And our focus within the print media is going to majorly be on news and current affairs outlets. And that brings us to setting the context to the freedom of print media, specifically journalistic media. Now let's understand this. In 2022, the World Freedom Index was released, and consistently over the last few years, India's ranking in the World Freedom Index has been continuously deteriorating. Last year, it was 142nd, and this year, it is 150th. And this has been vehemently questioned and debated by the government. The government of India questions the methodology, the framework, the way the data has been collected, and fundamentally questions how this ranking came into being. This ranking is published by an organization called Reporters Without Borders, and the government singularly questions the very making of this ranking. But this ranking does give us a very interesting insight into how the world sees Indian media, very specifically the Indian press. Now, the year 2022 has witnessed several instances which have led to questioning the freedom of the press. The first amongst them, of course, has been the IT Act, the IT rules of 2021, which we will discuss in digital media, which curtail the freedom of the press because you have certain limitations around it. Secondly, as we discussed before in 2022, the accreditation guidelines now make it easier for the government to take away accreditation from journalists if their actions are questionable. Thirdly, the allegations of the use of Pegasus in India has been a rather question mark. So first, the IT rules of 2021. Second, the Central Media Accreditation Guidelines. We discussed this in the previous lecture. Third, the Pegasus allegations, where there are allegations of surveillance on journalists, therefore compromising the freedom of the press. Fourth, there have been instances of alleged abuse or discrimination, specifically against Muslim journalists such as Ayub or Rana Ayub. Now, all of these have been a matter of debate. Our job as people preparing for the civil services exam is to not have a judgment on it. Our job is to identify that there are enough issues which have led us to fundamentally look at the freedom of press in India as a primary issue 2022. Apart from this, there have also been issues of internet shutdown, which have also brought a larger question mark on press and the availability of media. But the focus of our lecture today is, of course, print media, and we will come to that in the subsequent parts to the lecture. But what is very interesting to note is that the Constitution of India does not specifically give any special rights to journalists in the country. Journalists in India have the same fundamental freedom of speech and expression as any other citizen in the country. There are no special protections that should have been given to journalists, no special terms and conditions that could be given for affirmative protection of the journalists. None of that has happened. And it was debated in the Constituent Assembly that we must write freedom of the press specifically, or we must give special protections to journalists. It was debated heavily in the Assembly, but eventually it was understood that our fundamental right is open-ended enough to give the media the right amount of protections that they need. And therefore, when the final draft of the Constitution was adopted and enacted in January 1950, we do not find the mention of journalistic rights or press rights very specifically in the Indian context. And that is sort of the starting point of our discussion as far as our rights are concerned. And this tells you that if the laws of India are open-ended, if the laws are not precise enough, then it becomes the constitutional duty of the Supreme Court and the courts of the country to then start creating certain guidelines, to start creating certain judicial discourses, will then start giving more rights to press and non-press print outlets. So when we see the role of the Supreme Court to be astounding in print media, it is largely because the role of the law has been minimalistic. And to fill that void, to fill that gap, you will see several judgments by the court addressing several issues and thereby creating what is called a discourse on print media and Article 19. So we've divided the Supreme Court judgments into two parts. The first part are Supreme Court judgments dealing with news print media. The second part is the non-news print media. So let us begin with the news print media. Now, when we start with the news print media, we must understand through various Supreme Court judgments, we are now able to give the following freedoms to the press. And the following freedoms to the press include, first, the fundamental freedom to spread information. Fundamentally, what the media is trying to do is to provide information to people so that they can make informed choices. And this concept of information is extremely important. If people have the freedom to speech and expression, if I have the freedom to have an opinion about something, I also need the information to have the opinion about something. And this information will come from two places. One, from the media, and second, straight from the house's mouth, which is the government. This is also why later in several Supreme Court judgments, the Supreme Court has identified the right to information as an implied fundamental right under Article 19. Though the issues with right to information are organizational in nature, the issues with right to information are issues with respect to the Central Information Commission and the State Information Commission. And that is why they are dealt with from the governance point of view, not from the polity point of view. But one must always remember that the right to information is an implied fundamental right under Article 19. It is one of the ways in which people are able to get information. The other way is, of course, through print media. Now, governmental information will, of course, be biased. If not biased, it will not help you create an opinion. And that is why it becomes important. The freedom of the press has a very complicated function. The press, in addition to giving you factual information, is also giving you opinions on an event. And therefore, they will lead to the creation of certain opinions, which is also why one will always see that several newspapers, several media outlets, several of these will have several kinds of leanings all across the place. And that is why it becomes important. Now, the freedom to spread information was recognized for the first time, and we will do this case in a fair amount of detail, in India's first Article 19 case called Ramesh Thapar versus the state of Madras. This is a 1950 case. We will do this in detail. Now, the understanding here is that a press, by the means of its publication, has the power to distribute information. And it is also because of this that we will see issues of fake news or issues of paid news often come to the fore. So once we are done with discussing all the media together, we will then discuss how are we dealing with fake news and paid news in the country, which are questions on the operations of the media. It is extremely unlikely for questions on fake news or paid news to be asked in the exam because they're political in nature, they're controversial in nature, and there isn't a lot of legality involved. and they are not otherwise placed in any other part of the syllabus. We generally write about fake news and paid news in our essays and ethics, but from a polity point of view, we never see questions specifically with respect to paid news or fake news in the country, especially in the last 10 years or so. In addition to the freedom to spread news, the media also has the freedom to criticize. Of course, it cannot cross a certain boundary, cannot threaten the security, integrity, sovereignty of the state. Thirdly, the freedom to receive information also becomes important, because something very important and at the heart of journalism is the relationship the journalist would have curated with the source of the journalist. And it is a matter of standard practice of journalism across the world that this relationship between the journalist and the source must be protected at all costs. And when surveillance or Pegasus related issues are alleged in the country, then this confidentiality between the journalist and the source is questioned. Therefore, Article 19 is also questioned, because you could then create a sense of pressure. The fourth is the freedom to conduct an interview. Now, this is sometimes one of the places where the media has often crossed a line, whether it is about interviewing celebrities or politicians or the kind of questions the media often asks. And therefore, it is generally understood that the interview should happen if the person who's giving the interview has consented to it. The interview should stop whenever the person wants it to stop. And the interviewer cannot ask a question forcibly or asking a person to answer a question against their own will. And therefore, they become very, very important. And therefore, they become very, very focused. So the freedom to conduct an interview is a very important element of the freedom of press. Now, something which has become even more important nowadays is the freedom to report court proceedings. Now, this has multiple repercussions. The first is we still have contempt of court as a clearly defined reasonable restriction under Article 19, Clause 1, Clause A. The second is, nowadays, we also have legal journalistic websites like Live Law, Live Reporter, Case Reporter, etc., who are allowed to sit in courtrooms and give you a word-by-word discourse on judicial proceedings. So nowadays you have legal news portals which have become very, very rampant. Most of them are in the online space, so have to be dealt with from a broadcasting point of view or from a digital media point of view. Thirdly, is that several high courts and the Supreme Court itself has started live proceedings. So reporting those live proceedings has also now become a very important element of legal journalism, especially because when you are opening a case digitally, you have to ensure that in sensitive cases, the reporting is not allowed. You're not live streaming it. In cases where the identity of one of the parties to the case has to be hidden, that also has to be blocked from live streaming. Third, when you see a lot of these YouTube channels which have become very popular as they show live proceedings, are they showing it in the right context? Are they paraphrasing and cutting and only showing what is being shown to garner a little bit of popularity? So live proceedings have had an impact and have accentuated the freedom to report court proceedings. Now, in this case, the Supreme Court, in a case which is very well known but is not relevant for UPSC, is the Sahara India Real Estate Corporation case. So this was the Sahara versus SEBI case, when Sahara India, which was also an airline company, was under a lot of investigation because of certain financial irregularities. In this case, the Supreme Court had held that it is the right of the media to report judicial proceedings. In fact, in another case called Sarojini or Saroji Iyer versus Maharashtra Council, or the Maharashtra Medical Council, or the Maharashtra Medical Council of Indian Medicine, either of the three names, the case is not important. The Supreme Court held that the media has the right to print faithful reports of legal proceedings, even if it is against tribunals. So we have very clear judgments giving you the right to do so. And from here, as I was discussing, the freedom to attend and report legislative proceedings also comes into power. See, Article 361 of the Constitution gives us the right of publishing a report of parliamentary proceedings. The only thing is, there cannot be any malified intention when somebody is giving a report of parliamentary proceedings, whether it is the newspaper or the PRS or TV channels. And when the right of reporting legislative proceedings is sort of implicit under Article 19, we have to also ensure that parliamentary privileges that we are talking about, they do not get hampered. How? If a person has the right to speak whatever they want to on the floor of the parliament, and whatever the person is speaking on the floor of the parliament is on something very sensitive, or it could have an impact on the person's life, the MP or the MLA, then you cannot report it outside because it may cause a threat to the person and therefore limit the person's parliamentary privilege. And it becomes an important element. Then the seventh freedom of press is the freedom to act as an advertising platform. See, all of these will apply to online and offline both. But because we're talking about offline right now, we're talking about print mediums. So we will discuss them and you will replicate them for online as well. So online press agencies will also have similar rights. Okay. Then the freedom to act as an advertising platform in itself becomes very, very important. Why? Because the media in itself is a distribution mechanism. Newspapers are distribution channels. You're able to catch the eyes of the people. That is why you will see, for example, nowadays, a lot of times, you will see brand placements in YouTube videos or integrations in YouTube videos. Because YouTube in itself is an advertising platform as well. So are newspapers more original. And this freedom to act as an advertising platform was after the Tata Press versus the Mahanagar Telecom Supreme Court judgment. The judgment again is just to give you a little bit of an example or to just give you an understanding of it. But it is nothing but the Tata Press versus the Mahanagar Telecom case, wherein the freedom to act as an advertising platform was clearly identified. And lastly, the freedom to broadcast, which is largely and mostly to do with online or digital mediums, becomes important. So out of these 8 rights, there are 7 rights which are available exclusively for offline, and the 8 are available for offline and online because broadcasting can only happen through a technology-driven medium. Now that if these are our rights, let us understand some landmark judgments of the Supreme Court that will help us build these rights even further, grow these rights, and cement these rights. So we now start with landmark Supreme Court judgments pertaining to print news media. And after this, we will move to the next one, which is the non-print, non-news print media. So let's move ahead. The one doubt that one must be clearing when we start studying Supreme Court judgments is that under no circumstances, facts are important. So facts are not important I'm just going to be telling you what happened in the case so that you can understand what the case is about, but you do not have to mention the facts in your exams. So as discussed, we start with Ramesh Thapar versus the State of Madras of 1950. The case is a very interesting one, and let us understand what happened in the case. So, Ramesh Thapar was the printer, publisher, and the editor of an English journal called Crossroads. And this English journal called Crossroads used to be printed and published in Bombay. Now, the neighboring, the co-southern state of Madras at that time, because at that time Tamil Nadu did not exist, they passed an order act called the Madras Maintenance of Public Order Act. This act was passed in 1949. Under this act, the entry and the circulation of the journal was banned in the state of Madras. The section I don't remember correctly, but I think it was section 9(1)(a) or something. So basically, a law in the state of Madras called the Madras Maintenance of Public Order Act of 1949 banned the entry or banned the circulation of this journal in the state of Madras. So Ramesh Thapar obviously filed a writ petition before the Supreme Court saying that my Article 19 is being violated as they are not allowing my journal to be presented. And then the state of Madras said that this journal was restricted because it was violating public safety and public order. And public safety and public order could be equated with the security of the state, which was a reasonable restriction under Article 19, Clause 2. The judgment of the Supreme Court was brilliantly clear. The Supreme Court said that we agree with Ramesh Thapar that the powers that have been given under this act are unconstitutional. They restrict your freedom of speech, and therefore this must be reversed. So as a result of this, the Supreme Court declared this provision to be unconstitutional and allowed for the circulation of this journal in the state of Madras. And as a result, the Supreme Court very clearly, in a beautiful line, said that only and only very narrow restrictions on the freedom of speech and expression were envisioned by the Constitution. And one must try our level best to give as much freedom as possible. And therefore, any legislation which would allow wider restrictions should be considered invalid. You should have very specific restrictions for very specific reasons. Just because you think something is public order and therefore public order is public safety and public safety is security, that kind of an extrapolation will not work. So it became the first case through which the Supreme Court expanded and safeguarded the freedom of the print. Right, this is important. And because this was a journal which was slightly contemporary in nature, we categorized it under the news category. The second major judgment was the Sakal Papers judgment. Now, the Sakal Papers judgment was completely about newspaper organizations. Now, it's a very interesting judgment, and let us understand. Sakal Papers Private Limited was a private company which used to publish newspapers, and the shareholders of the Sakal company and two of the readers of the Sakal company had filed this case against the state. The problem was that there was something called the Newspaper Price and Page Act of 1956. That law doesn't exist anymore, but it was called the Newspaper Act of 1956 popularly. Through the Newspaper Act of 1956, the central government could regulate the prices of the newspapers in relation to the pages and the allocation of space for advertisements. So if you have lesser pages, you need to have lesser prices, and ranges were given by the central government. If you had more pages, but you had more advertisements in those more pages, then also the cost of the newspaper should be low. Not only this act, the rules because of this act, the Daily Newspapers Order of 1960, which was essentially used to implement certain restrictions on pricing, etc., they were also challenged. Now, the Supreme Court, of course, very categorically declared that the Newspapers Act of 1956, the Newspapers Page Order of 1960, they were invalid. They violated the constitutional right of free speech. And these acts, which regulated the prices, would eventually lead to a restriction of the way a person could run their business, even if it is the news business or the publication business. The court very clearly found that these laws would either increase the prices or make you reduce the pages, which would lead to a restriction of ideas, and that restriction of ideas could be a violation of free speech. How a person wants to communicate, in what manner, and how much of advertisements does one person want in their newspaper should be left up to them. And therefore, this decision is considered as one of the most landmark decisions as far as the Supreme Court and freedom of speech is concerned. Because by doing this, what has happened is we have reinforced that restrictions relating to the number of pages, the price, the advertisement, the circulation of the papers, any of these things that we are talking about, any of these restrictions will constitute a direct infringement on the freedom of speech and expression. So Sakal newspapers therefore deals with the freedom of organizations. This deals with how a reasonable restriction was interpreted by the court. Now comes the third judgment, which is called the Bennett-Coleman Limited Judgment. And the Bennett-Coleman Limited Judgment in itself is the organization which actually owns a very popular newspaper called Times of India. Now, this judgment is a slightly complicated one because Bennett-Coleman Limited is one of the largest media houses in the country. And they're essentially what are called media conglomerates. They own the Times of India. They own several other newspapers. They also own certain TV outlets, certain digital mediums also. Now, why is this a case? Because in 1955, there was something called the Import Control Order. The Import Control Order of 1955 was restricting the import of newsprint, the paper that you use to print your newspaper. That is called newsprint. The paper that you use on which you print the news and then you sell it to the people. So the new Import Control Order of 1955 was under a larger order called the Newsprint Order of 1962. And this essentially placed restrictions that you cannot import newsprint from outside. And there were restrictions on how you could use newsprint. And this was also just one part of the story. The other part of the story was the newsprint policy of 1972 to 1973 had placed another set of restrictions. This was not a law, this was a policy. Remember, emergency peak era is going to start from the 70s. That first, no new newspapers can be set up by an organization which already has two newspapers. One of them is a national daily. So you're restricting expanding businesses. Second, the total number of pages in a newspaper cannot be more than 10, which is a very abstract, arbitrary number. Third, the increase in the number of pages cannot be more than 20% for newspapers that are under 10 pages. So if at all there is, then you need special permission for it. And lastly, there cannot be any interchangeability of newsprint. The same newsprint has to be used for the same newspaper. And therefore, petitioners could not, or the people who filed the case could not adjust their circulations, and these newspaper policies were very, very restrictive. The Supreme Court accepted the arguments of Sakal newspapers and said that these restrictions on newspapers were affecting your right to freedom of speech and expression. No doubt. because the freedom of speech and expression includes both qualitative and quantitative dimensions. It's not only about the quality of news, but the quantity of news. And the Supreme Court declared that the newsprint policy of the early 70s, the policy in itself, was unconstitutional and should not be implemented, which is one of the rarest things for the Supreme Court to declare a policy in itself as unconstitutional. And its quantitative restrictions were not justified by the shortage of the newsprint. And therefore, it was struck down. And what is key for us to remember for the mains exam is that this judgment primarily recognizes that the freedom of press is not only restricted to freedom from direct regulation, it is also the freedom of press also goes to distribution. And quantitative restrictions that are not purely content based, they can also affect the freedom of the press. If you're limiting the number of pages or content, you're also affecting it. And therefore, the Supreme Court in this case recognized that if freedom of press has to be effective, unnecessary interference that affects its economic viability must also be prevented. So this case therefore deals with the economic sustainability or the economic viability of newspaper organizations. A very important judgment. The next judgment, which is again very important for a very popular newspaper, is called the Indian Express. The Indian Express newspaper, Bombay Private Limited versus Union of India. It's a recent judgment. It's a 1984 judgment, if I remember correctly. Now, what happens in this 1984 judgment is also very interesting. So, when we say the Indian newspapers Bombay Private Limited, the Indian Express newspapers Bombay Private Limited, who are we talking about? We're essentially talking about the company, the employee, and the shareholders of this organization. Now, what had happened was very similar to Bennett Coleman Limited. There was an import duty which was levied on the newsprint, and this import duty was levied under the Customs Tariff Act of 1975. That you have to pay a duty, a certain amount, when you're importing newsprint. And there was an additional duty through the Finance Act of 1981, passed through the 1981 budget. And both of these were done to, of course, make it more difficult and more expensive. As a result of this, newspapers would become more expensive, more costlier, and it would be very difficult to balance your interests. And if they could become expensive, then it would further limit my freedom of speech and my freedom to run a business as far as my newspaper organizations are concerned. They alleged and they argued that there is no public interest at all. The government fought this very hardly. The government argued that the burden of the cost, which is actually borne by the newspaper, and the foreign exchange reserves that we are referring to because of the import duty, are irrelevant, because the public interest was that this taxation would increase the revenue of the government, and we were in a very tough time in the early 80s. So this was one of the ways in which you could make things more expensive. Now, this is a late judgment of 1984, and the Supreme Court very clearly directed the central government to re-examine its taxation policy, to check whether this is actually constituting an excessive burden or not. Now, in this case, the Supreme Court understood that the government can levy taxes on newspapers, on publications of newspapers, but it should be within reasonable amounts. So the Supreme Court is trying to play safe here. The court also observed that neither Indian Express nor the government were able to prove the excessive nature of tax burdens. So while it requested the government to reevaluate it, it did not really make a lot of difference eventually. So this judgment is essentially about the Supreme Court making a poetic discourse on the importance of newspapers or media. So here, the Supreme Court says media is the fourth estate. It is invaluable to democracy and therefore must be protected from excessive interference. It also said that excessive taxation should not be placed on the media. And this standard of excessive taxation should therefore be applied to all media outlets, and one should not go beyond a certain limit. And the Supreme Court also said that the burden of tax payments, the burden of all of these payments, should essentially be in such a way that it does not cripple your entire ecosystem. It does not cripple your newspaper ecosystems. And that's why it becomes very, very important. And this is the directive or the decision of the Indian Express case. Now, the last case is the Pegasus case. And the Pegasus case is still going on from what I could remember. Manohar versus Union of India. And it is a case which affects 19 and 21 both, because this is about surveillance and this is also about privacy. So Pegasus is a surveillance software. It compromises the privacy of people, and it also affects the freedom of journalism or the freedom of press under Article 19 as well. So when we discuss privacy, we will also discuss this case under Article 21. So just to leave it out there, because this is a joint issue of 19 and 21, as I've discussed with you before, we will discuss all combinations, 19 and 21. We will discuss 14, 19 and 21, 14 and 21, 19 and 25 when the time is appropriate for 25. So these are the judgments which are fundamentally related to news. Now that we understand that these are the judgments which are fundamentally related to news, let us also quickly understand some very exciting judgments which have something to do with our non-news outlets. So let's get this part right. Or non-news agencies. The first judgment is the Ranjit D. Udeshi judgment, the Ranjit D. Udeshi versus the state of Maharashtra judgment of 1964. Now, this judgment is a very interesting judgment because it is about a book which is considered to be erotic in nature. Let's understand this. Ranjit D. Udeshi was one of the 4 partners which owned a bookstore. And these partners were prosecuted under Section 292 of the Indian Penal Code. The number is not important. The section is not important for you. But Section 292 of the Indian Penal Code can penalize you, can criminalize you for selling copies of an allegedly obscene book. Now, this book that we are talking about is called a book called Lady Charlotte's Lover by D.H. Lawrence. I think this book is also being made into a series which will come on one of the OTT platforms in some time. But it is essentially that book. Now, this is essentially about what is decent or moral. Now, this entire understanding of what is decent and moral will have 2 tests that the Supreme Court applies. One is called the Hicklin test, and the second is called the community test. The Hicklin test is derived from UK judgments, and the community test is derived from the US judgments. Anyways, so what is this? The Supreme Court here very clearly said that this particular book is a questionable book. And this book can only be understood to be right or wrong if we apply the Hicklin test through a UK judgment called Queen versus Hicklin. And that is a valid test to decide whether it constitutes obscenity or not. Now, what is the Hicklin test? It's a very simple one. It is, does that book, does that act, does that issue deprave or corrupt those minds which are open to immoral influences? And into the hands of this publication, will this go even worse? Now, this test itself was not found to be violative of Article 19. So, under Hicklin, a work should be viewed as a whole, but the obscenity is a separate issue to see whether it violates the test or not. So, what happens eventually was that this test was not applicable. It examined the text of the court, actually examined the text of the book called Lady Charlotte's Lover, and concluded that it was obscene under the Hicklin test, and declared that this book should be stopped and became a restricted book. Later on, of course, we've become more open by using different tests, but it initially looked at it and then finally said, no, this is not allowed. Now, why is this important? It is important because you are using the Hicklin test to determine obscenity. The Hicklin test in itself is a problem because you're saying whether something has the capacity to corrupt the minds of people. But the entire book was not like that. Only a few pages were. And even if that was the case, even if the entire book was, how is it the fault of the publisher? Is the larger question. Now, the Supreme Court has ever since rejected using this test. We don't use this test anymore. And of course, the 2004 case of Avik Sarkar versus State of Bengal is an example of this. So Avik Sarkar case applies to digital media and broadcasting, so we don't discuss it here. So this is the first case. What do we learn from this first case? That we followed UK judgments which were slightly restrictive in nature, and a test called the Hicklin test. All that you need to know are these three words for your mains exam. Then comes the next judgment, R. Rajagopal versus State of Tamil Nadu. This R. Rajagopal judgment is again an old judgment of 1994. Now, why is this judgment important? Let's understand what happened. R. Rajagopal is essentially collectively for the editors and the associate editors of a Tamil magazine called Nakhiran. Now, what had happened was there was an autobiography of a prisoner, Otto Shankar, which was published. Shankar was convicted of 6 murders and was sentenced to death. And this person, Otto Shankar, wrote his biography in jail and expressed that this book should be published in the magazine. Before it could be published for public viewing and public distribution, this magazine called Nakhiran announced the publication that we're going to do this. The prison officials then forced the prisoner to write to the magazine that this autobiography should not be published. And therefore, the magazine came to court. Supreme Court here very clearly ruled that the magazine had the right to publish an autobiography, even if the autobiography was written by the prisoner, and even without the person's explicit consent or authorization, because the authorization, the consent was compromised. And the court then, through this judgment, explained it was very important to strike a balance between the freedom of the press and the privacy. It therefore becomes important. So the final directive or the final outcome in 2 lines for this case was that it expands the medium of expression and it prohibits the state from conducting further restraints in speech. The state cannot even prevent the publication of potentially defamatory articles, and it can only sue for compensation if these articles are a problem. Then There is another Sarkar case. This is not the 2004 case. This is the 2014 case called the Sarkar versus West Bengal case. Now let's understand this case is a different one from the Avneet Sarkar case. Let's understand what this case is. This case is very interesting if you are a tennis fan. So what happened was, there was a German magazine which had published the photo of Boris Becker, who was a renowned tennis player. He was posing nude with his, the facts of the case were, dark-skinned wife, dark-skinned fiancée, I think, Barbara Feltes, who was an actress, and he was covering her breasts with his hand. This picture was taken by Feltes' father. The article, which was written in the German magazine, portrayed Becker as an opponent of racial discrimination and wanted to use this photo symbolically of the choice of love over hatred. And a newspaper in India republished the article with the photograph. And again, under Section 292 of the Indian Penal Code, a complaint was filed against the newspaper and the magazine. The Supreme Court here applied this new test called the Community Standards Test, which we have taken from US judgments. The Supreme Court held that this semi-nude picture of Boris Becker and his fiancée Barbara Feltes was not obscene because of the Community Standards Test. Now, what is the Community Standards Test is something that we must understand. The Community Standards Test is a very simple one. That as a whole, does it objectify or is it objectionable to a larger community at large? Now, the court purposefully did not apply the Hicklin test, which is also a standard of obscenity, and chose the Community Standards Test because the Hicklin's test basically examined, is it the tendency of the material to corrupt or not? Whereas it did not look at what the material per se was. This test allowed the material to be judged on the basis of the isolated parts, and therefore it became a problem. And therefore you could ban the novel by D.H. Lawrence called Lady Charlotte's, called Lady Charlotte's Lover. On the other hand, the Community Standards Test is a lot more bigger. Let's understand first what Article 292 is. It says that if something is obscene or not, it has to be lascivious, it has to be of prurient interest, it also tends to deprave and corrupt people who are likely to hear or see the matter. The court said, you have to look at it from more contemporary standards, not of standards of sensitive people. Is it okay nowadays to do this? And while this picture was a semi-nude picture, this picture was not a sex-related material. And therefore, the court then examined the context of the picture and why the picture was there and the message that the picture wanted to convey. And therefore, the court held that there was nothing wrong with this picture, and this picture should be allowed to be circulated. And therefore, the directive or the general understanding was that now we're going to look at larger standards of community as opposed to the Hicklin test. Finally, we look at the Felix versus Gangadhar test, Gangadhar judgment in 2018. The Felix versus Gangadharan judgment is also a very interesting judgment. It's interesting because of what it tries to cover, what it tries to achieve. See, the Felix versus Gangadhar judgment is our latest judgment. It does not particularly add a lot of gravitas to what we're discussing, but it still has a little bit of importance. It essentially is about a magazine in Kerala which was displaying a mother breastfeeding the baby. And the photo had a caption which said, "Don't stare, we have a baby to feed." Feed. Translated, it was in Malayalam. This gentleman, Felix M.A., said that this was against public interest. And he also said that this photo would violate the Prevention of Children from Sexual Offences Act. The Kerala High Court dismissed the matter, saying that it is essentially about a statement, and the court could not find anything obscene in it, and said that now we have to look at it from more contemporary times from a messaging perspective. And it therefore recognizes that nudity by itself cannot be considered obscene, and the context must be taken into account, whether it is serving a bad interest or a bad outcome or any of those things. So this is your print media. Now, what are our primary conclusions that we are deriving out of print media? Conclusion number one: the judiciary has played a very, very significant role. Second, there have been instances of outdated, controlling, or regressive laws and policies. Third, we have been greatly influenced by UK and US judgments, especially with respect to the definition of obscenity, from the Hicklin test to the commonality or the contemporary test. And fourthly, we have always seen an outward, a more liberal interpretation of all of it by the judiciary. Unlike other issues where judicial opinions can be slightly fluctuating, here they have constantly grown from point A to point B. And it therefore becomes extremely important for us to understand. Clear? Now, this covers, of course, our lecture. Now, in lecture number 6D, we will cover censorship, which is very, very important, and the rest in the subsequent lectures. Thank you.